Yeah, mentioned civilly.
Petitioner has physically challenged, my lords. He had sought for a mutual transfer, my lords. And in the earlier writ petition, my lords, there was a specific order that they should seek leave of the court and then they should transfer, my lords. But now they have transferred without seeking leave of the court, my lord. Fresh matter, my lords. End of the list, my lords. Please.
But let it come on Tuesday. What is this?
My lords, they'll come and take charge, my lords. He's physically challenged, my
All
lord.
right, we'll
My lords.
restore his position if you want.
Please, my lords.
We'll restore his place, madam.
There's a specific order by this court, my lord.
I
that
told it, 2:30, yes.
Much obliged.
My lord's premature transfer, my lord. I have another 1.5 year service. Fresh matter, my lord.
Tuesday.
Tuesday. Monday, my lord. Request, my lord. Monday.
Monday, I'm not sitting.
Tuesday. Madam.
Please wait. Please wait, madam. Please wait.
My lords, for IA for vacating stay. May I move it for Tuesday? My lords?
Which year?
My lords, 2024. I filed an IA for
2020?
2024.
Ah,
IA for vacating stay is what I filed.
it is virtually like hearing the petition on merits itself.
My lords,
Alva, is
interim
it not?
court and my final relief are the same. My
That
lords.
is right,
It's
but
a transfer matter, my lords.
so therefore we can't, if final relief and the interim relief are one and the same.
Lords,
If we vacate the interim order, then the final relief also will become infructuous.
my lords, the issue is if
We'll
there is
consider. Yes. What is memo code?
My lord, hearing for IA, my lord, we are for the.
Please hand it over, madam. I told 100 times I keep telling to the lawyers, fresh matter, orders, hearing on IA, please pass on the memo. I don't know, lawyers do not come to the court officer, ask him what is the procedure that we follow in the court. Please, all lawyers, please come to the court, ask the court officer. He will tell you what is the procedure that is adopted in this court. Yes.
Lordship, if I could, this is a matter wherein it's pertaining to Bowring doctors, Your Lordship. They have put in 1.5 years of service here. But what has happened is now the relieving order, which is given by the parent institution, has been unilaterally withdrawn by the government.
Why you want it to be posted? For what stage?
It's a fresh matter.
Hand over the memo.
On,
If it's a fresh matter,
on
it will
Monday or
come.
Tuesday, Your Lordship.
It will come on Tuesday. Please put the writ petition numbers.
List number 1, adjournment, page number 4, serial number 14 to 21. Page number 5, serial number 22 to 27. Page number 6.
Serial number 24, my lord. My lord, I want 2 weeks time for the reason that I want to implead one of the parties.
No, sir, we will not permit any impleadment now in the year.
My lord,
Petition is
she was
filed in the year
recently transferred
2012.
to the bank.
Sir, petition is filed in the year 2012.
Recently,
We
she
will
has
not issue-
transferred, my
no,
lord.
sorry, we will not allow any impleadment now.
My lord, serial number
Please
16.
argue the matter.
My lord, serial number 16 for the petitioner, my
Serial
lord.
number?
16.
Yes.
My lord, time may be given, my lord. My senior is not well.
Vidya, yes.
Yes, my lord.
Learned counsel for the petitioner seeks time. List on.
3rd August.
Serial number 16.
Page number 5, serial number 22 to 27. Page number 6, serial number 28 to 30. Page number 7, serial number 31 to 34.
32.
32.
32 and 32.1 is connected. I'm not keeping well today, actually. No.
32.1.
Don't ask for time in these old matters.
Kindly have it on Tuesday itself. I'm ready to argue them.
No. Please argue the matter. Let us see.
No, actually, I'm not keeping.
If you're not well, it's all right. Let the other person argue the matter.
Okay.
32.1, my name is
This
not.
matter, this relates to some transfer,
Not transfer, it
Not
is
transfer.
termination.
termination,
Termination.
no adjournment, yes.
My lords, my name may be shown, my lords, 32.1. I have filed NOC Wakalat.
What's your name?
Harish Ganapati.
Mr. Anyway, you know that the matter is listed.
No, my lords, in the previous occasion, by chance, today morning I checked. the-
Officer directed to show the name of Mr. Harish Ganapati as a counsel for petition number 1, C number 32.1L. After deleting the name of Mr. Putte Gowda K and CS Dwaraknath. Full stop, list on Tuesday.
Please.
32 also.
Yeah,
Disconnected.
32. Obviously,
yeah.
32.1 is adjourned,
Sure,
and
sure.
32 also will go.
Page number 8, serial number 35. Page number 9, serial number 36 to 40. Page number 10, serial number 41. List number 2, adjournments, page number 1, serial number 3 to 6.
I know serial number 6.
Yes,
I want 10 days adjournment.
3 weeks.
No, 10 days, 1 week after 19, 10 days because. my
What is
senior
the
is
issue
not-
in this? What is the issue involved?
My senior is not.
No, what is the issue involved, madam? Is it a case of dismissal?
I'm not aware of that.
Madam, you have the file, isn't it? Yeah. In this court, only service matters are listed. What is the issue involved in the petition? Is it a case of dismissal? Is it a case of reduction in rank? What is the punishment imposed? Oh, read the file, otherwise I will not.
Not well, so.
Madam, the lawyer should read the file. You read the file, I'll adjourn it later. Read the file. Don't come to the court without reading the file. Huh? Even the file is not with you. Learn counsel for the
Suddenly not come.
Learn counsel for the petitioner seeks time. List on. You should have at least some little facts on your fingertips.
23rd August.
Hmm.
Page number 2, serial number 7 to 12.
Hmm.
Page number 6, serial number 13 to 16.
16 my lords.
ಯಾವತ್ತು ಬೇಕು? Counsel for the petition.
Council for, no, my lord, for respondents. The council for respondent 18, 23 to 25 is in abroad,
For-
my lord.
Counsel for the respondent number,
18, 23 to 25. J.M.
Counsel.
Umesh Murthy,
so and so seeks time. List on date. put.
23rd August.
much obliged.
Hmm.
List number 1 for non-compliance office objection, first time. Serial number 1, Srinivas V.
I appear for petitioner.
Hmm.
But dispensation application, but the certified copy of the impugned order is not produced. One is RTA, one is Xerox pages.
Certificate of caution.
I am permitted to fill the dispensation application. Dispensation baki ella cure agide.
ಇದನ್ನ page, please, there are about 6 office objections.
All are cured, except certified copy.
ಯಾವುದು? When did you cure it?
Yesterday.
ಮತ್ತೆ ನಿನ್ನೆ ಇವತ್ತಿಗೆ ಹಾಕಿದ್ದಾರೆ.
Such is the case, I will clear it, because subsequent rise agide.
ನಿಮ್ಮ ಅಡ್ರೆಸ್ ಫಾರ್ ಸರ್ವಿಸ್ ಬರ್ದಿಲ್ವಂತೆ. Page number 22 and 24 to be properly stitched. Better copy of annexure C to be filed. Writ petition to be paginated correctly.
1 week's time.
1 week time is granted to do the needful.
For non-compliance, second time, serial number 2, Subramaniam Bhatt.
Subramania Bhatt. 1 week, 2 weeks time is granted to do the needful.
Serial number 3, third time of non-compliance.
2 weeks,
For 1 week time.
1 week time is granted to do the needful.
Non-compliance, fourth time, serial number 4.
1 week time is granted to do the needful.
For orders matter, serial number 5, Samartha Gowda.
But this had moved the memo,
Ah.
and served the copy to the government or to get. My lord, the issue is, this court has granted an interim order, my lord, to me on 22nd June 2023,
Hmm.
not to recover or deduct any money from my pension amount. Not in spite of the interim order, after interim order, I have also given a representation to second respondent requesting not to deduct. Even thereafter, my lord, they continued to deduct the amount, claiming that there is an excess amount that was credited to me after my pension was revised.
Yes.
Copy, sir, just now, my lord. Just now they have served the copy.
Yeah, who is deducting it?
Second respondent, my lord.
Do you represent the second respondent also, AG?
Yes, madam. I'll take instruction. Just now the copy is served.
Yeah, just now, what did you serve just now?
The application now I have filed seeking direction to them to comply with the interim order because they continue to deduct it even after the interim order that is served.
If there's an interim order, why don't you
Yes, sir.
comply with it? Right or wrong? You can deduct it later after we decide the writ petition. Yes,
Please, madam. Interim order has to be on.
cool. IA 1 of 24 is filed by the petitioner.
Recovery is one thing.
IA 1 of 24 is for early hearing.
No, my lord, that's for direction. Lord may kindly see. Please to direct the second respondent to abide by the interim order dated.
No
so and so.
slip off.
It's recovery.
ಯಾರ್ ಹಾಕಿರೋದು?
It's only.
IA 1 of 24 is filed for a direction to the respondent number 2 to abide by the order dated 26/6/2023 passed by this court. Next para. This court, in terms of the interim order dated 22/6/2023, had stayed the recovery against the petitioner pursuant to the government order dated 23/3/2020 till the next date of hearing. This order is extended from time to time. Is it, hello, 22/3/2020, full stop. The petitioner contends that despite the order of stay granted by this court, the respondent number 2 has continued to deduct money out of the pension amounts payable to the petitioner pursuant to the government order dated 23/3/2020. The petitioner therefore seeks for a direction to the respondent number 2 not to effect any recovery based on the government order dated 23/3/2020 pending disposal of this petition, or till the order dated 22/6/2023 is modified. Next para. The learned AGA submits that in view of the interim order granted by this court, steps would be taken not to ensure that no deductions are made out of the pensions payable to the petitioner based on the order dated 23/3/2020 passed by the state government. He, however, submits that liberty be reserved to the respondents to make appropriate application for modification of the order dated 22/6/23. In view of the above, IA 1 of 24 stands disposed of, directing the respondent number 2 specifically not to recover any amount from out of the pension payable to the petitioner based on the government order dated 23/3/2020 until further orders that may be passed by this court. Yes.
Serial number 6, PC Prabhakar.
ಆಗಿದ್ಯಾ?
And it all.
ಕೊಡಿ ಇದು TDS ಕೊಡಿ. ಕೊಟ್ಬಿಡಿ ಅವರು. ಕೊಟ್ಬಿಡಿ ಅವ್ರು ಕೊಡಿ. Please check whether the DDs are in order.
Pay order, man.
DDs or pay order, whatever, names, date, ಎಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆಯಾ ನೋಡ್ಕೊಂಬಿಡಿ. Correct idea? The parties are present. The LRs of the respondent number 1 are present. And they accept the terms of the joint memo. And in token of such acceptance, they have signed the order sheet of this court. In view of the above, the writ petition stands disposed of in terms of the joint memo. Yes. Obliged. Continue on. Could you give to me? ಇಲ್ಲಿಂದ ಇವಾಗ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿದ್ದು ಇಲ್ಲಿಂದ ಬರ್ಲಿ. Last line, strike off the last line. Yes, next serial number 7.
7, ತೆಗೆದುಕೊಡಕ್ಕೆ.
Non-placing on record the file. pertaining to
Make one
petitioner's
submission, Your
charge.
Lordship.
Also in the last.
Before she starts. We filed a wakala this morning, Your Lordship. Maybe taken up on Tuesday. We'll keep the records.
Is there
Tuesday or
any
Wednesday.
interim order?
No, my lords, there is no interim order.
Earlier, see, Devraj, it was taken notice to me. We have received the wakala and we filed it today morning, Your Lordship. When our name is not shown, that's the only reason.
Devraj is directed to accept notice for response and is directed to place on record the file pertaining to the Tuesday.
Please, lords.
List
My lords,
on-
until then, my lords, let them
Please wait, yes.
wait.
The learned counsel for the respondent seeks time to comply the order dated 37/2024.
Respond by 1 and 2.
Response 1 and 2. List on Tuesday.
3th August.
Great.
Much obliged.
Serial number 8, Kiran Kumar.
Petitioner will go.
IA 1 of 24 for CD file.
Dismissal.
Uh,
Petitioner working as a bill collector. Appointed
But how
1988.
many times should we? IA 1 of 24 is filed for condonation of delay in filing the application to seek recalling the order dated 1/8/2024. Sorry, 14/8/2023. The cause shown for the delay is produced and is accepted. It is stated in the application that there was a short circuit in the office of the counsel for the petitioner, resulting in some files being destroyed. As a result of which, the counsel could not keep a track of the cases being listed before the court. Full stop. Full stop. The cause shown for the delay is though not satisfactorily established, but yet the same is accepted. Consequently, IA 1 of 2024 is allowed, and the delay in filing the application to recall the order dated 14/8/23 is condoned. Next, but in view of the order passed on IA 1 of 24, IA 2 of 24 to recall the order dated 14/8/2023 is allowed, and the order dated 14/8/2023 is recalled subject to.
Not in job.
That is right. How many times last time I listed the matter, it is made clear that petition shall be taken for final disposal next date of hearing.
Ready.
You ready there, but ಬೇರೆ ಕೇಸ್ಗಳಿದೆಯಲ್ಲ. Subject to payment of cost of rupees.
Bill collector.
Bill collector ನಾವು collect ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ 2010 ವರ್ಷದಿಂದ ಕೆಲಸ ನಾವು ರಿಟೈರ್ಡ್
It's 2000. Payable to the advocates library fund. Yes. Within 1 week.
Serial number 9, Santosh.
List for final hearing on date ಕೊಡಿ. ಯಾವತ್ತು ಬೇಕು? When do you want it?
I am ready anytime.
Please pick a date of your choice.
28,
28th is too long.
16,
16th is a holiday. 21st. List on 21st August. Agata?
23rd, sir.
23rd. 23rd is a Friday. There could be division bench matters.
22nd is all.
22nd.
Serial number 9, Santosh BM.
What is IA 1 of 23?
Please, my lord, for direction to keep one post of my lord assistant
under general merit category, my lord, vacant. Not petitioner has general merit rural.
Petitioner has claimed general merit rural.
Please, my lord. My lord, because of he was in the list, my lord, he was selected as serial number. Its name was shown at serial number 33. Person who is shown at serial number 7, my lord, earlier files writ petition before this honorable court and obtains stay against that category. During the pendency of the writ petition, he was appointed elsewhere. So now he is claiming that right, not that post may be kept vacant and
No, but who filed the writ petition before this court?
one Chandan.
Adil, where do I find that?
Annexure E, my lord.
Annexure E.
Please.
So what has happened in that writ petition?
That, my lord, I was given, I filed an impleading application. I was given liberty, page 46, para 5.
But you are not even a party in this writ petition.
No, my lord. He obtains, my lord, stay against rural category, my lord. And my lord, subsequently, during the pendency of the suit, he was appointed in commercial department. He did not evince any interest.
But then why was the writ petition allowed then?
No. Writ petition was dismissed as become infructuous.
No, sorry.
Annex page 43, man.
25155
Please, man. Page 43.
is dismissed. Which is the other one? Praveen Patil.
That is, my lord, to show that, my lord, even the list, my lord, page 57, para 17. Unfilled posts, not to treat unfilled posts
Were
as.
there only 2 candidates in the general merit rural category?
Two candidates. There are nanginta ಕೆಳಗಡೆ ಮತ್ತೆ ಬೇರೆಯವರು ಇದ್ದಾರೆ.
So you are the
Next
next
eligible
list,
candidate.
next in the merit list.
Next merit.
My lord,
Earlier, I filed writ petition, my lord, for this honorable court with regard to the key answers. That writ petition was dismissed. My lord, because this fact was.
Anyway, see, if this what's his name, Chandan, he was in the he was topped the list
please, my lord.
in general merit category. And if he has abandoned his application, next candidate is the petitioner.
Lords, similar contention was raised by the petitioner before the division bench, my lords. However, the reserved publication of the list was done in 2019.
Where does the division come? Division bench
Earlier, he has approached this honorable court,
the
challenging-
same person.
Please, my lord.
Mahesh had
Please,
approached
yes.
this court.
Please.
complaining about the key answers.
Key answers.
That was dismissed. Writ appeal was also dismissed.
Uh.
My lord, he was not aware of, my lord, this pendency of this writ petition. On coming to know of
That is the case, we'll keep this post vacant.
It's vacant only, my lords, because the notification called for is filled. And the reserved notification
What
that
about general merit rural?
all have been filled, my lords.
How can it be filled without examining his case?
No, my lords, 2019 itself, the entire notification procedure is completed.
Yes.
The petition that has been filed by him is in 2023. As per the rule, it has to be done within 1 year. If any vacant posts are there, it has to be filled within 1 year from the date of publication of
Right,
the
madam,
reserve.
but see this,
there was a,
please wait. This Chandan had filed some writ petition
Please, my lords.
and there was some interim order in that case. So obviously you could not have filled up that particular post.
Please, my lords.
It was kept vacant.
It was
When
kept-
did you fill it up?
It can't be filled up, my lords. My only content, my humble submission is because the reserved list was already out, published and the entire procedure has been completed. Now you cannot fill the same position by giving him a post.
I'm not on that. General merit rural, there's a separate horizontal category,
Please, my lords.
correct? If that is the case, somebody has to be filled against that particular category. Now, who are the persons who are eligible to be considered in
That
that
list
category?
was published in 2019, my lords.
Let it be published whenever. Who are the persons in the order of merit who are entitled to be considered in that particular category?
The next eligible candidate.
Who was that?
That list is not produced by both of us.
No,
my
if
lord.
that is, if he is the second in line, then he has to be considered. If Chandan was the first person, and if this person was the second person, if Chandan has abandoned his right, then this person has to be considered. Where's the question of filling up by some other person who's lesser meritorious than this man?
No. Yeah, my only contention is, my lord, similar contention was raised by him before the division bench, and the division bench has held that because that exercise was completed in 2019, he cannot be given a post after that, because the
Yeah.
regulation says.
Where is that division
It's
bench?
filed along with additional statement of facts, my lords. Annexure H, page number 25.
Additional statement of objections.
Additional statement of facts filed by the
Hmm.
petitioner, my lords. Page number 25.
Yes, please. Read the relevant portion.
Para number 5, my lords. Page number 29.
Para 5.
Learned counsel for the appellant submitted that the appellant has not been assigned marks for question number 22, and the candidate, namely Parmesh B, who was placed below the appellant in the revised selection list, that is at serial number 34, was given appointment. It is also submitted that since a post has fallen vacant, as one candidate, namely Parmesh B, who was placed below the appellant in the revised selection list at serial number 34, has resigned. Therefore, the appellant is entitled to seek appointment on the post in question. The finding is at para number 8, my lords. Page number 32.
Yes.
The grievance of the petitioner that he has not been assigned marks in respect of question number 22 is concerned suffice it to say that from the affidavit sworn in by the Director Administrative and Human Resources, it is evident that the appellant has been awarded marks in respect of question number 22. The appointment to the post which has fallen vacant subsequent to the completion of the process cannot be made dehost the procedure contained in the regulations. Under none of the regulations, the appellant is entitled to seek appointment after the expiry of period of 1 year. Therefore, the contention that the appellant should be appointed on the post of assistant on account of the vacancy which has been caused subsequently does not deserve acceptance.
Yes. No, but what has happened to the post after this man resigned?
It's vacant, my lords. Nobody is
Vacant.
nobody's filled in.
Please keep it vacant.
Please, my lords. It'll be kept vacant.
Keep it vacant. Let us see.
But it can be disposed of to consider his case, my lord. The
Alala.
main contention in the
First
writ
of all,
appeal, there was
you
no
should
stay
sat-
anta.
You should satisfy the court that you are entitled to be
Para
recruited.
para 7 in the writ appeal order, madam.
Ah.
Page 31. Really, para 7.
Yes. Yes, please.
We have considered your lordship got it. Page 31 in the additional statement. Additional statement of facts.
Yes, please.
We have considered the submissions.
Hmm.
Consider the submission made on both sides and have perused the record. The issue with regard to the filling up of vacancy in case candidate selected does not join has to be determined with reference to the statutory rules. In the instant case, the recruitment was in accordance with the regulation. Regulation 3C1 so and so. The recruiting authority shall, in accordance with the provisions above, also prepare a reserve list of names of not included in the select list prepared under C3 above, in which number of candidates to be included shall be 50% of the number of vacancies notified, and may be operated within a period of 1 year from the date of approval of the main list or till the next day recruitment, whichever is earlier. Thus, it is evident that waiting list may be operated within a period of 1 year from the date of approval of main list or till next recruitment, whichever is earlier. In the instant case, revised main list was published on 13/11/2017. This one, madam.
No, when did he
The
resign?
aforesaid revised main list was not stayed by this court. That was stayed, my lord, in that writ petition. That particular post, their contention was there was no stay. But there was a stay, therefore, my lord, I was given liberty, my lord, to file fresh writ petition.
Well, even if it is stayed, what will be the effect? Now, the revised main list was published on 13/11/2017. Was that main list challenged?
No, that list, he has challenged his denial, his appointment, my lord,
Who
that
has
Chandan.
challenged? Who has challenged?
Marks, Chandan.
Ah,
On the case stay.
ah.
There was no stay, anta, my lord, it was observed.
Correct, sir, but see if Chandan now is abandoned, so you
That
can't,
petition-
you can't figure on it. The order of stay granted in his petition.
In this, Chandan,
Chandan case ಅಲ್ಲಿ ಆಗಿರುವಂತ ಸ್ಟೇಟ್ ನ you can't take advantage of it.
ನನಗೆ ಇಲ್ದೋದ್ರೆ ಅವರು, if he has not abandoned, if
Ah.
he was not interested, my lord, and if that he has not joined, I could have, my lord,
Correct, but see, now Chandan abandoned. This man is,
let them consider my case, my lord.
anyway, they say that they'll keep one post vacant.
Please, my lord. Kept vacant.
Portfolio IA 1 of 20, 3 is filed by the petitioner seeking for a direction to keep a post vacant. Keep the post of assistant in general merit rural category vacant. Until the disposal of this writ petition. Full stop. Next para. The petitioner contends that he was deprived of a legitimate right to be appointed to the post of assistant under the general merit rural category, though he was second in the order of merit, and the first candidate, namely Mr. Chandan, had failed to fulfill the requirements of the documents prescribed. The said Chandan had also obtained an order of stay of the final select list in WP number 25155 of 2018. Full stop. It is contended that the writ petition filed by Mr. Chandan was withdrawn unconditionally, and therefore it is the petitioner who is entitled to be recruited to the post of assistant under the general merit rural category. It is contended that the person who was below the petitioner who was recruited had resigned from the post, and therefore the post of assistant in the general merit rural category is still vacant. And therefore the petitioner prays that the said post be kept vacant until disposal of this writ petition. Next para. The application is opposed by the learned counsel for the respondents, who do not dispute the fact that Mr. Chandan, who had filed a WP number 25155 of 2018 and had obtained an order of stay of the main select list,
our post
huh?
rural category.
Select list insofar as related to the general merit rural category, withdrew the writ petition. Full stop. She also did not dispute the fact that the said post, which was filled up by a person named Yaro, what's his name?
Parmesh.
Huh? Parmesh had resigned from the post, and therefore the post of assistant in general merit rural category is vacant. Full stop. In view of the aforesaid submission, it is appropriate to direct the respondents 1 and 2 not to fill up the post of assistant in general merit rural category until further orders that may be passed by this
Consider
court.
minimal.
In view of full stop. Consequently, IA 1 of 23 stands disposed of on the above terms.
Please.
Yes. IA 2 of 20. IA 2 of 24.
That is,
Yes.
in this matter, my lords, both the IAs have been allowed on the previous date of hearing. In fact, if your lordships see the 9/7/2024 order,
9/7 or 8/7?
8/7/2024 order, there is a direction. In fact, I was working on ad hoc basis contract and got selected.
No, but I don't see any order passed on IA number 1 or 2 of 24.
8/7/2024.
Yes.
Last paragraph, my lords. Prima facie, this court must accord that if the petitioner has to be disturbed from his employment on a contract, he should have been given an opportunity and for reasons assigned. And in the absence thereof, this court must subject to further orders. Direct the second respondent, notwithstanding the order dated 16/5/2024, to continue the petitioner on a contract subject. But earlier order was not to replace the.
No, that's okay, but where is the order rejecting, disposing of IA 2 of 24?
This is the order.
There's nothing mentioned about IA 2 of 24.
Yes, ma'am. Now this order has to be compared by the respondent.
My lord,
Anyway, today it is listed. What is 3 of 24?
Implead.
IA 3 of 24.
Yes.
Direction for what?
Direction, my lord, this is an order. IA for direction is that I was working on a contract basis and got selected. Now there is an endorsement that selection cannot be implemented because I have obtained a degree in Chhattisgarh University. And based on the Supreme Court judgment, my lord, it is validated.
Yes, sir.
Lord,
There's some
R-
order
R2
passed with
is
this.
an-
Huh?
Respondent number 2 is answering respondent.
Respondent
My
number
lord.
two. Yes, madam.
my lord, I appear for R2. The arguing counsel is ready to argue the matter. The matter may be passed over.
Ready to argue, you say, ask for a pass over.
He is held up in another court currently.
Lord, unless an interim order is complied,
That is okay.
they don't have a right of
consider
hearing. Of course, we will
All right.
argue the matter.
Pass over.
Grateful, my lord.
Serial number 11. Vinayak B. Vishnu.
IA 1 of 24 is filed for dispensation of what, madam? Dispensation with the production of the certified copy of the notification dated 18/11/2023. The cost shown for seeking dispensation is accepted and the production of the certified copy of annexure so and so is dispensed. Yes, you are ready to argue on merits.
This matter may be taken up next week.
List on, at the request of the learned counsel for the petitioner, list on date.
7th August. Serial number 12, L. Muridhar Peshwa.
Petitioner lordships.
Yes.
My lord, there is a direction to file an affidavit.
What is this direction? IA 1 of 24?
The lordship, I had sought for a payment of wages on the month of February 2024, you know. The respondent, what they have done is they have paid the wages since workmen, which was paid to them prior to August 2022, you know. Not the wages which they were entitled.
What is the writ petition about?
The writ petition.
What is the relief sought for?
The relief which is sought is as per the prayer, you know.
What is annexure L?
That is the impugned order. You know.
Obviously, what does the impugned
But
order
they,
say?
as per that annexure, yeah, they wanted to start recover the wages from my paid salary, with a claim that it has been paid excess to me from the month of August 2022 to February 2023.
You are still in service.
We are all 3,500 people are there. You know.
Ah.
They are working still.
Please read the annexure L.
Yes, sir. ಬೇರೆ ವಿಷಯ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1 ಒಂದು 108 ಆರೋಗ್ಯ ಕವಚ ತುರ್ತು ಆರೋಗ್ಯ ಸೇವೆಯನ್ನು ಸರ್ಕಾರ ಮತ್ತು ಖಾಸಗಿ ಸಹಭಾಗಿಯಾಗಿದ್ದು 10 ವರ್ಷಗಳ ಅವಧಿ EMR ಅವರಿಗೆ ಒಡಂಬಡಿಕೆ ಮಾಡಿಕೊಂಡು ಸೇವೆ ಒದಗಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಒಡಂಬಡಿಕೆಯ ಮುಕ್ತಾಯವಾದ ನಂತರ ಸರ್ಕಾರದಿಂದ ಅಗತ್ಯ ಅನುಮತಿಯೊಂದಿಗೆ ಸೇವೆಯನ್ನು ಮುಂದುವರಿಸಲಾಗುವುದು ಬದಲಾಗಿದೆ. ಸೇವೆದಾರರೊಂದಿಗೆ ಮಾಡಿಕೊಂಡಿರುವ ವಿಸ್ತರಣಾ ಒಡಂಬಡಿಕೆಯ ಪ್ರತಿ ಕ್ರಮಾಸಿಕ್ಕೆ ಅಮೌಂಟ್ ಆಫ್ SPP. ಇದರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ,
Please read, mister. Please read the full thing.
ಲೆಕ್ಕ ತೀರ್ಮಾನ
ತ್ರೈಮಾಸಿಕಕ್ಕೆ ಮುಂಗಡವಾಗಿ
4,60 ಲಕ್ಷ ರು ಅನುದಾನವನ್ನು ನೀಡಬೇಕಾಗಿರುತ್ತದೆ. ಅದರಂತೆ 2024-25ನೇ ಸಾಲಿನ ಮೊದಲನೇ ತ್ರೈಮಾಸಿಕ ಆರೋಗ್ಯ ಕವಚ 108 ಯೋಜನೆಗೆ ಲೆಕ್ಕ ಶೀರ್ಷಕ 22-10-06-2000 ಅಡಿಯಲ್ಲಿ ಮುಂಗಡವಾಗಿ 2,329 ಲಕ್ಷ ಅನುದಾನವನ್ನು ಬಿಡುಗಡೆ ಮಾಡಿಸಿರುವ ಸದರಿ ಅನುದಾನವನ್ನು ಸರ್ಕಾರದೊಂದಿಗೆ ಮಾಡಿಕೊಂಡಿರುವ ಒಡಂಬಡಿಕೆ ಷರತ್ತು ಮತ್ತು ನಿಬಂಧನೆಗಳನ್ವಯ ನಿಯಮಾನುಸಾರ ವೆಚ್ಚ ಭರಿಸಲು ಸೂಚಿಸಿದೆ. ಉಲ್ಲೇಖ 2ರ ಸರ್ಕಾರದ ಅಧಿವೇಶನ ಸಂಖ್ಯೆ ಸೋ
ಆದೇಶದನ್ವಯ EMRI GH ಸಂಸ್ಥೆಯ ಓದಿ
ಅಲ್ಲ ಅದು ಸ್ವಲ್ಪ ಇದಾಗಿದೆ ರಿಮೂವ್ಡ್ ಆಫ್ ಪ್ರಾಧಿಕಾರ ಅನುಮೋದನೆಯ ಪಡೆಯುವುದು
ಸಿಬ್ಬಂದಿಗಳಿಗೆ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರ
ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಿಬ್ಬಂದಿಗಳಿಗೆ ಮಾಡಿರುವಂತ ವೇತನವನ್ನು ನಿಯಮಾನುಸಾರ ಹಿಂದಕ್ಕೆ ಪಡೆಯಲು ಕ್ರಮ ವಹಿಸಲು ಹಾಗೂ ಹಿಂಪಡೆಯುವ ವಿಧಾನ ಹಾಗೂ ಅವಧಿಯ ಬಗ್ಗೆ ಕ್ರಿಯಾ ಯೋಜನೆಯನ್ನು 3 ದಿನಗಳ ಒಳಗಾಗಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. ಉಲ್ಲೇಖ 3 ಆರ್ಥಿಕ ಸಾಲು 2024-25 ಒಡಂಬಡಿಕೆ ಮತ್ತು ಷರತ್ತು ಮತ್ತು ನಿಬಂಧನೆಗಳನ್ವಯ ನಿಗದಿಪಡಿಸಬೇಕಾಗಿರುವ ರೂಪಾಯಿ 1,01,62
16,140
ಆರೋಗ್ಯ ಕವಚ ತುರ್ತು ಆರೋಗ್ಯ ಸೇವೆಯನ್ನು ನಿರ್ವಹಣೆ ಮಾಡಲು ಕ್ರಮ ಕೈಗೊಂಡು 3 ದಿನಗಳ ಒಳಗಾಗಿ ಸದರಿ ಅನುದಾನದ ಮಿತಿಯೊಳಗೆ ಕ್ರಿಯಾ ಯೋಜನೆಯನ್ನು ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ.
What does this mean?
They say that they want to start recovery of the amount which was paid to this workmen, your lordships.
Why? On what ground?
Yeah, what they say is that there was an order, your lordship. That is 11/10/2022. That is the history of that, your lordships.
11/10/22.
Yes, sir.
Where do I get it?
That is it. It has to be. Annexure G, 71-72 page number.
Yes, please.
I also produced the type copy of the same.
Yes, please.
The meeting started about 2 p.m. prescribed by HDDA, Health and Family Welfare. The agenda of the meeting was to implement as per the decision approved meeting proceedings of commissioner meeting dated so and so 7/10/2020. Minimum wages, EMT pilot and ERO who are below the minimum wages need to be corrected by implementing the Minimum Wages Act for the financial year 2022. Needs to be implemented with effect from August 2022. Post correction of minimum wages, increments need to be considered based on the number of years of experience as mentioned below, which was pending 15% hike annual increment for the last 3 years. Based on the eligibility criteria of employees for the first year, 15%, completion of 1 year, employees having completed 2 years of service attract increments of 15% per annum. Employees having completed 3 years of service attract increments at 15% per annum. Support staff increment needs to be considered at 15% per annum for the financial year 2020-21-22. It is advised that GMK EMRI shall submit calculation sheet of arrears on priority for releasing required additional funds. Reference the previous order dated 28/4/2017.
So this was some kind of a settlement. Was this some kind of a settlement?
There was a decision, your lordships.
Huh?
What happened, my lord? Government decisions were there in that regard.
What happened, my lord?
So please, what is this case?
This is, my lord, meeting without the approval of the government. DD, my lord, who is the nodal officer to us, directed to pay this enhanced rent, enhanced salary. Then, my lord, the government settlement without the government approval, you have paid, therefore you recover it. Then, my lord, we started recovery. There was a stay of recovery, my lord. In the interim order, my lord, this one put my directed to pay the salary as you are paying before 10th to August 2022. Then we started paying the whatever we paid earlier. That we have been paying. No, my lord, on last occasion, my lord, your lordship directed to pay, file the affidavit. We need so much money required to pay to us. It seems, my lord, they filed the
We
affidavit.
have filed the affidavit, my lord, that we have paid all money of the, in advance of this quarter also, up to September, my lord.
Up to September you have paid?
Yes, in
That is,
advance we pay.
If you appropriate the excess paid, that will cover up to September.
Not that way, my lord.
that is
We
the-
have an arrangement.
What happened, man? As
There
per the
was-
agreement 2018, government required to pay 160 crores. Then they directed to enhance the salary, my lord. As per the enhancement salary method, we can't pay the within 160 crores. What government filed the affidavit, it seems, my lord, I am not given the copy, my lord. As per 160 crores agreement, they released. But it is not enough, man. Whatever they were released because we are paying. There is a,
What direction can be given here now? What direction? It's virtually like allowing your petition if he released his salary.
Yes, your lordship.
therefore, my lord, direction earlier, my
I just
understanding
would like
was,
to
my
make-
lord, after filing the statement of objection by all the respondent, it has to be decided finally. On that ground, my
Well,
lord, may I
this
proceed?
was his application, see, granting, issuing any direction on your application
May I
is
make-
virtually like allowing your application.
No, your lordship, it's not like that. The thing is, there are two aspects are there. One is as per the order dated 11/10/2022, they say
You are
that.
not even giving the bare facts. Who are these people? How they were terminated? What was the purpose of this agreement? What was this meeting?
Yes, your
You're
lordship.
not even giving me the backdrop of the case.
This, all these employees, your lordship, they are working for this 108 Argue Kavach. They are working as drivers and technical assistant, that's for staff nurse. 3,500 employees are there.
There was some, what is this, GVK EMRI?
Yes, sir.
What is that?
They are the intermediaries who have been releasing the salary for all these employees of the amount which is released by the state government and
State
federal government.
government and GVK had some tie-up.
Yes, that's what
Agreement,
it is.
as per the
Yes,
agreement,
sir.
my lord, we are.
And all these drivers are engaged by
Appointed by
GVK.
Drivers and staff nurse, your
They're
lordship.
engaged by GVK.
Yes, your lordship.
Now the term of GVK, this.
No, it is
Yes,
not
ended.
complete, it's continuous. My whole petition came into being, your lordship, that I have not been paid wages regularly, first fact. Second factor is that there was an order which is dated 11/10/2022. Saying that I need to
Who
be
has to pay
paid,
the salary to you?
salary will be paid, your lordship,
By whom?
by this third respondent, based on the amount released by the state government,
Who is third respondent?
that is GVK, EMRI.
GVK
EMRI.
Yes.
Based on the amount released by the state government and central government, they will be paying the salary. On 11/10/2022, your lordship, which I have just now read it, they were supposed to pay me some increase. That is again as per the order, a decision taken on 7/10/2022. The order dated 11/10/2022, it's not as it is on its own. It is based on a decision taken on 7/10/2022, which
Where
is
do I
Annexure
get that?
F. Annexure F, page 60 to 70, your lordships.
Next, sir, F.
F, your lordship. Page 60 to 70.
Minutes of the meeting held on chairmanship of Commissioner. Which so and so in Karnataka. What was the minutes of this, sorry, the final outcome of this meeting?
They say that these workmen, if not they're entitled for, they need to be paid.
Where do I get that? Giving effect to salary hike pending for 3 years.
Yes, your lordship.
Please read that.
68. Giving effect to salary hike pending for 3 years. The employees union submit to the commissioner that after a government order, the department had approved 15% salary hike for all 108 employees and released the required budget for the financial year so and so. However, after paying the increment arrears to the GMK to the employees, GVK EMRI had not given the salary hike into effect for the said 3 years. Despite repeated requests, GVK EMRI is still paying the basic salary as on 2016-17, and hence employees requested the commissioner to direct the GVK EMRI to give the salary hike into effect. DDMRI confirmed the fact and stated that salary hike can be given effect from August 2022, and for it, an additional budget of about 2.5 crore per month needs to be provided to GVK EMRI. Of the discussion, the commissioner agreed if salary hike for the said 3 years has been approved by the government through GO, then GVK EMRI should give effect to the salary hike and it shall be applicable from August 2022. The commissioner directed Deputy Director EMRI to work out a proposal with GVK EMRI for giving salary hike into effect for all the working 108 employees currently in the system and propose the appropriate additional budget to be released to GVK EMRI. Based on this decision, Your Honor, the 11/10/2022 order was passed. By an order dated 19/7/2023, Your Honor. Based on this 11/10/2022 order, I was paid some additional increment with effect from August 2022 until February 2023. I was paid additional increment, 50% increment was also paid to me. I was produced it.
From what date to what date?
From August 2022 until February 2023,
22 to 23.
August 2022, until February 2023. Your Lordships. I was paid as per the decision taken on 11/10/2020. On 19/7/2023, Your Lordship, that is Annexure H, page number 73 to 76.
Yes. So what is the affidavit now filed?
My lord, affidavit is filed in terms of the payment which is made. Court directed us to file an
Who appears
affidavit.
for the respond number 3?
I am for the respond number 3.
What is your case?
My lord, as per the earlier agreement, my lord, they were required to pay 100 crores, 160 crores to us.
That is state government.
Yes, that is the state government has to release, my lord. That is in 2018. Now, as for 2022 decision, what you are, my learned friend read, there is an enhancement of salary. They are not, government is paying only restricted to 160 crore only. As for the enhancement salary, they have not released it. Therefore, my lord, they are directed to recover whatever excess pay amount we started recovering. That was statement. As per the interim order, my lord, we used to regularly paying the earlier pay whatever we paid before.
There's a government order granting additional salary from August 2022.
No, that is not a government order. That is within the meeting. That's what now they withdrawn. They saying that my government is not approved that.
No. There's some order. It says.
We paid as per the DDA is the nodal
No,
officer
there's
to
some
us.
government order. See, it says after government order, the department had approved 15% salary hike for all 108 employees. What is this government order?
There's no government order. That is the.
There's a reference in the resolution.
My lord, that is a meeting proceedings where a coordination committee meeting was held between the provider and the government and the employees.
Whether the commissioner is here.
Commissioner.
What is this government order?
The government order tells that for period of 17, 18, 18, 19.
Where is that government order?
Page number 54, 55, Annexure E. 54.
ಹೆಚ್ಚುವರಿ ವೇತನವನ್ನು ಪ್ರಸ್ತುತ ಜೀವಿಗೆ ಲಭ್ಯವಿರುವ ಅಂದಾಜು ಮೊತ್ತ 2,310 ಲಕ್ಷಗಳ ಅನುದಾನವನ್ನು ಪಾವತಿಸಲು ಹಾಗೂ ಸದರಿ ಸಂಸ್ಥೆಯ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಅಪ್ರೈಸರ್ ಅನ್ನು ಹೆಚ್ಚುವರಿ ವೇತನವನ್ನು
That is for 2017, 18, 18, 19, 19, 20.
Right. So for that it was 231 crores. 231 crores. And what is lying with respond number 3 is only 130 crores.
Yes.
Whatever it is, now there's some settlement. Why don't you pay the money as per the order passed with the commissioner? August 2022 the code.
Whatever government releasing, there is a auditor appointed by them only. As per their report, we have to pay.
Kindly have this matter for next week, my lord. We will
as per
file a statement of
Please
objections.
come out with particulars as to what has happened pre and post this particular, what you call resolution. After this meeting, what is the steps taken? Mr. This is an ambulance is an essential service.
Yes.
So therefore you can't keep these people waiting. Even these people also have to survive.
My lord, it starts from an MOU between the government and the
Okay.
service provider.
See, we will not go back. Now the government has examined. They have arrived at some decision of granting some 15% hike in the salary from August 2022. If the government has taken a decision, why can't the government implement it?
My lord, a week's time may be granted. We'll make
After hearing,
2 weeks may be granted.
we'll also file the statement of.
don't start your argument.
I'm
with
not
the-
arguing a lot.
No,
I
no.
just want to make one.
You're not giving you start when you're arguing the matter, give a background as to what the case is all about. Don't start from the middle.
Yes, Your Lordship, I understand. Only one submission I wanted to make. Annexure H, Your Lordship,
Hmm.
which is dated 19/7/2023. As per that order, as per that particular circular,
Hmm.
they say that the 11/10/2022 order is not as per the government approval. Then what they say is that all these employees are entitled only for minimum wages, and that should be effective from March 2023. That's what they make this specific guidelines they make in direction they make. Now, after my application, which is filed before this, what the amount they have been paying to me is the wages which was paid to me prior to August 2022, Your Lordship.
Yes.
That is less than minimum wages. I work for 12 hours a day. They have been paying me 14,000 rupees now.
When will you get instructions? Yavaga?
Next week.
See, from the year 2016, 17, 18 and onwards, what was the agreement? What was the decision taken by the government? And post this 7/10/2022, what was the developments?
Lord, we'll address you next.
Huh?
Next week.
After hearing the learned counsel for the petitioner and the learned AGA as well as the learned counsel for respondent number 3, a week's time is granted to secure further instructions as to the developments that have taken place subsequent to the proceedings dated 7/10/2022.
Yes, sir. 7/10/2022, 11/10/2022.
7/10/2022 by the Commissioner,
Yeah, it was a joint meeting, Your Lordship, consisting
Commissioner
all
of
these people.
Health Services. List on, when do you want it?
Kindly have it on 22nd.
22nd, 22nd,
Okay, Lord.
22nd.
Serial number 30, A. Nagarajappa.
Yes. Yes.
The petitioner are, my lord, working as a lecturer. That is various colleges, aided institutions.
Pardon?
My lord, you want to say, number
Huh?
13.2, my lord. that is the-
No, why is it listed for orders today?
I have filed an application, it's covered by judgment. This is the reason.
Yeah, who has to say whether it is covered by judgment?
Government.
Yeah, government.
13.
He says it is covered by judgment. What is this judgment?
And all the, my lord, the petitioners, the working as my lecturers in, my lord, the aided institution, aided institution. My lord, the university and, my lord, the colleges have notified for the, my lord, recruitment of, my lord, the lecturers in the various aided institutions. As per that, notifications were issued. My lord, in the midway, my lord, the pattern of, my lord, the selection has been changed. My lord, instead of, my lord, the 100 marks are fixed by the UGC. And the, my lord, ratio of, my lord, the interview 1:5. This is the, my lord, UGC regulation. That has been changed by the government. We have questioned that.
That is after the recruitment notification.
After the recruitment notification, in the middle of that. That's the reason, Lord, this is covered by Manjushri judgment, Lord, and subsequently, my Lord, small on the case, 5 judges, judgment, my Lord, of the Supreme Court. They cannot in the middle change, my Lord, that is the reason.
If this is, if the facts as mentioned by the counsel for the petitioner is taken on its face value, I think it is covered. Yeah, you know,
The
there's
selection, my Lord, is held up for 2023.
there must be one more judgment of the Supreme Court, the Katti.
District judges, my Lord, 5 judges. After Manjushri case, my Lord, the Shivananda case. I cannot change, my Lord. I have included UGC also. UGC is supporting my case, and even the colleges supporting my case.
Yes, who has to answer?
The government, my Lord, UGC is supporting.
If that is the only short facts, I think we can close it.
All these matters, all the 3 matters.
We learned AGA seeks time. List on Yav, when do you want it? Huh? 21st. Agathenry, 21st.
It's a selection matter, but everything has all up.
Stay idella.
Stay the interim order. 2 matters.
Interim order granted earlier is extended till the next date. Interim orders wherever granted is extended till the next date.
Fresh matter, serial number 14, Balasubramania KM.
So and so is directed to accept notice for respondent number.
Yes, ma'am.
So and so list this petition along with so and so. Yes, next.
Number 15.
Please hand over the memo, the numbers. Mr. Srinivasa K. Hmm.
Petitioner had sought for the mandamus to the first respondent to consider his representation at Annexure A. Lord, the very note, the petitioner though was transferred, my lord, as per Annexure A, and he reported for duty, my lord, at the place of transfer, and he discharged the work for about 8 to 10 days. Thereafter, my lord, the third respondent is preventing the petitioner from discharging the work only on the ground that a reposting order has to be obtained from the second respondent. This second respondent, tenth, my lord, had already instructed the third respondent.
List ಕೊಡಿ. ಬೆಸ್ಕಾಂ ನಿನ್ನೆ ಯಾರು ಕೊಟ್ಟಿದ್ದು? ಶಿರೀಶ್ ರಕ್ಷಿತಾ ಡಿ ಇದು ಚೆನ್ನೇಗೌಡ is directed to accept notice. ಹೆಸರು ಬರೀರಿ ಇಲ್ಲಿ ಚೆನ್ನೇಗೌಡ ಅಂತ. Is directed to accept notice for the respondents. List on.
Date make it.
ಯಾವತ್ತು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತರ್ಸ್ಕೊತೀರಿ?
Monday.
List on date.
20th August.
Yes, Vidya
Short
is.
date may kindly be given because only a short.
Huh?
Short date may kindly.
In 20th ಕಿನ್ನ ಶಾರ್ಟ್ ಡೇಟ್ ಏನ್ ಬಂತು?
That it's on release of the terminal benefits of retirement, but I have not sought for an interim order, my lord, only. It has to be, notice may be ordered, my
So
lord.
what is challenged here?
Circular, my lord. Annexure T is the, my lord, the communication by, my lord, the Director of Technical Education to the principal.
Annexure?
Annexure T, my lord, page 70.
No, I don't see page 70 here. ಇದು ಯಾವ್ದ್ರ ಬೇರೆ ಕೊಟ್ಟಿದ್ರಲ್ರಿ? ನೀವು ದಿನ ಹಿಂಗೆ ಮಾಡಿ ನೀವು. Page 70.
70. Annexure T, my lord.
Yes, please.
The petitioner, my lord, is entitled for, my lord, the benefits, my lord, of the retirement. But it has been rejected on the ground that your lordship will find in the last pair of the communication.
Yes. Yeah, who appears? Are there any standing counsel for this respondents?
For all the respondents, my lord, the state government, all this.
AG is directed to accept notice for respondents. Yes, counsel for the petition is directed to serve copies of the writ petition to the learned AG.
Please.
Yes, next.
Serial number 18, Aishwarya,
SM Aishwarya,
Copy of the petitioners, my lord.
IA 1024 is filed for dispensation with the production of certified copy of Annexure A. What is Annexure A?
That's the challenge, it's final seniority list that has been published by the respondent number 2 authority.
The cost shown for seeking dispensation is produced and accepted. Hence IA 1024 is allowed. Yes, what is the writ petition about?
The writ petition is challenging the final seniority list published, dated 1/6/2024.
Take out
Confirming
notice, madam.
provisional list.
Please take out notice. Anybody for Jilla Panchayat Ramnagara? Jilla Panchayat Ramnagara? AG is directed to accept notice for R1. Issue emergent notice to respond number 2, 3 and 4.
serial number 19, Aditya M.
My lord, I appear for the petitioner. I had filed an IA number 1 seeking condonation, sorry, my lord, with respect to dispensation of certified copies of Annexure H, my lord.
Aditya M.
Yes, my lord.
Certified copy of Annexure A.
H, my lord. By oversight, I would request your lordship to please, my IA is at page number 105 of writ petition, my lord. It is Annexure H, my lord. By oversight, the cost title ಮಾಡುವಾಗ A ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Mistake is on you or by the office?
I request your lordship to please see my IA. It states Annexure H, my lord.
IA 124 is filed for dispensation of the production of certified copy of annexure H.
I'm ready to argue on the main matter, my lord, if your lordship
Of the
permits.
cost form for seeking dispensation is perused and accepted. Hence IA 124 is allowed. What is the case about?
My lord, it is a case wherein, my lord, I'll give a small backdrop, my lord. My lord, the petitioner number 1 to 11 herein are the members of the District Consumer Forum, my lord. They are currently presiding over and adjudicating the consumer cases, my lord. I have produced, my lord, the petitioners in the above case have come up with the above petition questioning and challenging the legality of the annexure H, my lord, which has been issued by R3, respondent number 3. My lord, wherein the respondent number 3 has denied the interim relief to the extent of 17% in the government pay, my lord. In his own annexure, placed at annexure H, my lord. My lord, I have produced the, just to give you a backdrop, my lord. My lord, the petitioners are appointed members of the Karnataka District Dispute Redressal Commission as per the government notification placed before your lordship at annexure A, page number 37, my lord. That is when I was selected.
Yes.
Further to my selection, my lord, I was appointed with respect to the with respect to Bangalore District Consumer Dispute Redressal Commission with respect to all other, as mentioned in annexure B at page number 22, I have produced the postal order, my lord, wherein I have been appointed. Till date, my lord, I have discharging my function as the adjudicating officer, my lord, there as member, my lord. Moving further, when the matter stood thus, my lord, the government was pleased to sanction the interim relief to the extent of 17% of the basic pay of the Karnataka state government employees, drawing pay to the extent of in 2018, a revised pay scale with effect from 1/4/2023. By virtue of the government order, wide number FD7 SRP 2020-23, Bangalore dated 1/3/2023. I have produced the government order, my lord, Geo, at page number 58, annexure F, my lord. I would request your lordship.
What is the benefit of that Geo?
Yes, my
is
lord.
available to
It was
even,
denied to me, my lord, by the respondent number 3.
You are a contractual employee or what do you call?
I'm a casual. I'm a casual.
After retirement, you've been appointed.
No, my lord. Before that itself, my lord, I would, yes, my lord. So far as the very Karnataka Consumer Protection Act rules is concerned, I am equivalent to Deputy Secretary, my lord. That I request your lordship to please come to.
Have you been appointed? Is it a case of re-employment?
No, my lord. I have already appointed. Till now, I am discharging my duty.
You're not getting it.
Please, my lord.
Were you serving the government earlier?
My lord? Yes, my lord.
Were you serving the government earlier and retired?
No, not retired, my lord. Not retired. They issued a notification seeking for selection committee, my lord. In selection committee, I was appointed. After appointment, my lord, this with respect to retirement comes for president, my lord. The petitioners herein are not the president. As your lordship is well aware, Consumer Forum consists of 3 people, members and the president, my lord. I'll just in 2 minutes, I will explain, my lord. Moving further, I request your lordship to please come to page number 94, my lord.
We will please take out notice. AG has directed to accept notice for response 1 to 4.
I seek for interim prayer, my lord.
What interim prayer?
My lord, to stay the operation of the impugned order, my lord, wherein the relief is been denied to me. I will explain, lordship, in just 2 minutes, my lord.
Relief is denied. We have to allow the petition. By granting a stay, what will you get?
At least issue emergent notice, my lord.
I have asked the government advocate to accept. It is double emergent notice.
Thank you. But my lord, R4 ge last time ಇನ್ನೊಂದು petition ಅಲ್ಲಿ ಮಾಡಿದಾಗ ನಮಗೆ emergent notice ಮಾಡಿದ್ವಿ. Who is the registrar of the Karnataka state?
The government can take notice for them also.
Grateful, my lord.
Serial number 20, Shankar Narayan Bhatt.
Annexure D is under challenge, my lord.
Annexure?
Annexure D, my lord.
K.
D.
What the petitioner was appointed or they promoted as a in-charge vice principal of the institution run by the 4th respondent.
Yes.
As per annexure D in the year 2021, he is discharging his duty as in the capacity of vice principal. Now annexure D has been passed by the management, directing me to relieve from the post and directed me to take charge as a regular teacher of the institution. This order is under challenge. Kindly see annexure C at page number 12. The order is passed on 24/11/2021. ಉಲ್ಲೇಖ ರೀತಿಯ ಕೇಶ ಶಿಕ್ಷಣಾಧಿಕಾರಿಗಳು ಗೌರಿಬಿದನೂರು ಅವರು ಕಚೇರಿ ಪತ್ರ ಬರೆದು ಸಂಯುಕ್ತ ಪದವಿ ಕಾಲೇಜು ಪ್ರೌಢಶಾಲೆ ಮಂಚೇನಹಳ್ಳಿ ಗೌರಿಬಿದನೂರು ತಾಲೂಕು ಇಲ್ಲಿ ಉಪಪ್ರಾಂಶುಲ ಕರ್ತವ್ಯ ರಾಮಚಂದ್ರ ರೆಡ್ಡಿ ಅವರು ದಿನಾಂಕ 23/3/20 ಸೇವೆಯಿಂದ ವಯೋನಿವೃತ್ತಿ ಹೊಂದಿರುವುದರಿಂದ ಶಾಲೆಯ ವೇತನ ಮತ್ತು ಇತರ ಭತ್ಯೆಗಳನ್ನು ಸೆಳೆಯಲು ಆಡಳಿತ ಮಂಡಳಿ ಎನ್ನುವಂತೆ ಸಭೆ ಸೇರಿ ಟರಾವು ಮಾಡಿ ಸದರಿ ಭತ್ಯೆಗಳ ಶಾಲೆಯಲ್ಲಿ ಸೇವಾ ಜ್ಯೇಷ್ಠತೆ ಆಧಾರ ಮೇಲೆಗೆ ಹಿರಿಯ ಸಹ ಶಿಕ್ಷಕರಾಗಿ ನಡೆಯುತ್ತಿರುವ ರತ್ವರ್ಮ ಅವರು ಬದಲಿಗೆ ಶ್ರೀ MV ಶ್ರೀನಿವಾಸ್ ಸಹ ಶಿಕ್ಷಕರು ಅವರಿಗೆ ತಾತ್ಕಾಲಿಕ ಉಪಪ್ರಾಂಶುಲ ಪ್ರಭಾರ ವಹಿಸಿದ್ದು ಇಲಾಖೆ ಅನುಮೋದನೆ ಕೋರುವುದರಿಂದ ಆಡಳಿತ ಮಂಡಳಿ ಪ್ರಸ್ತುತ ಖಾಲಿ ಇರುವ ಉಪಪ್ರಾಂಶುಪಾಲ ಹುದ್ದೆಯನ್ನು ಭರ್ತಿ ಮಾಡುವ ತನಕ ಹಾಗೂ ಅವರು ಕೋರಿರುವಂತೆ ಸಂಯುಕ್ತ ಪದವಿ ಕಾಲೇಜು ಪ್ರೌಢಶಾಲಾ ವಿಭಾಗ ಮಂಚೇನಹಳ್ಳಿ ಗೌರಿಬಿದನೂರು ತಾಲೂಕಿನಲ್ಲಿ ಪ್ರಸ್ತುತ M ಶ್ರೀನಿವಾಸ್ ಅವರಿಗೆ ತಾತ್ಕಾಲಿಕ ಉಪಪ್ರಾಂಶುಪಾಲ ಹುದ್ದೆಯನ್ನು ಪ್ರಭಾರ ವಹಿಸಲು ಅನುಮೋದಿಸಿದೆ. Now next order is now melody is order passed after more than 3 years. The management passes directing me to hand over the charge to the respondent number 4.
Who is respondent number 4?
Respondent number 4 is represented by a Keveta, my friend.
Correct. Who is he? Is he?
He is also another teacher who is going to be retired in a period.
He's senior than you.
Yes.
Is he senior than you?
No.
My lord, that order,
Now,
whatever the temporary order,
my situation with it. From
Suppressed the-
2021 to
Don't ridicule him, mister. When you're
Okay.
arguing, the way you said, huh? Don't ridicule him. Please wait for your turn.
from 2021 to 24, I am discharging the duty.
It's okay.
All
That
of a
is,
sudden, now the director giving me to hand over. There is no approval is also from the department. The
sir,
institution
you're only
makes
an
its own-
in-charge principal.
Pardon me?
You're only an in-charge
Please,
principal.
please, I am not.
Now the
being-
management has posted somebody else in your place to officiate as the
Could
principal.
be, I am not disputing that aspect of the matter. Now, the thing is this, when my representation, the institution itself has recommended for the department has approved it. Now, all of a sudden, you hand over chain.
As an in-charge.
No, they have no power to do so because already been discharged 3 years. It has not been questioned at all.
No, that doesn't matter. So long as you're an in-charge, you're an in-charge.
Look,
Unless your post is approved as
now,
a
once
principal.
again, a new person has a full charge is not been also given. Another person is also in charge.
Yaro.
Eager respondent number 4 is also ordered to be in charge.
Please read that order.
Annexure D. ಉಪಪ್ರಾಂಶ M ಶ್ರೀನಿವಾಸ್ ಪ್ರಭಾವ ಆಚಾರ್ಯ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಪ್ರೌಢಶಾಲೆ ವಿಭಾಗ ಗೌರಿಬಿದನೂರು ಈ ಮೂಲಕ ತಿಳಿಸುವುದೆಂದರೆ ಆಡಳಿತ ಮಂಡಳಿಯ ತೀರ್ಮಾನ ಮತ್ತು ಶೈಕ್ಷಣಿಕ ದೃಷ್ಟಿಯಿಂದ ನಿಮ್ಮನ್ನು ಉಪಪ್ರಾಂಶಲ ಹುದ್ದೆಯಿಂದ ಬಿಡುಗೊಳಿಸಿ ಸಹ ಶಿಕ್ಷಕ ಹುದ್ದೆಯಲ್ಲಿ ಅನುಷ್ಠಿಸಿರುವ ಪ್ರೌಢಶಾಲೆ ಉಪಪ್ರಾಂಶುಪಾಲ ಪ್ರಭಾರನ್ನು ತಕ್ಷಣ ಜಾರಿಯಾಗಿರುವಂತಹ ಗಂಗಾಧರನು ಆಚಾರ್ಯ ಪದವಿ ಕಾಲೇಜು ಪ್ರೌಢಶಾಲೆ ಅವರಿಗೆ ಉಪಪ್ರಾಂಶಲ ಹುದ್ದೆಗೆ ನೀಡಲಾಗಿದೆ. Now this, unless it has been approved by the department,
Yes.
they have no right to change my, all of a sudden, now 3 years I am discharging that duty. All of a sudden, once again, the respondent number 4 is ordered to be charged. He was in service as on that day. As against him, criminal cases are also pending.
Whether this man's the appointment as an in-charge is approved.
No, that is under challenge. This honorable court is directed to follow the 99 rules. As per the directions of this honorable court passed in writ petition, the appointment order itself, I have already filed the objections where I have all the documents I have produced. For compliance of this court order, I am appointed.
So this Rangadamaya also has filed some writ petition.
A writ petition challenging the temporary
ಮೇಲ್ಕಂಡ
vice principal post given to the
ಮೇಲ್ಕಂಡ ವಿಷಯ ಉಲ್ಲೇಖಿತ ಮುಂದೆ ಆಡಳಿತ ಮಂಡಳಿ ಅಧ್ಯಕ್ಷರು
objection file ಮಾಡಿದ ಕೊಡಿ ಸರ್. I have filed the detailed.
Passed in the year 2022. That operative portion may kindly be seen at page.
Please wait.
6.
I have produced the writ order issued by this honorable.
Where is that?
Objections along with the objections.
ಏನಂತ ಆಗಿದೆ? What is the order passed in the writ petition?
Lord, your lordship may kindly said that's a He has filed objection statement and same is available at page number 25 is objection statement, operative portion. Passed by the learned single judge of this honorable court.
Para
Number
two, may kindly. see.
Odi.
Ink page. Sri Satish, learned counsel for the petitioner, would submit that the petitioner is working as an assistant teacher in the institution run by the respondent association. It is grievance of the petitioner is that he is this senior most assistant teacher in the institution and post of the principal, vice principal is to be filled up in accordance with the Karnataka Educational Institutions Recruitment and Terms and Conditions of the Service of the Employees in Private Aided Primary and Secondary Education Institutions Act, Rules 1999 for the short term 99 rules. It is submitted that on retirement of Sri M.B. Srinivas, post of the vice principal is.
No, this
held
M.B.
by the-
Srinivas has retired.
No, Ratna Verma temporarily, Srinivas is.
So Ratna Verma is retired. ಅದು
Ratna
ಉಲ್ಟಾ ಆಗಿದೆ.
is retired. In his place, the present petitioner was temporarily appointed and approved by the fourth respondent DDP had been challenged, which had been set aside and directed this honorable court to follow the 99 rules. As per the direction of this honorable court, the institution is temporary appointment is.
So based on the 1999 rules, this order is passed.
Yes, my lord.
Whether this order is sent for approval,
My lord.
whether this order is sent for approval,
Yes, my lord.
ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಇವ್ರಿಗೆ DDP ಆರ್ಡರ್ ಮೇಲೆನೆ ಡೈರೆಕ್ಷನ್ ಮೇಲೆನೆ this order had been issued.
ಎಲ್ಲಿದೆ ಅದು?
I have produced the direction issued by the
Where is the order
DDPI.
passed to the DDPI?
The direction issued by the DDPI at
Yes, where is that order? Put it.
DDPI had issued by the.
Not been served on me, my lord.
The direction had been issued by the.
Sir, copy please.
No, that's okay. This is 24/2/2023.
Yes.
After this order was passed on 26/7/24, whether this order is approved.
Immediately they have challenged. It is for sent for approval.
Has it been sent for approval?
Yes, ma'am.
Then
Lord, it's more for the first time I my lord.
No, but have you-
He has filed objection statement. It has
So
not
that's
been served on
okay.
me.
no, you were a party to in the earlier writ petition.
The earlier writ petition, I am not a party.
You're not party?
I am not a party.
The institution is
Your
well
Lord-
aware of that.
Your lordship may kindly see what the order passed by the learned single judge. The sixth respondent is direct to fill up the post of principal or vice principal, headmaster or headmistress to the institution run by the respondent, that is Acharya Pre-University College High School, division of Gauri Bidanur in terms of 99 rules.
So how do you say that this appointment of the respondent number 4 is opposed to the 1999 rules?
My lord, the very clear is that in that order, they should get an approval. It has not been
Sir,
so far.
How do you say
Well, I'll
that
complete.
the appointment of
I'll
respondent number
complete what
5?
the- on the basis of the orders passed by the learned single judge. If such proposal is forwarded by the sixth respondent institution, the official respondent has decided to take up steps to approve the same in terms of the 99 rules. It has not been sent. This order is passed in the year 2022. It has not been sent, so far has been not sent. Now they claim that we have sent it.
Yes,
Now they have, at least in the objection statement also, it has not been produced at all.
yes.
They have filed objection statement yesterday. It has not been done.
You
And
produce the
at
letter sent
another
for approval.
99 rules is
Another
very
rule-
clear, rule
another-
8.
Please show the document
My lord.
to establish that your appointment as a principal has been approved. Idre kodi.
as per the direction of this honorable court, they have,
Even if this court has directed, if an appointment order is issued, because this is an aided institution, should it not be approved?
now in the last 1 week back only he was appointed.
So
And it
therefore,
is
has
sent
it been
for,
sent for approval? I have been asking 100 times.
yes,
Has
sir.
it been sent for approval?
I will get the,
If it is sent for approval, make a statement that it is sent for approval.
I will produce the doc.
ಯಾವಾಗ ಮಧ್ಯಾಹ್ನ
Next, ಮಧ್ಯಾಹ್ನ ಇವತ್ತು ಆಗುತ್ತೆ ಇಲ್ಲ ವಾಟ್ಸಪ್ ಅಲ್ಲಿ
ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ತರಿಸ್ಕೊಳ್ಳಿ.
ತರಿಸ್ಕೊಳ್ಳಿ.
If it is sent for approval, dismiss this petition, let him challenge it
Yes.
in the manner known to law. If he is appointed,
Now if it's already been sent, all that things, there should have been, find a place in this objection statement. Bond.
let him
That's
find
not
out.
been done so far.
Please
Another
produce it.
submission, what I am making.
2:30,
Lord,
2:30.
One more submission I want to make. There are two institutions are run by this, colleges are there. And in the both the colleges, there is a vacancy of principal. One, he could be accommodated and he will be
That
retiring
we
for
will not
another
say,
6
no,
months.
that we will not venture into deciding what should be done by the management.
No, I'm not that, I'm just bringing to your
No, no,
lordship.
please
notice.
don't even make a mention. We can't direct who has to be appointed as a vice. Again and Idya, we do not know the
The
economics
two
involved.
institutions in the same taluk, my lord. That's the reason I'm
We
making.
do not know who is the senior, whether you are senior, the other person is senior. We can't pass any.
The document
Keeping
given
direction.
by the institution itself shows that I am the most senior. Even in the earlier
Produce
petition.
that letter sent for approval. Pass over, 2:30.
21, Virupakshayam.
Virupaksha.
First over matter, serial number 10, I'm extremely sorry I could not be present.
Where serial number 21.
I'm so sorry.
My lord, IA one for a dispensation of annexure D, my lord.
I think. So and so IA 124 is allowed. Yes, next.
My lord, the petitioner as working as a manager, office manager at Sagar City Municipal Council, Shimoga District, my lord. A petitioner was discharging his duty as with the satisfaction of the seniors while discharging his duty. The first respondent issued impugn order on 31/7/24, disturbing the post of the petitioner by transferring the R4 to the post of petitioner.
When were you, from how long you have been serving here?
Since from
2020?
2020, my lord.
So how long you want to be in one post?
Now, without my submission, Your Honor.
Posting kotilva?
No, ma'am, without deputing any place or
no posting.
vacancy,
No
they have
post-
deputed the petitioner, Your Honor. It is, which is against the guidelines, Your Honor.
Venkat. Here is your name?
Guidelines.
Guidelines of, where is
Guidelines.
your name? Venkatayya.
Sir. Sir.
Nagaraja, Jagadevi, Madhu. Narsimurti, Venkatayya Yellappa idre, where is?
Annexure D, ma'am.
ವ್ಯವಸ್ಥಾಪಕರು ಸಾಗರ ನಗರ ಸಭೆ ವೆಂಕಟಯ್ಯರ ಜಾಗಕ್ಕೆ ಸ್ವಂತ ವೇದ. Is Venkatayya ingenu?
By
The posting for
Venkatayya. Venkatayya.
Is there any posting given to Venkatayya?
My lord, appearing for the caveat or on behalf of Prabhu L, my lord, I'm appearing on behalf.
That's okay.
My lord, he has taken charge, my lord, on 1/8.
That's okay, Mr.
My lord,
Because
no,
Venkatayya has been-
no posting has been given, my lord. For
Therefore, please get it direct. Because otherwise we'll have to say
Now
this.
the first respondent compelling the petitioner to relieve from the service.
Let him be released. How long you want to serve in one place?
3
More
years.
than 2
No,
years.
they have not shown the place and admit.
We'll get, the government advocate will get direct instructions. Himge posting ಕೊಡ್ಬೇಕು, he will get instructions. ಬರ್ಕೊಳ್ಳಿ. AG is directed to accept notice
order
for
may be spared,
respondent
madam.
number 1 and 2. Issue emergent notice to respondent number 3.
My lord,
Sir.
interim order may be.
No interim order. Yes. The respondent number 4 is on caveat and he acknowledges the receipt of a
File
copy of
the
the
objection by the R4 on.
Full stop.
That status quo may
With
be.
regard to the fact that the petitioner has been working as a manager at The City
Sagara.
Municipal Council, Shivamogga, Sagara,
Sagar, yes, ma'am.
from December 2020, his transfer on 31/7/2024 cannot be treated as in violation, cannot be held to be in violation of the transfer guidelines. Be that as it may, since the respondent number 2 has not given a posting, in view of the judgment of the division bench of this court in Seema versus State of Karnataka, the additional government advocate is directed to secure instructions as to whether the petitioner can be given a posting. List on Yavat 20? 14th. 14th. List on 14th. Please serve a
Status
copy
copy-
of the petition.
And already
Copy,
served,
copy.
the first husband already served, my lord.
ಇನ್ನೊಂದೆರಡು ಕಾಪಿ ಕೊಡ್ಬೇಕು
Okay.
ಕೊಡ್ರಿ.
Please, ma'am.
Coordination matters, serial number 22, Balakrishna MR.
MR Balakrishna.
The petitioners are challenging the order of taking cognizance and issue of process passed by the Honorable Trial Court for the offences punishable under sections 379, 425, 427, 434, 441, 503, 504, 506, and with 120 B IPC, my lords.
Yes.
Impugned order is in page number 23. This order of taking cognizance and issue of process passed by the Honorable Trial Court. Register the case in the register number 3 for the offences punishable under section 279, 425, 427, 434, 441, 503, 504, 503, 120 B IPC. There are 20 accused in the case, my lord. The present petitions are accused number 2, 4 to 6, accused number 8 to 18, my lord. And this court already quashed the proceedings against the accused number 7, my lord.
No, what are the allegations against you?
The identical allegations against all the accused. The case of the prosecution that these petitions have removed the survey stone and barbed wire fence and shifted it. That is the case of the prosecution, my lord. You will also kindly turn to page number 110. Is the order passed by this court, quashing the proceedings against the accused number 7. Page number 110.
Yes.
So relevant para in page number 8, page number 114, para 8 and 9, my lord. It is not in dispute that parties are litigating over a property in respect of which respondent 2 has already obtained a decree in OS number 398/192. It is also not in dispute that respondent 2 had already applied for execution of said decree in execution petition number 3/2016. Where she had sought for punishing the accused for willfully violating the judgment and decree passed in OS number 398/1992. As rightly contended by the learned counsel for the petitioner, respondent 2 had improved her case from time to time. On 25/3/2016, she alleged that the accused had removed the barbed wire fence, stone pillars, and placed them in her own property. However, this version changed when the private complaint was filed, where she alleged that the accused had removed barbed wire fence on 23/2016 and the stone pillars and removed them, and thus committed theft of property valued at more than ₹1 lakh. However, in the execution petition filed by the respondent 2, she alleged that incident took place on 33/2016 and not on.
You not arrange the state as a party.
It's a private complaint.
Private complaint.
Yes, private complaint. Private complaint fined under section 200 of the CRPC, and the Honorable Trial Court recorded the source statement of the respondent 2, my lord.
Yes.
Now, identical allegations. So doctrine of parity is applicable in the given case, my lord.
It is the third party. For CC has been,
Yeah.
criminal case has been registered, hence state is necessary party.
Criminal case,
Earlier.
It is not the
in
necessary
Earlier order,
party.
my lordship, state
It's a
has been
private
read as
complaint.
party.
charge sheet is not filed by the
Filed.
state.
Filed by charge, state. my lord.
Charge sheet is
Not
filed.
charge sheet. Your lordship kindly turn to page 20. 20 is the order sheet.
CCL.
CC ಆಯ್ತು ಸರಿ. After the cognizance is taken, CC is registered.
State is not the party.
ಆಯ್ತು. Against one accused, we have quashed it. Let the other, against the other accused also let it be quashed. What happened to the civil proceedings?
Lordship.
What happened to the civil proceeding? You are for the respondent number two.
For two.
What happened to the civil proceeding? You had filed some execution. What happened to that?
Pending. Lord.
Pursue that execution.
But my lordship, the allegation against these petitioners, as my lordship, it is attracting prima facie ingredients of the offences.
I think we'll consider the purport. You received a copy of the petition? After hearing the learned counsel for the petitioner and the learned counsel for the respondent, it is seen that this court in criminal petition 9704 of 2018 had quashed the proceedings against accused number 7, number 7. Full stop. The allegations against the petitions herein were more or less similar to the allegations made against the accused number 7. In that way of the matter, since the parties are litigating over a property which is a subject matter of OS number 398 of 1992, and the respondent number 2 has already initiated execution proceedings to execute the decree in OS number 398 of 1992, further proceedings against the petitioners deserves to be stayed. This on when will you argue?
Stay ಆಗಿದೆ already.
Stay ಆಗಿದೆ ಅವತ್ತು.
ಹೌದು.
ಮತ್ತೆ ಯಾವತ್ತು ಮುಗಿಸಿಬಿಡೋದು? We'll close it then. Barful. Madam, the petitioner, the petitioners have challenged the prosecution launched against them by the respondent in CC number 266 of 2023, pending trial before the senior civil judge and JMFC Moodbidri for the offences punishable under section 379, 425, 427, 434, 441, 503, 504, 506, read with section 120B of IPC. Full stop. The petitioners contend that the respondent had inherited certain property, inherited a property bearing survey number 20/6B of Kilpadi village, Mangalore Taluk, Dakshina Kannada district, measuring 34 cents from her father. Her father had filed a suit for perpetual injunction against the petitioners and some others in OS number 398/1992 before the Principal Civil Judge Junior Division, Karkala, Dakshina Kannada district, which was dismissed. Thereafter, he filed RA 391 of 2005, which was decreed. Full stop. Agreed with the said decree, the accused number 1 / petition number, accused number 1 filed RSA 1626 of 2009, which was dismissed on 25/3/2014. Full stop. The respondent alleged that the petitioners, forming an unlawful assembly on 20th of March 2016, removed the survey stones and barbed wire fence and shifted it. Full stop. When the respondent questioned the petitioners, she was abused and threatened of her life. She therefore lodged a complaint before she therefore reported the incident to the jurisdiction police, who registered a non-cognizable report stating that the acts alleged were purely civil in nature. So the respondent thereafter filed PCR number,
PCR number 65/2017, my lord.
65/2017. Full stop. The trial court recorded the sworn statement of the respondent, and after considering the material, took cognizance of the offences punishable under
page number 23.
section 379, 425, 427, 434, 441, 503, 504, 506, read with section 120B of IPC. And registered CC number 40/2017, presently renumbered as CC number 266/2023. Full stop. The petitioners contend that the private complaint was not accompanied by an affidavit and there was no complaints of section 154(3) of CRPC, and therefore the trial court could not have taken cognizance of the offences alleged. It is also contended that the accused number 7 had approached this court in criminal petition 9704 of 2018, and this court, after noticing the fact that the respondent had already applied for execution of the decree passed in OS number 398 of 1992, held that the prosecution of the petitioner therein was not warranted. It also noticed that the respondent had taken different versions when she reported the incident before the jurisdictional police on 25/3/2016 and when she filed a private complaint before the trial court, as well as in the execution petition filed by her. Full stop. Therefore, this court held that the allegations made by the respondent were suspicious and hence quashed the proceedings against accused number 7. Next, in the present case 2, the petitioners are similarly placed and therefore the prosecution of the petitioners is unwarranted. Consequently, this petition is allowed and the impugned prosecution of the petitioners in CC number so and so on the file of so and so for the offences punishable and so and so is quashed.
Much obliged.
Very good.
Number 2.
Maintainability of IA of 21 for recalling the order.
Appearing for the respondent, my lord.
Parthasarathy,
My lord,
Mr. Parthasarathy, MS Parthasarathy.
MP Srikanth.
my lord, what has happened is, my lord, an order was passed, my lord, by this honorable court on 24th October 2019.
24th October.
October 2019, my lord. The
September.
matter was disposed of on a submission, my lord, at paragraph 2. May I read that, my lord? This court on 19/2/2019 has recorded the submission of Lord Senior Advocate appearing for respondent minister that petitioner was not orally informed about any termination. That said the submission has been placed on record. Petitioner has been granted liberty to join the services in the respondent institution. My lord, his allegation is that we have been orally terminated. He has challenged that before the Educational Appellate Tribunal. Educational Appellate Tribunal, my lord, dismissed his application. That was challenged in this petition, my lord. My lord, we said that we never terminated him, my lord. It was only a promotion given to him. My lord, after this, my lord, now he has filed a recalling application, my lord. The reason he's asking for the recalling is that, my lord, we are not paying him the salary. My lord, that is the application, my lord.
See, if you're not terminated him, then he's bound to be in service.
Please, my lord, he has reinstated. We have paid him salary till December 2019. My lord, after that, my lord, he did not attend, he did not take any classes. My lord, the matter is pending before the Education Appellate Tribunal till now. And my lord, he has also made an application, my lord, for payment of salary for the COVID period. My lord, that order was allowed in favor of him, my lord. I have deposited the 50% amount of that, my lord, and then I've challenged that, my lord, in a separate
But
petition.
is he still working?
My lord, as of today, he is not working, my lord. He is not coming up, my lord. That is,
From what day is not working?
my lord, from December 2019 was the last salary paid to him, my lord. After that, my lord, he did not take any classes. He came to the college and sat in the staff room and he went, my lord. And then, my lord, one class was taken where the students have complained that he did not take any class. He simply sat in the class and he went on. That was the.
insofar as the application which has been filed, my lords, is on the premise that, my lords, there is no compliance of the order pass. I'm not being.
What is the order passed?
Lords, what happened, my lords, the petition was disposed of. On the my lords, my lords, I was working as, my lord, the headmaster of the high school. I was relieved of my duties. It was my contention that I have been relieved, which amounts to removal. My lords, I filed an appeal before the Education Appellate Tribunal. My lord, the writ petition which I had filed before the Honorable Court against the interim order, my lords, that is rejection of the interim order, was disposed of on the basis made by, my lord, the counsel for the other side, saying that I have been promoted and posted as the principal of the institute, the college, which is according to them claimed by the same management, which I disputed, saying that it has been entrusted to some other entity. It is the college, the management is not running that.
No, but anyway, you are reinstated.
My lord, not, that's what I'm trying to say, my lords. My case was that it is not a case of, my lords, the reinstatement or whatever. They wanted to keep me out of the employment. I was not even provided with the work allotment. I filed this application seeking for recalling of that order. In the meanwhile, my lords, I had moved an application before the Education Appellate Tribunal. There, my lord, the other side is directed to make deposit, my lords, the salary for that period. They have, my lords, I am instructed to state that, my lords, a portion of that amount, my lords, is deposited.
think
to the
survey
court.
for,
That's the reason, my lord, this application, my lords, may not survive for consideration, my lords, and may be disposed of, my lords, on that reason.
Where is the order passed by the EAT?
Lords, right now.
Or could I, the learned
Lord, on
counsel
the
for
salary,
the
my
petition?
They have filed, my lords, one more writ petition, my lords, as against.
That's okay. We are not
It is-
bothered about. Learned counsel for the petitioner. IA 2 of 21 is filed by the petitioner to recall the order dated 24/10/2019. Stop. By the order dated 24/10/2019, comma, this court merely recorded the
Hello.
submission
Good
of the
morning.
learned
Eli,
counsel
sir.
for the respondent that the petitioner was not informed orally about this termination of his services. Full stop. This court placed the submission of the learned counsel for the respondent on record and granted liberty to the petitioner to join the services in the respondent institution. Full stop. This application is filed on the premise that the respondent, after making the aforesaid submission, was not allotting any work and was not paying any salary. Full stop. When this application was listed for orders, the learned counsel for the petitioner submits that the Education Appellate Tribunal in MA EAT 5/2017 has passed orders on an application and filed by the petitioner and has directed the respondent institution to deposit half of the salary, directed the respondent institution to pay the salary.
My lord, 25% of the what salary was paid in the COVID period for the other lecturers, my lord.
Directed to, has passed orders regarding payment of salary to the petitioner. Full stop. He therefore submits that in view of the order passed by the EAT, this application may not survive for consideration, does not survive for consideration. In view of the aforesaid submission, IA 1 of 20, IA 2 of 21 is rejected as it does not survive for consideration. Yes.
Hearing on IA serial number 2.
This is Prashant.
I appear for the petitioner's counsel, my lords. This is questioning the penalty of dismissal from service imposed on a district person who was a district judge on super time scale. This IA, my lords, a wrong IA has been put up, but a correct IA is not shown. But then,
But will he hear the matter finally then?
yes, my lords, I am ready, my lords.
So please tell
I'll
us
come
when
at
when we can take it up. 2012 matter. When can we take it up?
Any day I am in my lord's command, my lords.
Yes. Yeah, on date code list on.
There is only one submission I would like to make at this stage, my lords. One of the contentions I have raised is the inquiry officers who were appointed were part of the administrative collective number 1, which rejected my defense statements,
We'll
which
consider
rejected
that.
my representations.
This is the
Records
petition.
produce ಮಾಡಿ ಅಂತ ನಾನು ಅಯ್ಯ ಹಾಕಿದ್ದೀನಿ. Let them make available the
Let us
consent
see if
resolution.
those records are necessary, we'll call it immediately. After all, the records will be lying in this building only.
But even that they are reluctant to produce.
We'll get the record. It is our own office, our own building. We can get the records.
That is a
here.
problem, my lords. For High Court, getting records from others is easy, but from our own is a problem.
Don't tell me
On
it is
that IA, the matter has gone from week to week for about 6 weeks.
No, that is okay. Don't tell me that it is difficult for even the court to get the records from its own registry.
In this case, that has been my
No,
experience.
we can get the records. Don't worry about it.
Very
We'll
well,
also
Manoj.
allow examination of the record by you.
Very well, Manoj.
IA 1/23 shall be considered along with the main petition. List for final hearing on
3rd August.
23rd August.
August.
Serial number 3, Kishan GS.
In fact, the respondent have also filed their statement of objections, my lord.
Why
It's also
this
covered by judgment, my lord.
covered by which judgment?
Covered by judgment of this honorable court only, my lord.
Yes,
In fact,
who
after
appears
4
for the
years of retirement,
Huh?
It's any date, Master.
Again, covered by
covered by
judgment.
judgment, my lord.
40 lakhs.
I have also given,
Any date, Master. File.
Any data, if this is a 2024 matter, unless you say it is covered, I will not take it.
Not covered, Master.
Not covered.
it is there. And my lord, he is 90% physically handicapped, my lord. To kindly see annexure A, my lord.
Objection ಹಾಕಿದ್ದೀನಿ ನಾನು ಒಲಿಗೆ ಹತ್ರ ಫೈಲ್ ಕೊಟ್ಟೆ ಅವರು ಆ ಕಡೆ ಎಲ್ಲ ಹೋಗಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ ಕೈಲಿ ಎನಿ ಡೇಟ್ ಮಾಡಿ
Learn counsel for the respondent seeks time list on.
Monday.
3rd August. List number 1 for final hearing matters.
Hmm.
Serial number 23. XB Mukkanappa.
Petition. Lord, in this case, Lord, your lordship may be pleased to recollect. Lord, the matter pertains to dismissal of an assistant accountant, Lord, on the ground that he was appointed as a cashier, but then he refused to report to duty on his reversion. Our settlement.
Settlement, what happened?
Lord, now, Lord, I have spoken to the bank. Lord, they are agreeable to pay a lump sum of about 5 lakhs, my Lord.
5 lakhs ಯಾರು ಒಪ್ಕೋತಾರೆ?
Swami,
Who will accept 5 lakhs? 5 lakhs is too less.
because ಇವ್ರಿಗೆ ಪ್ರಾಬ್ಲಮ್ ಅಂದ್ರೆ ಎಲ್ಲ ಹಿಂದಿನ ಡೈರೆಕ್ಟರ್ಸ್ ಟೈಮಲ್ಲಿ ಆಗಿರೋದು ಇದು.
Correct, but ಏನ್ ಮಾಡೋದು? Yeah, come up with some other, one more figure.
ಕಷ್ಟ ಆಗತ್ತೆ ಸ್ವಾಮಿ. ನಾನು ಇದರಲ್ಲಿ 3-4 ತಿಂಗಳಿಂದ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ನಾನು.
But 5 lakhs is too less. Even if I order reinstatement, what happens?
Now, my lord, he has crossed the age of.
ಆಯ್ತು.
At the time of 2013, he was retired. With date.
5 lakhs ನಾವು ಕ್ಲೋಸ್ ಮಾಡ್ತೀರೇನ್ರಿ?
I will take instead, but 5 lakhs, he had put in more than 29 years service. Date of dismissal, he had put in more than 29 years service.
ಅಲ್ಲ ಏನ್ ವಿಲ್ ಟ್ರೀಟ್ ಇಟ್ as ಟರ್ಮಿನೇಷನ್ ಇದು ರಿಟೈರ್ಮೆಂಟ್ ಅಂತ ಇದು ಮಾಡೋಣ ಅಷ್ಟೇ. ವಿಲ್ ಟ್ರೀಟ್ ಇಟ್ as ವಿಲ್ ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ ಯು
Take instruction, kindly out on Monday, my
so
lord.
that you get all other benefits.
ಆಗ್ಬೋದು. ಅದೇ ಒಂದು
5
court
lakhs
order
plus
at least.
compulsory retirement.
ಅಲ್ಲ, my lord, kindly out on Monday, Monday. Take his.
ಇದನ್ನೆಲ್ಲ ತಿಳ್ಕೊಬೇಕಲ್ರಿ.
Monday close. But I am sorry, in spite of my best effort, Lord, I could not.
ಏನೋ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡಿಸಿ.
ನನಗೆ 3 ತಿಂಗಳಿಂದ ಇದೇ ಕೇಸಿಗೆ ಅವ್ರಿಗೆ ಇದು ಮಾಡ್ತಾ ಇದ್ದೀನಿ ನಾನು. ಏನ್
ಆಯ್ತು, ಸ್ವಲ್ಪ ನೋಡಿ ಏನೋ ಜಾಸ್ತಿ ಮಾಡಿಸಿ.
ಆಯ್ತು.
About 8 lakhs, I think will be reasonable.
My lord, certainly I will make a sincere attempt, my lord.
8 lakhs.
If it is possible, certainly I will revert back to your lordship.
Monday.
Monday.
Tuesday, not Monday.
Number 24, N. Sriram Reddy.
For the petitioners.
Yes.
My lord, after the decision of Mahadevi case, several decisions came from
Now, what is your case? When did you enter service?
regularization of service. My lord,
I want to quote one ML Kesri case.
Yeah. Then don't go to the judgment. Please give me the facts first. What are the facts?
The petitioners were appointed. The first petitioner is the typist. The others were the class 4 employees. They are working for more than 25 to 30.
When were they appointed, sir?
They are appointed in 1992.
1992.
92.
Not even given the date when they were appointed. You simply say they got experience of more than 10 to 20 years. When they were appointed.
Earlier petition alli mention ಮಾಡಿದ್ದೆ ನಾನು ಇದರಲ್ಲಿ mention ಮಾಡಿಲ್ಲ.
When were they appointed, sir?
Now their service is more than 25 years.
I'm not on that. When were they appointed?
I will give the reason.
Was there an interim order in writ petition 5857? Was there an interim order in writ petition 5857 of 2001 not to terminate their service?
In the Annexure A, it is Annexure A. Yes. Which the communication dated the 31 January 2001 is hereby set aside only insofar as the relation to that portion which refers to termination of services of these petitioners and directed the Adhyaksh of the fourth respondent. The matter stands remitted back to the third respondent for recommendation of the matter afresh after obtaining consolidated report from the fourth respondent regarding appointment of these petitioners, and thereafter forward the same decision according to law to regularize the service of common cadre. Further, common cadre committee hereby directed to consider on merits in accordance with law after affording opportunity for the petitioners. This is the first petition. Annexure A. In the second petition, my lord.
ನೀವು ಉಮಾದೇವಿ ಕೇಸ್ ಓದಿದಿರಾ? ಓದಿದಿರಿ.
Para number.
What does ಉಮಾದೇವಿ say?
Para number 53.
What?
One aspect to be clarified. There may be cases where irregular appointments, not illegal appointments, as explained in S.V. Naranappa and also in other case, referred in para 15 above. Of duly qualified persons in the duly sanctioned vacant posts might have been made, and the employees have continued to work for 10 years and more, but without the intervention of orders of.
What do you mean by that?
Tribunals. My lord, the intention of this.
No, please read that sentence. But without the intervention of.
Vacant persons have been made. Employees continued to work for more than 10 years or more, but without intervention of orders of the courts or the tribunals.
ಏನಂಗಂದ್ರೆ ಅರ್ಥ?
If there may be any interim order to continue them, it is to be
So
considered.
therefore, you must have continued in service
Yes.
without the intervention of any court order
Yes.
to be entitled for consideration for regularizations. ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ? What is there to show that
My lord,
there is no interim order granted in this petition?
interim, it is not the interim order. There is no such directions to continue, only the direction issued to consider their case. for
Was there no interim order in the annexure A in that writ petition?
Interim order. Interim order. Interim order ಏನಿಲ್ಲ. Annexure ಏನಿಲ್ಲ.
See, you have been pursuing your case from the year 1998.
It is filed in 2005.
So in the year 1998, you filed a writ petition, petitioners 1 and 2.
That is more than 25 years.
So therefore, if you are continued based on interim orders, you are not entitled to the benefit.
So there is no interim order.
Please make a submission. There is no interim order. Then you have to get these records, WP number ella ತರಿಸ್ಬೇಕಾಗುತ್ತೆ. To find out whether there was an interim order.
Orders ಹಾಕಿದ್ದೀನಿ.
Huh?
Final decision, annexer A.
Final decision ಅಲ್ಲ ಸರ್, interim order ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಾರೆ.
Like, my lord, the deputy registrar, my lord, has passed an order. My lord, directing, my lord, the committee of the fourth respondent to terminate the services of the petitioners. Therefore, they filed a writ petition, and I think, my lord, they secured an interim order till disposal. Therefore, they were not removed from service.
Then thereafter you filed one more petition in 2009.
Yes, my lord.
Then again, there was an interim order to
Yes,
protect
sir.
your services.
In 2001 writ petition, there was an interim order. Because they have challenged the communication of the third
The
respondent.
second petition, annexer B, my lord, when they have considered the case of Kamraj, one petitioner number 1, they have not considered the other petitioners. As such, they have approved.
Amaraj, my lord, he is joined service prior to the constitution of Common Category Committee, second respondent, before 31/10/1992. Therefore, not his services was regularized. All others who joined service after the constitution of second respondent, not their services are not regularized because the local banks have not been empowered to make recruitment.
But they are still in service? Are these
Oh,
people
ಇವರಿಗೆ
still in-
ಫಸ್ಟ್ ಪೆಟಿಷನರ್ಗೆ ನಾವು ದಿನಗೂಲಿ ನೌಕರ ಕ್ಷೇಮಾಭಿವೃದ್ಧಿನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀವಿ.
benefits ಕೊಟ್ಟಿದ್ದೀರಿ?
ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂದ್ರೆ she is
What
Only
petition
daily
2 and
daily
3?
wages scheme.
first petition.
Petitions 2 and 3?
2 and 3, they are in service, but they are not eligible even under that act.
Why?
2006 ಗೆ 10 years of service ಮಾಡಿಲ್ಲ.
ಇಲ್ವಾ ಅವ್ರದ್ದು?
ಇಲ್ಲ ಮಾಡಿ.
But 10 to 20 years ಅಂತಾರೆ ಮತ್ತೆ writ
ಇಲ್ಲ.
petition ಅಲ್ಲಿ.
ಇಲ್ಲ, ನಾನು ಹಾಕಿದ್ದೀನಿ. I have produced the certificates were not issued by the local banks along with my statement of objections. 1996 ಕೊಬ್ರು 1998 ಕೊಬ್ರು ಜಾಯ್ನ್ ಆಗಿ.
Correct, ನೀವು facts ಕೊಡ್ದಿದ್ರೆ ಹೆಂಗೆ? You don't give the correct facts when you entered service, when you completed 10 years.
Right.
Page 15, my lord, of my statement of objections.
So the Sarvamangla is considered.
Sarvamangla, she joined, my lord, on 11/6/1996.
When did Sarvamangala join the service?
11/6/1996.
1996.
96.
Yes.
What about Manjunath Swami?
My lord, next, my lord, 9/9/1998.
9990?
98.
8.
98, my lord.
98.
Yes, my lord. 9/9/98.
Ganapati?
And my lord,
Petition number 3.
petition number 3, my lord. 1/4/1993.
1/4?
1993.
93.
Yes, sir. 1/4/1993.
Yeah, do you admit these dates? Do you admit these dates of joining?
Yes, but.
Please point out how you are entitled for regularization.
My lord, as far as the Umadevi case is concerned, my lord, recently, 2024, regularization of employment, change in nature of employment through continuous service, held the essence of employment and rights thereof cannot be merely determined by the initial terms of appointment when the actual course of employment has evolved significantly over time. Continuous service in capacities of regular employees.
Correct, sir. ನಿಮ್ದು ಎಲ್ಲಿದೆ ನಾನು ಕೇಳ್ತೇವೆ. Where is the continuous service? You have been continued under interim orders granted by the court. So therefore, how can you ask for regularization? See, ನೀವು
Melody, by entry order, their services were protected.
sir, if you are continued under the services of continuing services based on interim orders, it is not a continuous service. You cannot say that you are in service at all.
They are working in a regular basis on
That
the
is not
same.
that cannot be the contention. See, 96 ಇಂದ 2006 ವರೆಗೂ ಎಲ್ಲಾದ್ರೂ ಕೆಲಸ ಮಾಡೋದಕ್ಕೆ without intervention of the court order, you please point out, we will grant you the relief.
Kindly go through the para 6 of the.
Annexure C ಓದ್ಬಿಡಿ ಒಂದ್ಸತಿ. Please read Annexure C. Please read Annexure C.
Yes.
Annexure C.
Yes. ಸೇವೆ ನ್ಯಾಯಾಂಗದ ತಡೆಯಾಜ್ಞೆ ತಂದು ಸೇವೆಯಲ್ಲಿ ಮುಂದುವರಿಯುತ್ತಾರೆ. ನ್ಯಾಯಾಂಗದ ತಡೆಯಾಜ್ಞೆ ತಂದು ಸೇವೆಯಲ್ಲಿ ಮುಂದುವರೆದಿರುತ್ತಾರೆ.
ಅಲ್ಲ, Annexure C ಓದಿ ಸರ್.
Annexure C.
Page 27.
27. ಕರ್ನಾಟಕ ಗೌರವ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಅರ್ಜಿದಾರರ ಸರ್ವಮಂಗಳ ಮಂಜುನಾಥ ಸ್ವಾಮಿ ಗಣಪತಿಯವರು ಹಂಗಾಮಿ ನೌಕರಿ ಇರುವುದು ದಾಖಲಿಸಿ ರಿಟ್ ಅರ್ಜಿ 2009 ದಾಖಲಿಸಿದ್ದು, ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 20/6/2012 ನೀಡಿರುವ ತೀರ್ಪುಗನುಗುಣವಾಗಿ ದಿನಾಂಕ 28/8/2000 ಅರ್ಜಿದಾರರು ಖುದ್ದಾಗಿ ದಾಖಲಿಸಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ದಿನಾಂಕ 31/10/1992 ಒಳಗೆ ಸೇರಿರುವ ದಿನಗೂಲಿ ನೌಕರ ಸೇವೆಯನ್ನು ಸಕ್ರಮಗೊಳಿಸುವ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಜಾರಿಗೊಳಿಸಿ ಅಂತ್ಯಗೊಳಿಸಲಾಗಿದೆ. ದಿನಾಂಕ 31/10/1992 ನಂತರ ನೇಮಕಾತಿ ಅಧಿಕಾರವು ಸಾಮಾನ್ಯ ಶ್ರೇಣಿ ಸಮಿತಿ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮಾತ್ರ ಇರುತ್ತದೆ. ನಿಯಮಬಾಹಿರವಾಗಿ ಯಾವುದೇ ಹಂಗಾಮಿ ನೌಕರನ್ನು ನೇಮಿಸಿಕೊಳ್ಳಬಾರದೆಂದು ಸೂಚನೆಯಲ್ಲಿ ಕಳಿಸಲಾಗಿದೆ. ಆದರೆ ಈ ನೌಕರರನ್ನು ಪಿಕಾರ್ಡ್ ಬ್ಯಾಂಕ್ಗಳ ಹಂತದಲ್ಲಿ ನೇಮಕಾತಿ ನಿಯಮಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿ ನ್ಯಾಯಾಲಯದ ತಡೆಯಾಜ್ಞೆ ತಂದು ಸೇವೆಯನ್ನು ಮುಂದುವರಿಯುತ್ತಾರೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಉಮಾದೇವಿ ಇದರಂತೆ ಅನ್ವಯ ಪರಿಗಣಿಸಲಾಗಿದೆ. ಖಾಲಿ ಅನುಮೋದನೆ ಹುದ್ದೆಗಳು ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಈ ನೌಕರರು ವಿದ್ಯಾರ್ಹತೆಯು ಸಿಸಿ ನೇಮಕಾತಿ ನಿಯಮಗಳಿಗೆ ಅನುಗುಣವಾಗಿ ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಪಿಕಾರ್ಡ್ ಬ್ಯಾಂಕ್ ಸಾಮಾನ್ಯ ನಿಯಮ ಸಕ್ರಮಗೊಳಿಸಲು ಸಮರ್ಥನೆಗಳು ಮತ್ತೆ ಅವಕಾಶಗಳು ಇರುವುದಿಲ್ಲ. There are so many vacant posts right now.
We are not on that. Daily wages welfare act.
Daily wages welfare.
Daily wages welfare act. Is it 10 years before 2006?
Yes, sir. 1/4/2006, I think it's a cutout.
If they are continued in service, can be given the benefit.
Pardon me?
If they are continued in service from 1993 and onwards,
ಅದೇ ಒಬ್ಬರಿಗೆ ಆಗಿದೆ ಫಸ್ಟ್
I think
ಪೆಟಿಷನರ್
petition number 3 ಆಗುತ್ತಲ್ಲ.
ಅದೊಂದು ನೋಟ್
Petition number 3 has joined service in 1993.
ಅಲ್ಲಿ ವೆರಿಫೈ.
KCSR ಇರಲ್ರಿ, ಅದು ಬೇರೆ ರೂಲ್ಸ್ ಇರುತ್ತೆ. Daily wages.
Karnataka Daily Wages Employees Welfare.
Karnataka Daily Wages Employees Welfare Act 2012. ಓದಿ. 2012 act put, yes, Mr. Ten years as on 10th of
Tenth
April
of April 2006.
ಆಗಿದೆಯಲ್ಲ
Let me verify.
93, 2003,
Petition number 3 one verify.
98.
1993. As per the certificate issued.
ಕಸ್ಪಲ್ ಇದ್ರೆ ಏನ್ ಮಾಡೋದು 11/6/96 2 ತಿಂಗಳು ಶಾರ್ಟ್
11/6/96.
ಅಲ್ಲ ಫಸ್ಟ್ ಪಿಟಿಷನ್ ಇಸ್ 11/6.
First petition ಆಗಿದೆ sir. Order is passed. That annexure,
First petitioner, what order is passed?
Her services is protected under this act. 60 years of
As per
services.
this act, our services protected.
What about petition number 2?
Petition number 2, I think, my lord, he is not entitled.
Or he is not entitled.
He is not entitled.
What about
Petition number 3, my lord, let me verify. with the
yes.
authority.
ಅಷ್ಟೇನಾ?
And kindly go through the para number 6 of this judgment.
ಯಾವುದು? This judgment.
ಹೌದು.
ಆಯ್ತು ಓದಿ. What are the facts of this case?
Regularization of employment, change in the nature of employment through the continuous service. Para number 6. The application of the judgment in the Uma Devi case by the High Court do not fit squarely with the facts at hand. Given the specific circumstances under which the applicants were employed and have continued their service, the reliance on procedural formalities at the outset cannot be used to the perpetually denied substantive rights that have occurred over the considerable period of through continuous service. Their promotion was based on the specific, that is in respect of the judgment of Supreme Uma Devi also distinguished between the irregular and illegal appointment, underscoring the importance of considering the certain appointments, even if they are made strictly in accordance with the prescribed rules and procedure, cannot be said to have been made illegally if they have followed the procedures of regular appointment, such as conduct so and so. On the aspect of the above clarified, there may be cases where irregular appointments so and so if they have worked for more than 25 years, their cases has to be considered on the head.
ಎಲ್ಲಿದೆ ಹಂಗಂತ? Where do we find that? See, you've been filing litigations from the year 1998. In 1998, you had not completed 10 years.
1990.
1998 ಅಲ್ಲಿ writ petition ಹಾಕಿದ್ರಲ್ಲ sir. Please come to the annexure A ಬಂದು. Petitioners 1 and 2 herein have filed page number internal page 5 ಬಂದು. Internal page 5, ink page 13 of the writ petition.
29225 to
29225 and 226 of 1998.
Yes.
Petitions 1 and 2. Ganapati and Kamaraj.
Yes. For cameras, they have regular.
Ganapati came in 1993. Then his services were sought to be terminated. You came to this court in 1998.
Yes.
His service was protected by an interim order. Thereafter, this court directed the consideration of his request. Then again, it was rejected. You came before this court in 2009. Again, it was protected. Then again, they passed the impugned order. Where's the question of granting you the regularization?
The recent decision is more than 25 years.
Sir, that is a different, the judgment that you relied upon.
Yes.
The court has said that there's a regular process of interview. There's a regular process of filing applications. The candidates were interviewed, they were selected. So the court has said you can't ignore these facts while considering but the court has not diluted para 53 of the judgment of the Supreme Court in Umadevi.
Yes, sir. Yes.
Ashte, you're only entitled to the relief as submitted by the other side. Manjunath Swami ಏನು ಬರಲ್ವಾ?
ಅವ್ರಿಗೆ ಬರಲ್ಲ ಸರ್.
Huh?
ಅವ್ರು 1998 ಅಲ್ಲಿ
Any amendments to this 2012 notification extending that?
ಆಗಿಲ್ಲ ಸರ್.
ಏನ್ ಮಾಡಿದಾರ? ಮತ್ ಇವ್ರಿಗೆ ಹೆಂಗ್ ಕೊಟ್ರಿ ಸರ್ವಮಂಗಳಗೆ?
ಸರ್ವಮಂಗಳ she joined my lord
on 11/6/96.
11/6/1990.
So April 2006 ಗೆ 10 years ಆಗ್ಲಿಲ್ವಲ್ಲ? Who did you grant the benefit to her?
The order, my lord, is at page 21. Page 21 of my objections.
Yes.
Similarly, the name of my lord, petition number 1 is figured at serial number 42, my lord, page 24.
And date of entry into service ಕೊಡ್ಲಿಲ್ಲ ನೀವಲ್ಲಿ.
Then they are not mentioned.
Will direct you to extend the same benefit because you say that you have given the benefit to petition number 1. Though she had not completed 10 years as on 2006 April, we'll grant the benefit to petition number 2 also.
Petition number 2, 1998. He joined 19.
Correct, but ಅವ್ರಿಗೆ ಹೆಂಗ್ ಕೊಟ್ರಿ? ಇಷ್ಟು ವರ್ಷ ಇದರಲ್ಲ, still is working.
Act ಅಲ್ಲಿ ಅವರಿಗೆ ಎಲಿಜಿಬಿಲಿಟಿ ಬರೋದು.
Whether ಅಷ್ಟೇನಾ? ಬರ್ಕೊಡಿ. The petitioners are before this court challenging an order dated 24/9/2012 passed by the respondent number 1, refusing to regularize the services of the petitioners.
This respondent number 2 also.
Respond 1. Respond number 1.
Respondent 2, member secretary, common category.
Respond number 1 alla.
Respondent 1 is registrar of cooperative society.
Who has passed the impugned order?
Respondent number 2, my lord.
Respondent
number 2, member secretary, common category committee.
Respond number 2. Refusing to regularize the services of the petitioners. The petitioners have also sought for a writ in the nature of mandamus to direct the respondent number 2 to regularize their services from the date of their entry into service and to pay all consequential benefits. Full stop. Next para. The petitioners contend that they're all working at the respondent number 3 and have more than 10 to 20 years experience. They contend that they made several representations to the respondents to regularize their service. However, the same was not considered and the petitioners, having no other option, filed WP number 5857-5861 of 2001 before this court. They said writ petition was disposed of with a direction to ಏನ್ ಮೇಡಮ್ ಮತ್ತೆ ಮೇಲ್ ಹೇಳಿ ಅಲ್ಲಲ್ಲ ಅದ್ ಮೇಲೆ ಹೋಗಿ 5857 ಮುಂಚೆ ಹೇಳಿ. The petitioners made several representations to the respondents to regularize their services. However, the respondent number 3 issued an endorsement dated 31/1/2001 terminating the services of the petitioners, which was challenged in WP number 5857-5861 of 2001. Full stop. This court, in terms of the order dated 12th of April 2005, allowed the writ petition in part and set aside the order dated 31/1/2001 insofar as it related to the termination of the services of the petitioners, and remitted the case before the third respondent for reconsideration of the case after obtaining a consolidated report regarding appointment of the petitioners, and thereafter to forward it to the second respondent therein to take a final decision in accordance with the relevant regulation. This court also directed the common cadre authority to proceed only in accordance with law after affording an opportunity to the petitioners therein and the society before taking any decision. Full stop. The respondents thereafter, the respondent number 3 thereafter regularized one of the services of regularized the services of one of the employee by name GN Kamaraja, but refused to regularize the services of the petitioners. Aggrieved by the said order, by the said action on the part of the respondents, the petitioners filed WP number 1299-1301 of 2009. Full stop. A coordinate bench of this court, in terms of the order dated 20th of June 2012, allowed the petition and set aside the order refusing to regularize the services of the petitioners and remitted the case back to the respondent number 2 herein to reconsider the case of the petitioners in accordance with law. After such remand, the respondent number 2 held proceedings and, in terms of the impugned order dated 24/9/2012, rejected the request of the petitioners on the ground that the petitioners had continued in service based on interim orders granted from the courts, interim orders granted by the courts from time to time, and that in view of the judgment of the apex court in the case of State of Secretary versus State of Karnataka and others, Karnataka, Secretary State of Karnataka and others versus Uma Devi and others, year 2006, Karnataka 1806. Prohibited the regularization of employees who had continued in service based on interim orders granted by the court. Full stop. The petitioners, being agreed with the said order has filed this writ petition. The learned counsel for the petitioners contend that the petitioners have put in more than 20 years of service and therefore they are entitled to be regularized. He contends that there is enough vacancy in the respondent number 3 and respondent number 3, and that the services of the and vacancy in the respondent number 3, and that there is sufficient workload in the respondent number 3 to justify the regularization of the services of the petitioners. He contends that the apex court in the case of ML Kesari has considered the distinction between irregular and illegal appointments and has held that those appointments which are irregular and if those appointments has held that those employees whose appointments were those employees would put in 10 years or more and whose appointments were not regular are entitled to be considered for regularization. He therefore contends that the petitioners who have put in more than 20 years and who are regularly recruited by the respondent number 3 are entitled to be considered for regularization. In support of his contention, he relied upon the judgment in the case of Vinod Kumar and others versus Union of India and others 2024 live law SC 330. Full stop. Next, by the learned counsel for the respondent number 3,
2 minutes.
Respondent number 2 submitted that the case of Kamraj was submitted that a common cadre authority was constituted contended the respondent number 2 has filed a statement of objection and has contended that it came into existence with effect from 31/10/1992 and from then on it was the only competent authority to recruit employees for P card banks, including the respondent number 3. Full stop. It contended that the petitioners were casual employees appointed by the respondent number 3, contrary to the provisions envisaged under the Common Cadre Committee regulations. It is claimed that the petitioner was appointed by the respondent number 3 on 11/6/1996 as a typist/clerk, while petitioner number 2 was appointed by the respondent number 3 on 9/9/1998 as clerk, and petitioner number 3 was appointed as peon on 1/4/1993. Therefore, the respondent number 2 contends that the appointment of the petitioners was not through the common cadre was not through the respondent number 2, but was directly by the respondent number 3, and hence was contrary to the regulations framed. Full stop. Full stop. It is further contended that the Deputy Registrar of Cooperative Society, Shumaga, had issued a communication dated 31/1/2001, directing the respondent number 3 to terminate the services of the petitioners 1 to 3 and 2 others, failing which disqualification proceedings would be initiated under Section 29C of the KCS Act 1959 against the Board of Directors of the respondent number 3. Feeling aggrieved by the said communication, the petitioners and others filed WP number 5857-5861 of 2001. And this court, in terms of the order dated 12/4/2005, set aside the communication dated 31/1/2001 insofar as it related to termination of the service of the petitioners and remitted the case back to the respondent number 3 for reconsideration after obtaining a consolidated report from the respondent number 3 bank, respondent number 3, and thereafter forwarded to the respondent number 2 to take suitable decision. So after such remand, the respondent number 2 examined the case of the petitioners, and since one of them, namely Mr. G.N. Kantraj, was appointed prior to the constitution of the Common Cadre Committee, his services were regularized by an order dated 2/2/2008. However, as the petitioners were appointed directly by the respondent number 3, contrary to the regulations, which was contrary to the regulations, the respondent number 2 refused to regularize the services of the petitioners. Full stop. The petitioners thereafter challenged the order dated 27/12/2008 before this court in WP number 1299-1301 of 2009. On the ground that Mr. K.N. Kamraj was regularized, though his appointment was subsequent to 31/10/1992. Full stop. It is contended that this court lowered the writ petition and quashed the order dated 27/12/2008 and remitted the case back to the respondent number 2 for fresh consideration. The respondent number 2, after considering the case of the petitioners, has passed the impugned order, refusing to regularize the services of the petitioners as they were all continued on the basis of interim orders granted by the courts in the aforementioned writ petitions, and their appointments were all illegal. Full stop. The respondent number 2 therefore contends that the petitioners are not entitled to the benefit of regularization.
Sorry, madam, and they do not possess a required qualification.
As they did not possess the required qualification. Full stop. Next, I have considered submissions made by the learned counsel for the petitioner as well as the learned counsel for the respondent number 2. The learned counsel for the petitioner did not dispute the fact that the petitioner number 1 was appointed on 11/6/1996, petitioner number 2 on 9/9/1998, and petitioner number 3 on 1/4/1993. He also did not dispute the fact that the petitioner number 3 had filed WP number 29225-226/1998, challenging an order dated 31/8/1998, ordering removal of his services. He also did not dispute the fact that in the said writ petition, the services of the petitioner was, petition number 3 was protected by way of an interim order. Full stop. The learned counsel further did not dispute the fact that the services of the petitioners 1 and 2 was also ಇವರೇ ಬೇರೆ ಹಾಕಿಲ್ವ ರಿಟ್ ಪಿಟಿಷನ್ ಇವರು 1 and 2 apart from this
ಇನ್ನು ಒಬ್ಬರು
1299 ಬಿಟ್ಟು ಬೇರೆ ಯಾವ್ದು ಹಾಕಿಲ್ಲ.
ಇನ್ನೊಬ್ರು ರಾಜೇಂದ್ರ ಅಂತ ಹಾಕಿದ್ರು, he quit the service.
ಏನ್ ಮೇಡಮ್ ಆಯ್ತು? Continued based on interim order granted in WP number 1299-1301 of 2009. Full stop. If the recruitment to the recruitment to Primary Cooperative Agricultural and Rural Development Bank had to be done by the respondent number 2 as per the regulations framed, the petitioners who did not possess the required qualification and who were directly recruited by the petition respondent number 3, their appointment cannot be treated as irregular, but were illegal in as much as no recruitment notification was issued, no interview was conducted, and no roster policy was adopted while selecting the petitioners. Besides this, the petitioners did not possess the requisite qualification. Therefore, the petitioners cannot contend that their appointments were irregular and that they were entitled to be regularized. Be that as it may, since the services of the petitioners are continued under various interim orders granted by the court, the petitioners are not entitled to the benefit of regularization as held by the apex court in the case of Uma Devi versus so-and-so. Secretary versus Uma Devi, 2006, so-and-so, so-and-so. Therefore, the order passed by the respondent number 2 cannot be challenged as the petitioners were not vested with any right to seek for regularization of service. Full stop. Next para. It is seen that it is seen from the statement of objections filed by the respondent number 2 that the respondent number 3 has extended the benefit of the Karnataka Daily Wage Employees Welfare Act 2002 and has granted the benefits, granted the pay, leave and terminal benefits as provided under section 4 of the act to the petition number 3 as well as the petition number 1 and the petition number 3.
ಇಲ್ಲ petition number 1 ಒಬ್ಬರಿಗೆ
Only one. ಗಣಪತಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತಂದ್ರಲ್ಲ.
ಇಲ್ಲ petition number 1 ಒಬ್ಬರಿಗೆ ಸರ್ವಮಂಗಳ.
ಗಣಪತಿ ಕೊಡ್ಬೇಕಲ್ಲ.
ಗಣಪತಿ ಕೊಟ್ಟಿಲ್ಲ ಅದನ್ನ.
Only petition number 1.
Petition number.
To the petition number 1. However, since the petition number 3 has also completed 10 years of service as on 10th of April 2006, there is no reason why the benefit of the Act of 2002 should not be extended to him as well. The petition number 2, who entered service only on 9/9/1998, did not complete 10 years as on 10th of April 2006 and therefore is not entitled to the benefit of the Act of 2012. In that view of the matter, this writ petition is disposed of, upholding the order passed by the respondent number 2. However, the petitioner number 1, petition number 3, however, the respondent number 3 is directed to extend all benefits to the petition number 3 as provided under section 4 of the Act of 2012. The same shall be considered within a period of 3 months from the date of receipt of a copy of this order.
Petition number 2.
2 ಬರಲ್ವಲ್ಲ.
I extend ಮಾಡಿ.
Please ನೋಡ್ಕೊಂಬನ್ನಿ ಸರ್, ಏನೋ ನೋಡಿ ಇದು ಆಕ್ಟ್ ಕೊಡಿ ಅವ್ರಿಗೆ, ಕೊಡಿ ಅವ್ರಿಗೆ. ಸ್ವಲ್ಪ ನೋಡ್ಬಿಡಿ, ಬರಂಗಿದ್ರೆ ಕೊಡಕ್ಕೆ ನಂದೇನಾಗ. There is nothing for me to lose. If I am entitled to get it, you will get it. Yes, next.
The same benefit has to be extended to similarly placed employees.
Huh?
The same benefit has to be.
No, we can't cover them. Whoever is not there before the court, we can't give the benefit to them. Yes, next.
Ravi HK.
Huh? 25. MR Shailendra. Ravi HK.
The matter pertains to recruitment to the post of assistant engineers at BWSSB, my lord. In the year 2008, the respondent number 1 invited applications for filling up the posts of assistant engineers.
2008, huh?
2008. The notification is dated 22/8/2008. In all, there were 78 posts available, my lord.
Yes.
The petitioners herein applied. Subsequently, my lord, the respondent number 1 formulated a selection list. While formulating the selection list, the respondents failed to comply with the regulations which govern the formulation of the list. As per the said regulations, 2 lists were to be formed. The main list and the marginal list of 30%. And two lists have to be consolidated, and that consolidated list will have to be put in operation. Since the said exercise was not undertaken, one of the applicants, namely Shilpa, filed a writ petition before this honorable court.
Yes.
In the said writ petition, my lord, a direction was issued for formulation of a marginal list and later formulating a consolidated list and later put it in operation.
Yes.
Kindly see the direction that was issued by this honorable court, which is produced by Annexure C, my lord. The order commences at page number 53. The operative portion is at page 73. The respondent BWSSB is directed to prepare and publish the first consolidated list as contemplated by Regulation 8 to include the names of candidates falling within 30% margin of number of existing vacancies to be filled up forthwith. The respondent is directed to operate that list for filling up of vacancies strictly in accordance with Regulation 8 and in accordance with observations made supra in respect of selection to the post of junior assistant. If after operating the list, there are vacancies to be filled up, to consider the case of the petitioner for filling up of such vacancy in accordance with regulations.
Hey, let us see the regulations relating to this
Lord,
marginal list.
Yes, my lord. The regulations, the relevant regulation is at page number 45, my lord.
45.
45. Serial number 14, my lord. Preparation of approved list of candidate and candidate found suitable. The selection recruitment committee shall.
Please wait. Where do I get this?
Page number 48, my lord.
48.
Sorry, 45, my lord. I'm sorry, 45.
45, 14 ilvalla illi.
My lord, the regulation is produced by Annexure B, my lord, commencing from page number 39. Internal page
Correct.
number 8.
I have the regulations.
Yes, my lord. Internal page number 8, my lord. 8.
14.
14, my lord. Preparation of approved list of candidate found suitable. The selection recruitment committee shall, after interviewing the candidates, select those who are found suitable for appointment and shall prepare a first consolidated list, irrespective of class to which they belong, arranging them in order of merit, keeping in view of the number of existing vacancies to be filled with a margin of 30%.
Please read it again.
The selection recruitment committee shall, after interviewing the candidates, select those who are found suitable for appointment and shall prepare a first consolidated list, irrespective of class to which they belong, arranging them in the order of merit, keeping in view the number of existing vacancies to be filled with a margin of 30%.
So the first list will be based on the merit, irrespective of which caste, creed, no reservation, nothing. Yes.
Then point B, my lord. The committee will then prepare from out of the first list, separate list containing the names of the candidate found suitable and equal to the number of posts to be filled by various categories of reservation candidates, namely SC, ST, etc., by arranging them in the order of merit.
Yes.
The third point, the list finally settled by conforming to clauses A and B above shall constitute the list of candidates finally selected for appointment to any particular category of the board service for which the selection is made. So these were the prescription of the regulations.
Yes.
Therefore, my lord, this honorable court directed them to follow these regulations.
Where is the marginal list? Where is the provision for marginal list?
My lord, the first clause itself prescribed for the marginal list, my lord, 30%.
Keeping in number of 30%.
30.
Yes. Keeping in view the number of existing vacancies to be filled with a margin of 30%.
30%. Out of the total vacancies, my lord, 30% margin has to be taken into account, and a separate list was required to be
So
formulated.
there's 100 posts, 130
total number of
candidates.
78, my lord.
So suppose if there are 100 posts, it should be 130 candidates who are to be shortlisted.
Yes. And then the consolidated list will have to be put in operation. However, my lord, BWSSB had not prepared the marginal list, therefore direction came to be issued. After the direction came to be issued, my lord, a consolidated list came to be formed with a marginal list being merged into the main list.
Yes.
In the said consolidated list, the names of the petitioners figured. Later, the selection committee shortlisted the eligible candidates, and out of the selected candidates, certain candidates did not report and certain candidates did not give their consent. Again, there were certain vacancies. And during the process of filling those vacancies, instead of selecting the candidates from both the main list as well as the marginal list, they only confined to the main list and said that the roster points that are available in the main list have been completely exhausted. And therefore, there is no vacancy available for the roster point to which you belong. Therefore, the said vacancies cannot be filled by giving you appointment. So they took this stand and gave an endorsement. The said endorsement has been questioned before this honorable. My respectful submission is, as per the directions of this honorable court, the vacancies, if any, available has to be considered from the consolidated list and not just from the main list. And the direction also says that consolidated list will have to be put in operation.
Yes.
So they just chose vacancies from the main list and said that there are no roster points available to enable us to give you appointments and fill the vacancies. So that is the error committed by the BWSSB.
Yes.
Therefore, the said endorsement have been questioned before this honorable court and directions have been sought
What
to
is it?
consider the
Is
case.
there
of the
any
petition.
interim order granted?
Lord, there is no
No,
interim
yeah.
order. No interim.
Then what will be the effect?
Lord, the lapse, if any, is purely attributable to the BWSSB.
See, all those who have been recruited have been in service for more than 12 years.
My lord, I'm not seeking to disturb those appointed, my lord, but my instructions are, there are still several vacancies available.
That is okay. Several vacancies, there will be one more round of recruitment.
Yes, my lord,
You
but this is
can't-
a lapse that is committed by BWSSB itself. And they have not complied with the directions of this honorable court.
No, this recruitment, you can't ask for a placement in another, against another vacancy. ಈ recruitment ಎಷ್ಟಿದೆ, if the recruitment process is complete, ಏನ್ ಮಾಡೋದು?
My lord, even after the completion, there were vacancies, my lord. Therefore, it should have been automatic selection of the petitioners. Still, they didn't do, my lord. Therefore, what I request is the other side may be directed to consider the case of the petitioners to
For
fill in the
what?
vacancies.
For what?
Because of the lapse committed by them in complying with the directions of this honorable court as well as the regulations.
I think, I don't know whether you're entitled for some any age relaxation. You're, I think, overaged.
My lord, even the selected candidates have not been made as parties. Only on that ground itself, my lord, this honorable court can.
My lord, the selection
Secondly,
list
my
has
lord,
not been questioned, my lord. The selection list has not been
What
questioned.
is, see, ultimately, somebody has to give way for you.
My lord, the vacancies are there, my lord. Since there are
Right,
vacancies
see, you
available.
are claiming under 2A and 3B.
Yes.
So you have to find out whether there was any candidate who was lesser meritorious than you who was selected.
Yes, my
And
lord,
you
that
should
is
have
the
made
ground.
them as parties.
4 candidates from 2A were selected. All of them reported. He was in the reserve. Now he says, the other groups, let me be accommodated, which cannot be done. My lord.
My lord, that is the error that is being committed by them. They are saying that there are no vacancies by considering only the main list. However, if a consolidated list is considered, vacancies are there in respect of my respective roster points.
ಇವಾಗ ಎಲ್ಲಿರುತ್ತೆ vacancies? It would have already been exhausted
As on
long
today
back.
also, my lord, there are
No,
vacancies.
correct, ನೀವು delay ಮಾಡ್ಕೊಂಡ್ರಿ. You should have done some, taken some
I think the
immediate steps
first
to.
candidate has withdrawn already. The second candidate is already a government servant.
First candidate is already withdrawn the
Then
petition.
he left out.
My lord, I represent the first petition.
Say, second one.
Second
Second has
petition
already been out. Yes, my lord. First one is also working, my lord. He is also a government servant.
ಮತ್ತೆ ಇನ್ನೇನಿದೆ? ಬರ್ಕೊಳ್ಳಿ. I thought there's some big issue in this.
ಇಲ್ಲ.
The petitioner sought for it in the nature of certiorari right to set aside an endorsement dated 24/9/2012 and 24/9/2012 at annexure L and M issued by the respondent number 1. The petitioners have also sought for a writ in the nature of mandamus directing the respondent to include the name of the petitioners in the second final select list published on 16/9/2011 and issue appropriate appointment orders to the petitioners. Next para. The petitioners, next para, the petition number 1 had applied against a notification dated 22/2/2008 published by the respondent number 1, inviting applications for eligible candidates for the post of Assistant Engineer Civil. Full stop. Post, 78 posts of Assistant Engineer Civil. The petitioner number 1 contends that the respondent number 1 did not comply with the Cadre Recruitment and Promotion Rules 1981. In selecting the candidates, full stop. The petitioner number 1 contends that one of the aggrieved candidates filed WP number 22937 of 2010 before this court. And this court, in terms of the order dated 5th of October 2010, disposed of the writ petition directing the respondent number 1 to prepare and publish a consolidated list as contemplated under Regulation 8 small Roman 14 brackets small a to include the names of the candidates falling within 30% margin of the number of existing vacancies to be filled up, and thereafter operate the list for filling up vacancies strictly in accordance with the Regulation 8 bracket small Romans 14. Full stop. The petitioner contends, petition number 1 contends that even after a direction was issued by this court, the petitioner, the candidature of the petitioner was not considered, and the respondent number 1 has issued the impugned endorsement stating that all the posts were exhausted. Full stop. The petitioner number 1 is therefore before this court. The learned counsel for the petitioner submits that when this court had directly had directed the respondent number 1 to prepare 2 separate lists as provided under the regulations, provided under Regulation 8 small Roman 14 bracket A of the recruitment regulations of the respondent number 1, the respondent number 1 could not have operated the list prepared by it without preparing the consolidated list. Full stop. He therefore contends that the petition number 1 is deprived of an opportunity and hence prays that the impugned endorsement issued by the respondent number 1 be set at naught, and the petitioner and the respondent number 1 be directed to recruit the petitioner against any vacant post of assistant engineers. Per contra, the learned counsel for the respondent number 1 and 2 submits that the writ petition is not maintainable as the petitioner number 1 has not arrayed selected candidates as respondents in this petition. He submits that all the 78 posts that were notified were filled up from the list prepared by the respondent number 1, And therefore, any order that may be passed in this petition would affect the candidates who are recruited by the respondent number one. He therefore contends that no indulgence can be shown to the petitioner, petition number one in this writ petition. Besides this, he submits that the list that was prepared by the petitioner was operated and all the posts and all the notified posts were filled up, and therefore there are no posts available to entertain the request of the petition number one. Next para. Full stop. He also contends that the petition number two has withdrawn from the fray as he has landed a job with the state government. Full stop.
Even
Next
the
para.
first petitioner, I
Uh-huh.
think, even the first petitioner is working in the state government.
That a fact.
That is what I heard.
He also submits that the petition number one has gained employment in the with the state government, and therefore there's no need to consider the request made by the petitioners. Next para. The petitioner, this petition is liable to be rejected on the short ground that the selected candidates are not arrayed as party respondents in this petition. The relief sought for by the petitioners shows that the petitioners have sought for a direction to the respondent number one to recruit them against vacant posts. In view of the contention of the learned counsel for the respondents that all the posts notified were filled up by operating the list, no indulgence can be shown to the petitioners in this writ petition. Hence, the petition is dismissed.
Serial number 26. This Srikanth.
Lords was heard. What my lords, the librarian my lords was secured appointment my lords.
Yeah, what is this case about?
How my lords, the appointment was made, subsequently he acquired. my
Iದೇನು
lords,
settlement ಅಂತೇನೋ ಅಂದ್ರಲ್ಲ?
ಅಲ್ಲ ತಾವರು ಇಗ್ನೋ ಡಿಗ್ರಿ ಬಗ್ಗೆ ಕೇಳಿದ್ರು. ಇಗ್ನೋ
Acceptable one.
ಕೊಡಿ.
And the official also present.
And even this man has retired from service.
About
to 11th.
when-
2012 is 48 years. Now
50
he's
years.
60.
About 60 years. Otherwise, they have to give the monetary benefit. Fact that I have worked, not appointed, approved without aid, they have to approve from that date only. It cannot be.
Yeah, what is the order which is challenged?
Lords, the order, my lord says, if you lords kindly come to my lords, the page number 52. They say that my lord, they go by the strength, my lords, as
ಸರ್ಕಾರದ ದಿನಾಂಕ
2000 ಆದೇಶ ಅಂತ ಹೇಳ್ತಾರೆ. ಅಪಾಯಿಂಟ್ಮೆಂಟ್ 89 95 ವಿತೌಟ್ ಅಪ್ರೂವಲ್ ಆಗೋಗಿದೆ.
2000 ಆದೇಶದಲ್ಲಿನ ಮಾರ್ಗಸೂಚಿಗಳಂತೆ ಸದರಿ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜಿನಲ್ಲಿ ಕಳೆದ 5 ವರ್ಷಗಳ ವಿದ್ಯಾರ್ಥಿಗಳ ಕನಿಷ್ಠ ಈ ಕೇಸ್. ಓಕೆ.
In fact, notes 89 I was appointed, 94 notes approved without aid.
ಬರ್ಕೊಳ್ಳಿ.
Presence may be marked. Official presence.
ಆಯ್ತಾಯ್ತು. ಏನು ಅವ್ರ ಹೆಸರು ತಿಳ್ಕೊಳ್ಳಿ. The petitioner has challenged the correctness of an order dated 25/8/2012 passed by the respondent number 2 in number accommodate bearing number so and so dated so and so passed by respondent number 2, by which the respondent number 2 refused to approve the appointment of the petitioner. The petitioner has also sought for a direction to the respondent number 2 to approve his appointment.
That is approval with aid, my lords.
Approval with aid. Approve the appointment of the petitioner with aid. And consequentially to grant all reliefs to which the petitioner is entitled to. Next para. The petitioner was appointed with effect from 30/10/1995 by the respondent number 4. For the post of librarian, for the post of librarian. It was alleged that the petitioner it is contended that though the petitioner did not possess the required qualification of a bachelor in library and information science at the time of his appointment, he acquired it during the year 1993. Full stop. The respondent number 2, in terms of a communication dated 14/10/1998, addressed to the respondent number 4, informed that the petitioner did not possess the requisite qualification at the time of his appointment as a librarian, and therefore his appointment cannot be approved. Full stop. The respondent number 4 then represented to the respondent number 2 that similarly placed candidates who did not possess the requisite qualification as on the date of their appointment and who had acquired the qualification were approved. The respondent number 4 therefore requested the respondent number 2 to approve this appointment of the petitioner with salary grant. Full stop. The petitioner contends that insofar as those candidates who did not possess the requisite qualification as on the date of their appointment and whose appointments were approved, a relaxation was provided that such candidates could acquire the prescribed qualification within 3 years from the date of the order. Full stop. The petitioner contends that he was also entitled to the said benefit. As the same was not extended to the petitioner, he preferred an appeal before the respondent number 1 in appeal number 330 of 1998. Full stop. The respondent number 1 disposed of the appeal in terms of an order dated 1/4/2002 to consider the case of the petitioner. Full stop.
That was rejected. my lord.
Huh?
That was rejected. my lords. Appeal was rejected. Page number 20.
Disposed of antigala. Page number para number 6.
That is.
Said appeal came to be
Says
disposed
disposed of accordingly, but holding that I am not entitled for.
disposed of by an order dated 1/4/2002. Annexure H.
That is, yes, my lords. Page number 27. They say when the economy measure is lifted, they can consider the request of the petitioner is therefore dismissed.
Disposed of, directing the respondent number 2 to consider the case of the petitioner. What is this? Economy order is lifted and the
Economy measures, my lords, will be there in place. Say that
case of
because
the petitioner.
economic constraint, they will not be in a position to approve the appointment.
Case of the petitioner, when the financial health of the respondent number 4 of the state.
government, State.
When the financial health of the respondent number 1 had improved. Full stop. The respondent number 5 represented to the respondent number 2 to approve the appointment of the petitioner with salary grant. This was escalated by the petitioner before the respondent number 2, as the state government had lifted economic measures. Full stop. The respondent number 4 again on 6/5/2002 submitted a representation to the respondent number 2.
Your lordships can
ಇವೆಲ್ಲ ಇಷ್ಟೊಂದೆಲ್ಲ ಎಂತದ್ರಿ ಇದು? ಏನಾಯ್ತು?
next year cube ತಾ ಬರ್ಬೋದು.
No, these are unwarranted, unnecessary.
ಅಲ್ಲ, we had been making ಅಂತ ತೋರ್ಸ. next year
Re-
cube ಗೆ your lordship can.
ಏನ್ ಮಾಡಮಾಯ್ತು? This followed by various other similar representations, which ultimately came to be, in respect of which, the petitioner filed WP number 27929 of 2011, which was disposed of in terms of an order dated 22/2/2012, directing the respondent number 2 to consider the matter afresh. Full stop. The petitioner then filed a representation dated 16/3/2012 and also got a notice issued to the respondents on 16/3/2012, calling upon them to comply. The order passed in WP number 27929 of 2011. Full stop. The respondent number 2 then issued the order dated 25/8/2012, rejecting the proposal sent by the respondent number 4 on the ground that there were not, on the ground that sufficient number of students had not taken admission, had not taken the examination of secondary and pre-university course in the respondent number 4. Full stop. The petitioner contends that his appointment was in the year 1989, 89, and therefore 89, which was approved by the respondent number 1 on
Without aid, my lords.
approved by the respondent number without aid on 18/7/1996. Sorry, 4/1/1996. ಇಲ್ಲ, ಯಾವತ್ತು ನಿಮ್ದು ಅಪ್ರೂವ್ ಆಗಿತ್ತು? ಅಲ್ಲ, 31/10/1995. And therefore, the endorsement related, therefore, therefore the government order dated 27/11/2000 prescribing guidelines was not applicable to him. Full stop. Next, the learned counsel for the petitioner reiterated the above contentions and claimed that the petitioner, having acquired the requisite qualification and he having attained the age of superannuation, requisite qualification, his appointment was entitled to be approved with salary grant, as was done in the case of several others who were permitted to acquire additional qualification after their appointments were admitted to salary grant. Full stop. When this writ petition was listed for final hearing, a doubt arose in the mind of the court as to whether the Bachelor of Library Science acquired by the petitioner for from the Indira Gandhi Open University was recognized by the respondent number 2. This court directed the additional government advocate to secure instructions from the respondent number 2. Full stop. An official from the office of the respondent number 2 named Mr. Puttalingappa, a first division assistant, has furnished a declaration dated 9/8/2024, stating that the degrees offered by IGNO is recognized by the respondent number 2 for the purpose of admitting the petitioner for salary grant. Full stop. Next para. As rightly contended by learned counsel for the petitioner, once his appointment was approved by the respondent number 1, and when similarly situated persons whose appointments were approved by the petitioner and admitted to salary grant were given the liberty to secure additional qualification within 3 years, the petitioner was also entitled to be treated alike. Full stop. The reliance placed by the respondent number 1 on the government order dated
Make sure you.
dated 27/11/2000 is inapplicable to the petitioner, as his appointment was approved way back in the year 2010.
1995.
1995, in the year 1995. In that way of the matter, the impugned endorsement issued by the respondent number 1 is quashed. The respondent number 2 is directed to take steps to admit, is quashed. Consequently, the appointment of the petitioner. Consequently, the respondent number 1 and 2 are directed to admit approve the appointment of the petitioner for salary grant with effect from ಯಾವತ್ತಿಂದ ಆಗುತ್ತೆ?
Could say not from the date of notes appointment, at least from the date of approval without gate.
ಅಲ್ಲಿಂದ ಹೆಂಗಾಗುತ್ತೆ? Whenever your other employees were admitted to grant, ಅದೇನು ತಗೋಬೇಕಷ್ಟೇ. ಏನಾಯ್ತು? Salary grant retrospectively from the date similarly situated appointees were admitted for salary grant.
Yes.
And grant all consequential benefits to the petitioner. Yes.
Kind permission.
Petition is allowed on it.
Kind permission ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಮೇಲೆ ಯಾವ್ದು ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ ಇದೆ ಪಕ್ಕದ ಕೋರ್ಟ್ ನಲ್ಲಿ 13th ತಗೊಳ್ತಾನೆ ದಯವಿಟ್ಟು ಶ್ರೀಕಾಂತ್ಗೂ ನಮಗೂ ಇರೋದು
ಯಾವ್ದು serial number 26
27 13th ಮೇಲೆ
2014 ಆಯ್ತು ಯಾವತ್ತು ಬೇಕೋ ತಗೊಳ್ಳಿ whichever date you want.
My lords. My lord, serial number 37, my lords.
29, sorry, Mr. 2012 matter, sorry.
My lords.
Allah, I think problem of you do whatever you want.
Next week.
27.
29.
No, that is what you, both of you decide that you get an adjournment. I mean, these are old matters with great difficulty. I get it posted.
They've amended the petition only now.
Huh?
They've amended the petition only 2 months back.
My lords.
ಯಾವತ್ತು ಬೇಕೋ ತಗೊಳ್ಳಿ.
My lords.
Please come.
Lord, serial number 30.
Please come at 2:30.
ತಗೊಳಕ್ ಬರಲ್ಲ ಸರ್. ಹೆಂಗ್ ಹೇಳಿದ್ರು ನೀವು ಸಾಹೇಬ್ರ ಮುಂದೆ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು ಅವ್ರು ತಗೊಂಡು ಅವ್ರು ತಗೊಂಡ್ರೆ ನಾವ್ ಹೆಂಗ್
ಇಬ್ರು ಇದು ಮಾಡಿದ್ರು ಯಾವ
8 ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ?
Hey, to come at 2:30 and the last 30.
Sir, 27.
27. Sir, 2:30 ಬಂದ ತಕ್ಷಣ ತಗೊಳ್ಳಿ. ಇವ್ರೆ 2:30 ಬಂದ ತಕ್ಷಣ ಹೇಳಿ.
Sir, 41 ಇದೆಯಲ್ವಾ?
ಇದೆ ಮೇಡಮ್.
Sir, 27 mention ಮಾಡಿ. 13
13. ಅದರ ಸರ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ವಿ.
ಹೇಳಿಲ್ಲ ಹಂಗೆ.
ಇಲ್ಲ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು.
30 ಒಂದ್ಸಲ ಬಂದು
ಇಲ್ಲ
ಹೇಳಿ.
ಅವ್ರಿಗೆಲ್ಲ ನಮ್ದು ಫಸ್ಟ್ ಆಗೋಗಿತ್ತು ಅದು. ನಮ್ದು 13th ಆಗೋಗಿತ್ತು.
ಎಲ್ಲ ಹೇಳಿದ್ರು 37 ವರ್ಗು ಹೇಳಿದ್ರು 31 ವರ್ಗು ಹೇಳಿದ್ರು ಆಮೇಲೆ ಕಮೆಂಟ್ 2:30 ಅಂದ್ರಲ್ವಾ ಕಮೆಂಟ್ 2:30.
ಹಾ.
ನೀವ್ ಹೇಳಿ ಡಿಸ್ಪೋಸ್ ಆಯ್ತಾ ನೋಡೋಣ ಇದು ಇವ್ರಿಗೆ ಹೇಳಿ ಅವ್ರಿಗೆ ಹೇಳಿ ಇವ್ರಿಗೆ ಹೇಳಿ ಈ ಕಡೆ ಬನ್ನಿ. ಅವ್ರು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್ ನಮ್ಗೇನ್ ಹೇಳಿಲ್ಲ ಸಾಹೇಬ್ರು. ಹೇಳಿದ್ನಲ್ಲಮ್ಮ ಅವ್ರಿಗೆ 2:30 ಬನ್ನಿ ಅಂತ. ಬನ್ನಿ ಇನ್ನೊಂದ್ಸಲ ಹೇಳಿ ಬಿಡಿ. ಅವಾಗ 27 ಕರೆದ್ರೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅವ್ರನ್ನ ಡೇಟ್ ಕೇಳ್ಬಿಟ್ಟು ಡೇಟ್ ಕೊಟ್ಬಿಡ್ತೀವಿ.
ಈಗ
ಏನ್ ಮೊನ್ನೆ ಬಜ್ಜಿ ತಿಂತಾರಲ್ಲಪ್ಪ ಯಪ್ಪ.
Court officer?
Court officer? Court officer? Court officer? Court officer?
ಸರ್ ಹೇಳಿ ಸರ್. ಸರ್ ಹೇಳಿ. ಹಲೋ.
ಸರ್ ಇದು ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಕೊಟ್ರಿ.
ಹೌದು ಸರಿ ಸರಿ ನೋಡಿ.
Serial number 37,
Ah,
they filed memo for withdrawal of the petition.
30?
37. Serve the copy, my lord.
Who has filed a memo for withdrawal?
Petition. We have filed.
You filed a memo for withdrawal.
Yes.
See number 37, the Learned Counsel for the petitioner has filed a memo to withdraw the petition. The memo is placed on record, is taken on record, and the petition is dismissed as within.
Please, oblige.
No. Correct. Correct. I will take
Defense
it.
matter for dictation, serial number 1.
Password ಅಂದ್ರೆ password ಯಾವ್ದು ಇದೆ? ಕರೆದು ಬಿಡಿ, ಒಂದು ನಿಮಿಷ password.
Password matter, list number 1, serial number 10.
Petitioner.
Pardon?
The facts of the case of this.
Password.
Facts of the case may I submit. my-
Please use the mic.
I'm sorry.
Ah.
My lord, this case, my lord, petitioner working since from 2009, my lord, as a science teacher in respondent number second institution, my lord. My lord, this honorable court has issued the notice, my lord, and kept it for disposal after hearing, my lord. Then the taken notice, the second respondent, Sridhar Prabhu, is taken a notice, my lord. After that, my lord, he submitted orally that he will not terminate from the services since his petitioner is a contract basis teacher, my lord. After that, my lord, 16/5/2024 order has been passed, my lord, not to continue the petitioner in the next academical year, my lord.
Where is
Hence, I
Sridhar
have filed the.
Prabhu? Where is Mr. Sridhar Prabhu?
Is it?
It's appearing for R2.
Yes.
Council is on his way. Apologies for the delay, my lords.
Who is the answering respondent?
Respondent number 2, Sridhar Prabhu, my lord. After hearing this matter, my lord, this honorable court has been allowed the application for direction, my lord, directed issued to the second respondent not to terminate the petition and continue with the services, my lord. That order placed on 8 July, my lord. After 1 month also, my lord, the interim order is not complied, my lord. And IFR 1 for the impleading application opinion by this honorable court to implead the UGC, my lord, I have impleaded, my lord.
So IA 2 of 24 is.
Is a impleading application
Already considered or not?
consider partly, my lord, is not showing that it's disposed of. On dated,
You
my
already
lord,
impleaded. So let us
I have
follow this
impleaded, my lord, 27/6/2024, my lord, order has been passed, my lord, second para. I number 2 of 24, impleading must be considered. So hence I have served the copy to the Anil Shauri, my lord.
I have
UGC
filed
panel
wakalat
advocate.
for UGC, my lord.
Okay, but even before the application is allowed, you have impleaded.
I have impleaded and amended also, my lord, that may be
2 of
disposed of.
24 is filed for impleading the University Grants Commission. Since
I appear for proposed respond, UGC.
why was University Grants Commission made a party?
My lord, this honorable court opinion that UGC have to answer for this, my lord, hence I have impleaded, my lord.
Really?
My lords, I think that B.Ed degree was done from a university, my lord. Its recognition was an issue. And that has been the ground for not considering for appointment, my lord.
Where you have got the BA degree?
No, sorry.
May I
Page
sub-
42, my lord, is.
UGC necessary party, one of you can tell
Yes,
me
my
how
lord, I will
it is.
submit. The issue is, my lord, page 42 relates to a judgment rendered by the apex court regarding the legal status, the university from where, my lord, my learned friend's client obtained the degree. Now UGC, my lord, has de-recognized it. Lordships may see this judgment, my lord.
So to that effect,
Before that, I'll.
Adike,
only for that limited purpose,
Yes.
UGC is made a
Yes.
party.
And then they submitted that the students who studied there have been relocated to other universities within the state. Now, what is the present status of that university was to be ascertained, whether the legal status
So then
remains
anyway-
same.
So then we'll allow this application.
Yes, ma'am.
14 is filed to impede the University Grants Commission to ascertain whether the university from where the petitioner had obtained the degree is still recognized by it or not.
Yes.
Full stop. In view of the fact that any order that may be passed would hinge on the question whether the degree obtained by the petitioner from an university which is recognized by the respondent, proposed respondent,
Number 6, ma'am.
is necessary. Then it's sentence ain't the sure.
Any order.
Hello, any order that may be passed would hinge on the question, or not. So therefore, IA 102 of 24 is allowed and the proposed respondent is ordered to be brought on record. Counsel for the petitioner is directed to amend the cost rate.
I already amended, I'm
Please
opposing.
change the date.
Please, ma'am.
What about this IA 3 of 24?
IA3, my lord, may I submit, my
If
lord?
there's an
ಇಲ್ಲ,
interim
ನಂದು
order,
ನಾನು ಇವತ್ತೇ ಹೇಳಿದ್ದೀನಿ ಸರ್. They have to, my lord, continue the contract employment. He was employed on contract basis.
when will you report the complaints of the order?
3 days may be given, my lord. I'll secure the. I have instructed them that immediately this
3
should
of
be done.
24 is filed by the petitioner seeking for a direction to the respondent number,
Respondent
2,
number.
my lord.
respondent number 2 to comply. The order dated 8/7/2024 passed by this court. Next para. This court, in terms of the order dated 8/7/2024, had directed the continuation of the services of the petitioner
Contract basis.
on contract basis. Notwithstanding the order dated 16/5/2024, which is impugned in this petition. Full stop. The learned, stop. The learned counsel for the respondent number 2 submits that steps would be taken to comply the order passed by this court on 8/7/2024. In that view of the matter, recording the submission of the learned counsel for the respondent number 2, IA 3 of 2024 stands disposed.
Yes.
Date may be fixed, ma'am. Date may be fixed, ma'am.
Let them first comply, madam.
ಅಲ್ಲ, ನಾನು 3 ದಿನದಲ್ಲಿ ಮಾಡೇ ಮಾಡ್ತೀನಿ.
ಮಾಡ್ಸಿ.
ಅಲ್ಲ, lordships may seem lot there is, the
No,
matter
for
is very on a very short compass.
Right, but 2024, why should you take it up for disposal?
ಅವ್ರ ಪಾಪ employment is the issue.
ಇವ್ರು ನಾವು ಕೆಲಸ ಕೊಡ್ತೀರಿ
Contract basis ಅಲ್ಲಿ
Sir,
ಇದೆ, because
contract
he is
basis
also,
ಅಲ್ಲ.
if his degree is not confirmed, then he will get the permanent employment also.
Therefore,
It's a
But
matter of
my
2
lord,
days that
Number
my learned
11
friend-
notification, my lord.
That's why
I have
in
been
their
selected
interest I'm saying.
2019.
So Shauri, can you get
Yes.
information?
Yes, my lords, I may be given 2 weeks time, my lords, I'll get the
ಈಗೆಲ್ಲ
information.
ನಾನೇ ತಗೊಂಡ್ಬರ್ತೀನಿ ಅಷ್ಟರಲ್ಲಿ RTI ಅಪ್ಲೈ ಮಾಡಿದ್ರು. ಅಲ್ಲ, this
So
is
why to get
recognized
in-
or not?
ಅಲ್ಲ,
There is a list published by
Alala,
this.
my humble submission is, it is not of present status. In 2003 is the issue. ಅವಾಗ the derecognize ಆಗಿದೆ ಅಂತ that order
ಅಲ್ಲ,
says.
UGC, everything, it's
ಅಲ್ಲ,
just,
but
website-
ಅಲ್ಲ, I being a council, I know the difficult, I cannot make a
Correct.
submission about the condition there. Lords, at least a week, next
so
week,
all this
Lords,
data
ಹೇಗೋ
is fed into
Independence
the
Day
system
ಇದೆ.
now, Shauri, it is not physical, you are not to, you need not
ಅಲ್ಲ,
retrieve
but
it
still, my
physically.
lords, may I seek, my lord, at least 19th ಒಂದು date ಕೊಡಿ. By that time I will get this.
List on 19th.
Much.
20th minute ಕೊಡಿ. So sorry. 20th.
ಅವತಾರದ್ದು 19th.
ಅಲ್ಲ, ಹಂಗ್ ಬೇಡ. Sorry, I'm so sorry.
20th.
So sorry.
20th.
Much obliged.
Serial number 20.
Yes.
Shankar Narayan Bhatt.
Yes, Adina.
Yes, sir.
ಅವ್ರು ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
ಕೊಟ್ಟಿದ್ದೀವಿ. Also signed to the payment bill. Salary bills ಗೆ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ.
Lord, this order is passed on 29/7, my lord. Now it has not been approved. This is only a recommendation made by the authority. Lord, I
No,
want
you
to produce.
please point out you are entitled to under the rules of 1992 to be appointed as a principal.
Please,
Simple. If you are eligible, we'll consider.
Blood. Now the earlier, this respondent number 4 was the vice principal. He himself has requested for relieving him as the vice principal. And as per the order dated 29/12/2020, he got it to withdraw on that vice principal post.
Sorry, how does it help you, sir?
Blood.
How does it help you?
Now when he,
Are you eligible to hold the post of?
please, that is the reason I have been appointed.
Yes.
Now this order may kindly be seen. I have served a copy on my learned friend.
That withdrawn, that request we have withdrawn and subsequently the writ petition and
Withdrawn it and he wants to come back and he wants to get back that post. 2020 he withdraws.
ಬಿಡುಗಡೆ ಆದೇಶದ ಹಿನ್ನೆಲೆ.
Second page, I scored it and wrongly scored it, my lord, sorry. Second page on the order, I scored it, I'm sorry, my lord, by wrongly I have scored it. In 2020, he himself withdraws that post and goes back to the post, to the teaching post. Now he claims that I want to be made as an appointment.
ತಪ್ಪೇನಿದೆ ಅಂತ ಕೇಳುದು. What is wrong in that?
No, when he himself doesn't want that post. Now, when I have been appointed for
Whatever
more than
reasons
3
he-
years.
Correct. For whatever reason, he gave up that
Lord,
vice principal post and went back to
Lord,
an assistant
your
teacher
lordship may
post.
kindly see the earlier order passed by this honorable court, what my learned friend has relied upon.
Hmm. Yes.
That's in the writ petition, my lord. Last page of that judgment may kindly be seen.
Hmm.
That the sixth respondent is directed to fill up the post of principal or vice principal, headmaster, headmistress to the institution run by the sixth respondent, that is Acharya Pre-University College, High School Division, Gauri Bidanur, in terms of the 1990s expeditiously. If such proposal is forwarded by the sixth respondent institution, the official are directed to take step to approve the same in terms of 99 rules. Now this what my learned friend has produced now that dated 29/7/2020. It has not been approved so far.
Right.
Then
They have to
unless and until it's been approved by the competent authority.
You give a statement, soon after his post is approved, you will step down.
No, but such an order could be passed.
No. You give a undertaking that the moment his appointment is approved, I will step down the court.
Please, I will make a such I will file an affidavit to that effect.
Give a unconditional undertaking that you.
Please, I'll undertaking may kindly be recorded and I'll file an affidavit by Monday.
ಮಾಡಿ ಮಂಡೆ ಹಾಕಿ.
ಅಲ್ಲ ಇವತ್ತು ಅದು interim order may kindly be granted.
ನೀವು ಮಂಡೆ ಹಾಕಂಗಿದ್ರೆ ಹಾಕ್ರಿ.
ಇವಾಗ I'll file it by Monday. Interim order could be, if not.
Make it an order of the court, sir. I can't compel you to file an affidavit.
No, my undertaking may kindly be recorded also. I'm making such statement.
Yes, Mr.
it is already financial bills is
ಆಯ್ತು,
signed.
ಫೈನಾನ್ಸ್ ಬಿಲ್ಸ್ ಅಪ್ರೂವ್ ಆಗ್ಬೇಕಲ್ಲ, ಅಪ್ರೂವ್ ಆಗದೆ ಹೊರತು ನಿಮ್ಗೆ
ಅಪ್ರೂವ್ ಕಳಿಸಿದ್ದಾರೆ, ಅಪ್ರೂವ್ ಆಗಿದೆ ಅಂತಾನು ಹೇಳಿದ್ರು ಸ್ವಾಮಿ. I will verify, it is already sent for approval.
ಅಪ್ರೂವ್ ಆಗಿದೆ ಅಂತೀರಾ, ಅಪ್ರೂವ್ ಕಳಿಸಿದ್ದಾರೆ ಅಂತ.
ಅಪ್ರೂವಲ್ 29/7 ಕಳಿಸಿದ್ದಾರೆ. ಅದು ಅಪ್ರೂವ್ ಆಗಿ ಬಂದಿದೆಯಾ ಇಲ್ಲ ಅಂತ, ಅಪ್ರೂವಲ್ ಕಳಿಸಿರೋದು ಕಳಿಸಿ ಅಂತಂದೆ, ಅಪ್ರೂವ್ ಆಗಿ ಬಂದಿದೆ ಅಂತಾನು ಹೇಳಿದ್ದಾರೆ.
ಅಪ್ರೂವ್ ಆಗಿ ಬಂದಿದೆ ಅಂದ್ರೆ ಅದೊಂದ್ಸತಿ ಇನ್ನೊಂದ್ಸತಿ ತರಿಸ್ಬೇಕಲ್ಲ ಇಮಿಡಿಯೇಟ್ ನೀವು.
ಸೋಮವಾರ I will produce.
ಬಟ್ ಅಲ್ಲಿವರೆಗೆ ಕೇಳ್ತಾರೆ ಎಂಟ್ರಿ ಮಾಡ್ರು. ಯು ಟೇಕನ್ ಚಾರ್ಜ್.
Taking charge, I am discharging my duties as a vice principal.
Already discharging.
Discharge.
Sorry,
That is what I.
It's not that I'll, your lordship may kindly grant an interim order, subject to the condition that I'll file an affidavit to that effect.
Please file it on Monday, list on Monday. Moreover, writ petition is not maintainable. I don't know how writ petition is maintainable.
It's a aided institution.
So what? You have
Then
to go
you
before the authorities. There's an appeal provided, sir.
Appeal is provided, it's not an efficacious and alternative remedy, my lord.
Why?
That is the reason I approach this court. I'll file affidavit Monday.
No. Yes. A dictation ಕೊಟ್ಟಿದ್ದೀಯ ಅಲ್ಲಿ ನೋಡಿ.
bench matter for further dictation, serial number 1, Swaraj Karadi.
ಇದು ಸ್ವಲ್ಪ ಇವರು ದೊಡ್ಡ ಎಂತದು ವಾಟ್ಸ್ ಹರ್ ನೇಮ್?
ಗುಂಡಮ್ಮ.
ತಮ್ಮ
ಹಾ.
ಅವ್ರು ಯಾವಾಗ ತೀರೋಗಿದ್ದು ಅಂತ ಹೇಳ್ಕಾಗುತ್ತೆ.
Yes,
Date
1982 ಇದೆ ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್.
88 ಡೇಟ್ನು ಇದೆ.
88 ಅನ್ಸುತ್ತೆ.
88 ಅಲ್ಲ, ಬಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ 82 ಅಂತಿದೆ.
ಅದೇ
82 ದಲ್ಲಿ
mistake.
tribunal order.
And who is this Husainappa? Husainappa, son of Shivappa.
ಹುಸೇನಪ್ಪ.
Land Tribunal order ಬನ್ನಿ, please come to the order of the Land Tribunal.
ಇದು ಇಂಟರ್ನಲ್ ಪೇಜ್ 5 ದಾಗ ಬಂದ ಹೆಸರೇನು ಸಾಹೇಬ್ರೆ?
ಅಲ್ಲ, 7 ಅಲ್ಲಿ ಬರುತ್ತೆ ಬನ್ನಿ. Please come to internal page 7.
7 ಅದೇ ಆಜಾದ್ಪುರ್ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ ಸೋಣಿಸು ಬೇರೆಯವರು ಶ್ರೀ ಹುಸೇನಿ ತಂದೆ ಶಿವಪ್ಪ ರವರು ಇವರು ಗೇಣಿದಾರರೆಂದು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದರಿಂದ ಸೋಣಿಸು ಜಮೀನಾಗುವುದರಿಂದ ಈ ಜಮೀನನ್ನು ಸರ್ಕಾರ ವೀತಗೊಳಿಸಿ ಆದೇಶ ಮಾಡಿರುತ್ತಾರೆ. ಏನೇನು ಅದು ಯಾರು ಎಂತ
ಇದು ಹುಸೇನಿ ಅಂದ್ರೆ ಯಾರು?
ಇವನ್ ಸೆಂಟೆನ್ಸ್ ಮೀನಿಂಗ್ ಕೊಡ್ತಾ ಇಲ್ಲ. ಅದು ಆದೇಶ ಮಾಡಿರುತ್ತಾರೆ ಅಂತ.
And that is not a stray, this one mistake. ಅದನ್ನ ರಿಪೀಟ್ ಆಗಿದೆ. Please come to the last sentence in para 7.
Para 7 ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್. ಆಜಾದ್ಪುರ್ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ ಸಾಲಿನ ಪಹಣಿ ಪತ್ರಿಕೆ ಪ್ರಕಾರ ಗೇಣಿ ಜಮೀನೆಂದು ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡು ಬರುತ್ತದೆ. ಅಲ್ಲ, ಅದರಂತೆ ಆಜಾದ್ಪುರ್ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 3 10 ಎಕರೆ ಗೇಣಿ ಜಮೀನಿದ್ದು ಬೇರೆಯವರಿಗೆ ಮಾರಾಟ ಮಾಡಿರುವುದರಿಂದ ಸೋಣಿಸು ಸರ್ವಾನುಮತ ಅಭಿಪ್ರಾಯಪಟ್ಟಿರುತ್ತದೆ. ಆಜಾದ್ಪುರ್ ಗ್ರಾಮ ಸರ್ವೆ ಪಹಣಿಯ ಪತ್ರಿಕೆಯ ಪ್ರಕಾರ ಗೇಣಿ ಜಮೀನೆಂದು ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡು ಬರುತ್ತದೆ ಅಂತಾರೆ.
And you please go to the next paragraph. ಈ ಪ್ರಕರಣದಲ್ಲಿ
ಈ ಭೂಮಂದ ಅಧ್ಯಕ್ಷನಾದ ನಾನು ಅಭಿಪ್ರಾಯ ಪಡುತ್ತಾ ಮಾಲ್ಗತ್ತಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಹಾಗೂ ಆಜಾದ್ಪುರ ಇವು ಜಮೀನುಗಳು ಇನಾಮದಾರ ಅರ್ಜಿದಾರರಿಂದ
ಸಾಗುವಳಿಗೊಳಪಟ್ಟಿರುವುದಿಲ್ಲವೆಂದು
ಮತ್ತು ಗೇಣಿನಾಥೆಯಿಂದ ಸಾಗುವಳಿ ಆಗಿರುವುದಿಲ್ಲವೆಂದು, ಅಲ್ಲದೆ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಸಂಚಾರಿ ಪೀಠ ಗುಲ್ಬರ್ಗದಲ್ಲಿ ವಾರಸುದಾರರೆಂದು ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿದ ದಾವೆಯು ವಿಚಾರಣೆಯಲ್ಲಿರುವುದರಿಂದ ಈ ಎಲ್ಲಾ ಜಮೀನುಗಳನ್ನು ಇದು
ಗುಂಡಮ್ಮ ಶಿ ವಾಸ್ ನಾಟ್ ಕಲ್ಟಿವೇಟಿಂಗ್ ಅಂತ ಬರ್ತಾ ಇದೆ.
ಅವರು ಏನು ಹೇಳ್ತಾ ಇದಾರೆ, ಇವನ್ ಇವರು ಹೇಳಿದ್ರು
ಆಯ್ತು. ಪಾಣಿ ಇದ್ರೆ 73, 74 ಪಾಣಿ ಇದೆಯಾ? ಇದು ಕೊಡ್ರಿ, ಇದು ಇನಾಮ್ ಸಬಲಿಷನ್ ಹಾಕೊಡ್ರಿ. Is the criteria under the certain inam subordination act?
Before that, my lord, may I make one submission, my lord? My lord, since this land was granted in 82, which was not the subject matter of
That I understood, that I understood. ಅಲ್ಲ, ಇದ್ರ ಈ ರೆಫರೆನ್ಸ್ ಇದೆಯಲ್ಲ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ, ಹೌ ಟು ಗೆಟ್ ಓವರ್ ದಟ್ ಅಂತ.
ಅಲ್ಲ, ನಾನು ಹೇಳೋದೇನು, ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಈ ಲ್ಯಾಂಡ್ ಬಗ್ಗೆ ಏನ್ ಮಾತಾಡಿದ್ದು, ಏನ್ ರೆಫರೆನ್ಸ್ ಮಾಡಿದ್ದು, that itself is without jurisdiction, because as on that day, the order of the tribunal 82 order is already there. Allah.
No, that is okay, but the entire order is set as Tali. What is the basis for this application form number 1? Yeah, 1374 ಏನಾದರೂ ರೆಲೆವೆನ್ಸ್ ಇದೆಯಾ? Come to section 5. Five ನೋಡಿ. You have withdrawn the writ petition that you have filed.
I have withdrawn matters. In fact, matters, I have filed an application for regarding the withdrawal. The counsel appearing on behalf of this respondent in the writ petition expired matters. Without informing the withdrawal of the writ petition, he himself filed a memo and withdrawn the writ petition. In fact, my father never instructed the counsel to withdraw the writ petition matters.
Yes.
In fact, your RCP may kindly see matters. The one.
We'll not consider your application right now.
Yes, ma'am. On merits matter, this petition, in respect of this petition matters, one Sadasivaya and Rachotaya were the brothers.
Lord, may I make one submission about that?
We are not going to that question.
Yes.
We are not going to, so far as his petition is concerned, the only question is whether what was pending before the tribunal, was it in respect of survey number 3 also?
3 also, ma'am. Yes, ma'am.
The writ petition filed by what's his name? Karanaya, was not in respect of survey number 3.
Survey number 3 also matters. I have challenged the both 3 lands in the entire order of the land tribunal is questioned by me, ma'am.
Read the writ petition. Let us read the writ petition that you have filed.
In my writ petition matters.
Before that, may I make a submission, my lord? He has no right of audience in my humble view. It is because at no point of time, he has claimed survey number 3. One thing, he has not filed form number 1. Second thing, even if this order.
Form number 1 illide, avaru hakirodu form number 1 illide.
It is not in dispute that matters. I have also filed form number 1.
ಒಂದು ಕೊಡಿ ಸರ್ ನಿಮ್ಗೆ ಹೆಲ್ಪ್ ಮಾಡಕ್ಕೆ ಅಟ್ಲೀಸ್ಟ್ ಏನಾದ್ರು ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಇಫ್ ಯು ಆರ್ ಏಬಲ್ ಟು ಫೈಂಡ್ ಔಟ್ ಫ್ರಮ್ ಸಮ್ ರೆಕಾರ್ಡ್ ಟು ಶೋ ದಟ್ ಹಿ ಹಸ್ ಫೈಲ್ಡ್ ಎ ಫಾರ್ಮ್ ನಂಬರ್ 1 ಓನ್ಲಿ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದೀಸ್ 2 ಸರ್ವೆ ನಂಬರ್ಸ್.
ಅಲ್ಲ ಅದು that is an admitted fact. Earlier writ petition may kindly be seen.
Yes, he has mentioned that. First paragraph in the writ petition, he says that he is a inamdar of these 2 particular survey numbers.
And he has
ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ.
Allah, he is not concerned with, he is only concerned with those survey numbers. This writ petition pertains to, I will read that portion, my lord. Is,
I read it, sir, I have read it. ತಗೊಳ್ಳಿ ಅದನ್ನ ಕೊಡಿ ಅದು. ಅದು ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀನಿ. ನೀವು ಏನ್ ಹೇಳಿದ್ರು ಅದನ್ನೇ ರೆಕಾರ್ಡ್ ಮಾಡಿ. I have read it. I just want to know whether this Sharanaya has filed form number 1 only in respect of survey number 93 and 99. ಅದು ಅಷ್ಟೊಂದು ಹೇಳಕ್ಕಾಗತ್ತಾ? ಏನಾದ್ರು ಇದೆಯಾ?
ಅಲ್ಲ ಸಾಹೇಬ್ರೆ, ಇದೇ ಆರ್ಡರ್ ನಲ್ಲೇ ಬಂದದಲ್ಲ ಮತ್ತೆ
ಯಾವ್ದ್ರಲ್ಲಿ?
ಈ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ನಾಗೆ.
ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
ಬಂದೈತೆ.
ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಎಲ್ಲದಕ್ಕೂ ಫಾರ್ಮ್ ತುಂಬಿದ್ದಾರೆ.
ಓದಿ ಎಲ್ಲಿ ಹೇಳ್ತಾರೆ?
ಇದು ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ನಾಗ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ವಿಷಯ ಸಾಹೇಬ್ರೆ, ಸರ್ವೆ ನಂಬರ್ 99 ಮತ್ತು 93 ವಿಸ್ತೀರ್ಣ ಸೋ ಅಂಡ್ ಸೋ ಜಮೀನಿನ ಗೇಣಿ ಜಮೀನಿನ ಅಧಿಬಾರಿಕೆ ನಿರ್ಧರಿಸುವ ಕುರಿತು. ದಿಸ್ ಈಸ್ ಒನ್ ಥಿಂಗ್. ಸೆಕೆಂಡ್ ಥಿಂಗ್ ಮೈ ಲಾರ್ಡ್,
page number 5.
No, you please come to the first order. You will get to know that.
Please.
First order ಅಲ್ಲಿ ಇದೆ. First order land tribunal order.
Swami, page number 5 minutes. Land tribunal states that ನಂತರದಲ್ಲಿ ಕರ್ನಾಟಕ
ಏನು ಹೇಳಕ್ಕೆ ಬರಲ್ಲ. ದಯವಿಟ್ಟು my lord, with due respect, I request the honorable court.
ಗುಂಡಮ್ಮ ಹಾಗೂ ಶ್ರೀ ಶರಣಯ್ಯನವರು
respect, I request the honorable court. For the present,
ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
the other side audience may kindly be not given. Only ವೈ ಅನ್ನೋದಕ್ಕೆ ಹೇಳಕತ್ತೀನಿ. ನಂದು ಕೇಳಿದಾದ್ಮೇಲೆ ಸಾಹೇಬ್ರ ಆಡಿಯನ್ಸ್ ಕೊಟ್ಟ ಮೇಲೆ ತಾವು ಹೇಳ್ರಿ ಅಂತ ಹೇಳಿದ. ನನ್ನ ಪ್ರಕಾರ ಇವ್ರಿಗೆ ರೈಟ್ ಆಫ್ ಆಡಿಯನ್ಸ್ ಇಲ್ಲ, ರೈಟ್ ಆಫ್ ಅಪಿಯರೆನ್ಸ್ ಇಲ್ಲ. ಅಪಿಯರೆನ್ಸ್ ಇರಬಹುದು, ರೈಟ್ ಆಫ್ ಆಡಿಯನ್ಸ್ ಇಲ್ಲ. ಈವನ್ ಆಡಿಯನ್ಸ್ ಇದ್ರು ಇಟ್ ಕೆನಾಟ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಅಂತ
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ಅಲೋಡ್.
ನಾನ್ ಹಾಕಿಲ್ಲ, ಅವ್ರಾಗಿ ಬಂದಾರ.
ಹಾಕಿರೋದು ಅಲೋ ಆಗಿದೆ.
ಅಲೋ ಆಗ್ಲಿ, ಅಲೋ ಆದ್ರೂ ಈಗ ಒಂದು ಸಾಹೇಬ್ರೆ, ಇವರು ಎಟ್ ಎನಿ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಸರ್ವೆ ನಂಬರ್ 3 ತಮ್ಮದು ಅಂತ ಕೇಳಿದ್ದ ಅವರನ್ನ
reading this order. Your RCP kindly page number 5. The tribunal given a specific finding.
5 of what?
Page number 7 of the land tribunal order, man.
ಓದಿ ಎಲ್ಲಿ?
Yes, man.
ಲಾಸ್ಟ್ ಟೂ ಲೈನ್ಸ್. ನಂತರದಲ್ಲಿ ಕರ್ನಾಟಕ ಹಲವು ಇನಾಮ್ ರದ್ದತಿ ಕಾಯ್ದೆ 1977 ನಿಯಮ 5 ಪ್ರಕಾರ ಶ್ರೀಮತಿ ಗುಂಡಮ್ಮ ಹಾಗೂ ಶ್ರೀ ಶರಣಯ್ಯನವರು ಆದಿಭೋಗದಾರಿಕೆ ಹಕ್ಕನ್ನು ಮಂಜೂರಿಸಲು ಭೂನ್ಯಾಯ ಮಂಡಳಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
Correct, sir. You please go to the first order of the tribunal, annexure A. Go to the first order. Sharanayya and Gundamma, Ibro 93-99 ಆಗ್ತಾರೆ. In addition, Gundamma had applied for survey number 3. So you did not apply for survey
Is
number
not in
3.
dispute that matters. Gundamma filed Form 1 for grant of occupancy rights matters. The occupancy rights granted in the year 1982, which was challenged by me.
Sir, ನೀವು ಯಾವ ಸರ್ವೆ ನಂಬರ್ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ ಅಷ್ಟು ಹೇಳಿ.
Survey.
ನೀವು ಯಾವ ಸರ್ವೆ ನಂಬರ್ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ.
Yes, but even I have not filed any application in respect of survey number 3 matters. In fact, matters, he is not a competent person. He has.
That is not the issue. You did not file an application in respect of.
Though I have not filed an application matters, your Arshit may kindly see matters, the Shantaya claims to be the adoptive son of Gundamma. That adoption deed is questioned by me by filing a civil suit.
Sir, that is in respect of survey number 99 and 93.
No,
Yes.
your Arshit, I have questioned the very adoption.
Sir, you might have questioned the adoption, sir.
That upheld by your Arshit, set aside by.
One issue, please. Please correct me if I am wrong. ನೀವು ಹಾಕಿದ್ದು 93-99. ಗುಂಡಮ್ಮ ಹಾಕಿದ್ದು 93-99-3. ಮೂರಕ್ಕೆ ಹಾಕಿದ್ರು. You challenged the order passed by the land tribunal in respect of 99 and 93. You did not challenge in respect of survey number 3.
Yes.
The High Court did not say that this, the order setting aside the order passed by the tribunal is also in respect of survey number 3 ಅಂತ ಹೇಳಿಲ್ಲ. ನೀವೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು ಅದು ಅಲೋ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ.
Yes, ma'am. In fact, matters whether Gundamma had a Gundamma claims to be the tenant matters. She filed form number 1, but she has not signed the form number 7. In fact, Shantaya signed this form number 7. Whether he has got any right over the property in question, since he is very adoption itself, Shantaya is nothing but son of Sharanayya. Sharanayana magane avunu.
ಶಾಂತಯ್ಯ ಶರಣಯ್ಯನ ಮಗ.
Sharanayana maga. Gundamma, your Arship, that is why facts are necessary. One Sadashivaya and Rachotaya were the brothers. Rachotaya died in the year 1940. Sharavaya died in the year 1965. Rachotaya had a wife, Gundamma. After the death of Rachotaya in the year 1940, Gundamma got married with one Siddhalingaya. She contacted second marriage with Siddhalingaya. Siddhalingaya died in the year 1969 months. Thereafter, she took this natural son of the late Sharanayya in adoption. That adoption deed is questioned by Sharanayya. That suit came to be dismissed initially. I filed an appeal. Appeal allowed. He filed RSA. RSA withdrawn by the Shantaya. Your Arship, in the year 1982, land tribunal granted occupancy rights. He purchased in the year 1988.
ಆಯ್ತು ಬನ್ನಿ ಕೊಡಿ ಕೊಡಿ ಇಸ್ಕೊಳ್ಳಿ. I consider submissions made by the learned counsel for the petitioners as well as the learned High Court government pleader and the learned counsel for the respondent number 3. LRs of the respondent number 3. Next para. It is evident from the order passed by the land tribunal dated 14/7/1982 that Gundamma had filed an application in respect of survey number 93 of Malgatti village and survey number 99 of Uppalam village and survey number 3. While the deceased respondent number 3 had filed an application in respect of survey number 93 of Malgatti and 99 of Uplam village. Full stop. The tribunal, in terms of the order dated 14/7/1982, registered Srimati Gundamma as the occupant of all the 3 survey numbers referred above. Full stop. The deceased respondent number 3 challenged this order in WP number 28129 of 1982. A perusal of the writ petition does indicate that the challenge to the land tribunal order was restricted to survey number 93 of Malgatti village and survey number 99 of Uplam village. Therefore, the order passed by this court setting aside the order of the land tribunal had to be construed as affecting survey number 93 and 99 and not in respect of survey number 3 of Azadpur village. Full stop. The right of Gundamma in respect of survey number 3 of Azadpur village was established, was thus set in stone by virtue of the order dated 14/7/1982. Full stop. The tribunal therefore could not have ventured into finding out whether the respondent number 3 had any claim in respect of survey number 3 of Azadpur village. Full stop. Insofar as the Azadpur village, consequently, the impugned order passed by the tribunal, revisiting its earlier order registering Srimati Gundamma as the occupant, deserves to be interfered with. Insofar as survey number 3 of Azadpur village is concerned. Full stop. Insofar as the finding of the tribunal that the land in question, land bearing survey number 3 of Azadpur village was cultivated by a person named Hussaini, son of Shivappa, as on 1/3/1974, and that Srimati Gundamma was not cultivating the said land, and that the land had thereby vested in the state government, is not based on any material document. Full stop. Is not based on any material document. Under Section 5 of the Section 5 of the Karnataka Certain Enams Abolition Act, the criteria for claiming occupancy rights or to register an authorized holder as an occupant is that he or she must be personally cultivating for a period not less than 3 years prior to the first day of March 1974. Full stop. Therefore, in the absence of any material to show that the land in question was cultivated by a person named Hussainappa, son of Seenappa, Shivappa. He is not based any material documents, and the finding recorded by the tribunal deserves to be set aside on that score. Full stop. Insofar as the finding recorded by the tribunal that the land bearing survey number 3 of Azadpur was alienated even while during the pendency of the proceedings before the tribunal, the same also deserves to be interfered with, since the tribunal had already confirmed the rights in favor of Srimati Gundamma by virtue of the order dated 14/7/1982. Full stop. However, what needs to be considered is that the sale permission in respect of 3 acres of land granted on
16/6.
please wait, granted on 26/10/1994 and 29/6/1996 to sell 3 acres and 4 acres 9 guntas respectively was granted in favor of Shantayya, who claimed to be the adopted son of Gundamma. However, the respondent, a deceased respondent number 3 had filed a suit in OS number 328,
Yeah, 289 minutes.
369.
369, that is for bare injunction, permanent injunction.
ಯಾವ್ದದು?
ಆಮೇಲೆ
289 of 2000.
289 bar 2005 minutes.
289
That is
2005.
question the validity of the adoption.
Questioning the validity of the alleged adoption of Shantayya by Srimati Gundamma, and that the suit was initially dismissed, and thereafter an appeal was filed by the deceased
Allowed.
respondent number 3 in RA number
RA number 28 bar 2010 minutes.
28/2010, which was allowed, and the suit filed in OS number so and so was decreed, thereby declaring that Shantayya was not the adopted son of Srimati Gundamma. Full stop. The said judgment was assailed by the deceased respondent number 3 in RSA number 7131/2012.
I have not filed minutes. The
Shantayya.
Shantayya filed.
Shantayya. Assailed in RSA number 7131/2012, which is unconditionally withdrawn. Therefore,
ಮೆಮೊ ಮೆಮೊದಲ್ಲಿ ಹೇಳಿ ನಾವು ಏನಂದ್ರೆ
order ಇಲ್ಲ sir, which is unconditionally withdrawn.
ಇಲ್ಲಿ
Therefore, the question whether the petitioner number 2 and petitioner number 2 had derived any title in respect of the land bearing survey number 3 of Azadpur, measuring 7 acres 9 guntas, is left open to be considered in an appropriate case. Insofar as the impugned order is concerned, as stated above, the land tribunal ought not to have considered the question whether Srimati Gundamma was entitled to claim occupancy rights in respect of the land bearing survey number 3 of Azadpur village, and therefore the tribunal committed an error in directing the said land to be vested in the state government. In view of the above, this writ petition is allowed in part, and the impugned order passed by the land tribunal directing the land bearing survey number 3 of Azadpur village to be vested in the state government is set aside. However, the findings recorded by the tribunal in respect of survey number 93 of Malgatti and 99 of Uplam shall remain in view of the decree passed in OS number 2
decree passed 289 bar 05.
ಅಲ್ಲಲ್ಲ
89/2005.
ಇಲ್ಲ ಸಾಹೇಬ್ರೆ ಶಾಲ್ ರಿಮೇನ್ ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ಡಿಗ್ರಿ ಅಂತಿರೋದಲ್ಲ.
ಆ ಥರ ಹೇಳ್ತಿಲ್ಲ, ನಾನು ಏನ್ ಹೇಳಿದ್ ನೀವು ಅರ್ಥ ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಓದಿ ಅವ್ರಿಗೆ. ಟ್ರಿಬ್ಯುನಲ್ ಏನ್ ಹೇಳಿರೋದು, ಯಾರು ವಾರಸ್ದಾರರು ಅಂತ ತೀರ್ಮಾನ ಆಗುತ್ತೋ ಅವ್ರಿಗೆ ಹೋಗುತ್ತೆ ಅಂತ.
93 ಮತ್ತೆ 99
ನಾಟ್ ಕನ್ಸರ್ನ್ ಅಬೌಟ್ ಇಟ್.
ಅದು ಸೇಲ್ ಆಗಿ ಲೇಔಟ್ ಆಗಿ ಮಾಡ್ರೆ
ಇನ್ನೊಂದ್ಸತಿ ಓದ್ಬಿಡಿ.
The very alienation is hit by.
ನಿಮಿಷ ತಾಳಿ ಸರ್ ಪ್ಲೀಸ್. And the withdrawal of RSA 7131/2012. Full stop. This order shall not be construed as conferring title in respect of 7 acres 9 guntas in survey number 3 of Azadpur village in favor of the petitioner number 2. 2 to 5. 2 to 2 to 4. It is open for the deceased respondent, LRs of the deceased respondent number 3 to work out their remedy in accordance with law.
In fact, man, the very alienation is hit by section 61 of the act, man.
Sir, ಅದು ಹೆಂಗಾಗುತ್ತೆ ಸರ್ 1982 ಅದು alienation hit by 61.
ಅಲ್ಲ 88 ದಾಗ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ 82 ದಾಗ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಗ್ರಾಂಟೆಡ್ ಆಕ್ಯುಪೆನ್ಸಿ ರೈಟ್ಸ್
ಬರಲ್ಲ
8 years they
No, 61 ಬರಲ್ಲ. 61 ಬರೋದಿಲ್ಲ. You have to go back to the 1977 Act.
I would like to rely upon some decisions made for RCM kindly see these judgments and
ಕೊಡಿ.
ಅಲ್ಲ ಸಾಹೇಬ್ರೆ ಅವ್ರಿಗೆ ತಾವು ಕೇಳಬಹುದಾ ಈ ಕೇಸ್ನಾಗ? ನಂದದು
ಬಿಡ್ಬೋದ ಕೇಳ್ಬೇಕು.
ಅಲ್ಲಲ್ಲ, ನಂದದು ಬೇಸಿಕ್ ಕ್ವಶನ್ ಸಾಹೇಬ್ರೆ. ಯಾಕಂದ್ರೆ ತಾವು ಅವ್ರಿಗೆ ಬಹಳ ಎಂಟರ್ಟೈನ್ ಮಾಡಿರಿ, ಅದ್ರ ಬಗ್ಗೆ ಮೊದಲು ಡಿಸೈಡ್ ಆಗಲ್ಲ ಅಂತ ಅನಿಸ್ತತೆ. ಯಾಕಂದ್ರೆ ಅವ್ರು ಕ್ಲೇಮ್ ಮಾಡ್ಲಾರ್ದವ್ರು ಇಲ್ಲಿ ಬಂದು ಸುಮ್ನೆ ದಾರಿ ಹಿಡಿದು
ತಪ್ಪಿದೆಯಲ್ಲ. ವೆರಿ ಲ್ಯಾಂಡ್ in contrary to section provisions of section 61 of the act.
ಇದು PIL ಅಲ್ಲ,
ಬೇಕಾಗಿಲ್ಲ. PIL ಆದ್ರೆ there is a
ಕೋರ್ಟ್ಗೆ ಹೇಳಕೈತೀನಿ. ನೀವು ಸುಮ್ನಿರ್ರಿ, ನಿಮಗ್ ಕೊಡಬಾರ್ದು ಮಾತಾಡೋದಕ್ಕಂತ ಕೋರ್ಟ್ಗೆ ಹೇಳಕೈತೀನಿ. ಸಾಹೇಬ್ರ ನನಗೆ ಇಲ್ಲ ನನ್ ತಪ್ಪಂತ ಕೂಡ್ಲಿ, ಅವಾಗ ನೀವು ಹೇಳಕ್ ಶುರು ಮಾಡ್ರಿ.
So 11 to ಓದಿ ಒಂದ್ಸತಿ, 13 to ಓದಿ. 13 to ಕೊಡಿ. Section 13 to ಓದಿ. Yes.
The amount shall be determined for the inam as a whole and not separately for each of the interests therein.
Section 13 subclause 2.
Subclause 13(2). The amount shall be
ಏನು ಓದ್ತಿದ್ದಾರೆ ಇಸ್ಕೊಡಿ. 11 to ನಾ ಕೊಡಿಲಿ. 13. I am sorry, 12 to, sorry. 12 to ಓದಿ.
the amount payable in respect.
12 to. ಸರ್ ನೀವು 13 ಓದ್ತಾ ಇದ್ದೀರಾ ಸರ್?
Yes. An inamdar 6 times the land revenue of the lands to be registered. Other persons referred to in section 5, 100 times the land revenue of the lands to be registered. The said right shall also be subject to the further conditions that the land registered shall not be alienated in any manner or partitioned except with the previous sanction of the deputy commissioner, and on payment of an amount equal to 20 times the land revenue of the lands concerned, which shall be in addition to the amount already paid as premium.
So therefore, under certain Inams Abolition Act, it's only permission. They have obtained a permission. So therefore, you can't go back to section 61 of the Land Reforms Act. Land Reforms Act only 15 years non-alienation ಇದೆ, provided it's a land governed under the Land Reforms Act.
Yes.
Procedure for considering applications under in form number 1 is the procedure prescribed under the land reform rules.
My respectful submission before your RCP is made, the very adoption deed, once the very adoption deed is set aside.
Yes, next. Connected withdraw ಮಾಡಿದ್ರು ಬಿಡಿ. Yes, next. Correct, next. I have to list WP number 207047/2014 separately for further hearing. Yes. Next, correct. ಅದು ಐ ಹಾಕಿದಾರಲ್ಲ, ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್ ಲೇಟರ್.
ಐಎ ಹಾಕಿದ್ದು.
ಅವರು ಐ ಹಾಕಿದ್ದಾರೆ.
ಹಾ ಹಾ.
Recalling this order.
Yes, yes.
So we'll consider that application separately.
ಅಲ್ಲ ಬಟ್ ಒಂದ್ ತಮ್ಮ ನಾಲೆಜ್ ನಾಗ ತರೋದೇನಂದ್ರೆ ಅವ್ರೊಂದು ಡೀಟೇಲ್ ಮೆಮೋ ಬರೆದು ನಮ್ಮಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ
ಏನಂತ?
ವಿಡ್ರಾಲ್
ಕೊಡಿ ಅದು ಕೊಡ್ಬೇಕು, ಕೊಡಿ.
ಅದಕ್ಕೆ
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ರಿ ಅದಕ್ಕೆ ಐಯಾಗೆ.
ಅಲ್ಲ ನಾವು ಪಾರ್ಟಿ ಇಲ್ಲ ಸಾಹೇಬ್ರ ಅದ್ರಾಗ.
ಯಾವ್ದಲ್ಲಿ?
ಅವ್ರ ಅದ್ರಾಗ್ರಿ
ಆಯ್ತು,
ನಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಅದಕ್ಕೆ
ವಿಲ್ ಕಾಲ್ ಫಾರ್ ದ ರೆಕಾರ್ಡ್ಸ್.
ಇಲ್ಲಿ ತಾವು ಸರ್ ನೋಡಿ ಮತ್ತೆ ವಾಪಸ್ ಇಲ್ಲಾಂದ್ರ ಅವ್ರ ಮತ್ತೆ ಏನ ಹೇಳಿಕೆ ಅಂತ ನಿಮ್ ಟೈಮ್ನು ಅವರು ಎದಕ್ ವಿಡ್ರಾ ಮಾಡಾಕತ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು ಹೇಳ್ಯಾರ.
The advocate who has filed this memo also no more.
ಆಯ್ತು, ಸರ್ವೆ ನಂಬರ್ 3 ಬಿಡಿ, ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ 93. Interim order ತಹಸೀಲ್ದಾರ್ not ready to.
ಅದು ಏನಾಯ್ತಂದ್ರೆ ಸಾಹೇಬ್ರೆ ಅಂದ್ರೆ
ವಿಲ್ ಕನ್ಸಿಡರ್.
ಆಯ್ತು ತಮ್ಮ ಗಮನದಾಗ
3 ಬಗ್ಗೆ ಇಲ್ಲ ಅದು.
ಅಲ್ಲ 3 ಬಗ್ಗೆ ಇಲ್ಲ, ಮತ್ತೆ ಅವ್ರು ಇಲ್ಕರ ಅದ್ರಾಗ ನಾನೇ ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕ್ತೀನಿ ಸಾಹೇಬ್ರೆ. ಮತ್ತೆ
ಯಾವತ್ತು
ಏನಿದೆ
ಯಾವತ್ತು ಇಡ್ಬೇಕು ಹೇಳ್ರಿ.
22nd, 22nd or 23rd.
22nd. Correct. Leelesh Krishna.
230 mood matter.
WP copy to be served to the BISCOM. There is no representation for the petitioner. Copy of the writ petition is not served to the learned counsel who represents the Kevata respondent. List after the same is done.
List number 1 for final hearing matters, serial number 27, MP Srikanth.
Hmm? 27 Allah. The learned counsel for the respondent number 6 seeks time list on. Yes.
Second August. Serial number 28 for dictating. Dictating orders.
I am filing written submissions.
Sorry.
I hope that this court will take a different view after going through this. I leave to the court.
The petitioner has challenged an order dated 2012-2010 passed by the first respondent terminating the services. Termination ಏನಿದು? Removal.
To recover your money when. Of course was the loss incurred. Out of that, the disciplinary authority said only 137. Later, it was reduced to 50. Ultimately, the 50,000 rupees is subject matter of this.
Yes.
I have said in the para 1 of the submissions.
Order dated Two 2011. And the consequent order passed by the Appellate Authority dated 26/7/2012, by which the disciplinary, the 2/7/2011 passed by the Disciplinary Authority, by which penalty of ₹50,000 was ordered to be recovered from the retirement benefits of salary
retirement terminal
from
benefit.
the terminal benefits of the petitioner. The petitioner is also agreed by the order passed by the Appellate Authority dated 26/7/2012, by which the order of passed by the Disciplinary Authority was confirmed. Next para. The petitioner contends that he was posted as the AG1 andreno. What is the AG1?
Assistant grade 1.
Assistant grade 1 at unit number 4 of the respondent number 1. Full stop. He was assigned with the job of a shed in charge and was expected to receive and issue stocks to maintain gunny registers, etc. The petitioner contends that he was discharging his duties diligently He contends that during July 2010, the stacks in the godown were overloaded. And he took charge of the godown based on the book balance. Full stop. During the period during which the petitioner worked as a shed in charge, he issued stocks that had already been received by his predecessor. He contends that he retired from service on 30/11/2010, and that at the time of receiving his retirement benefits, he was shocked to know that the respondent number 1 had recovered a sum of rupees 1,32,407 towards alleged storage loss that was allegedly incurred during August 2010. Stop. The petitioner contends that he was issued with a memorandum/show cause notice dated 25/11/2010, for which he submitted a reply dated 29/11/2010. However, the respondent number 1, without considering the reply of the petitioner, passed an order dated 20/12/2010, imposing penalty to recover a sum of rupees 1,32,407, being the pecuniary loss suffered by the respondent number 1. The petitioner thereafter filed an appeal before the respondent number 2, who also upheld the order passed by the respondent number 1. Full stop. Being agreed with the said order, the petitioner has filed this writ petition.
In that order, it was reduced to 50,000 rupees.
Yeah, appellate
Annexure E.
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಿರೋದು ಹಂಗೆ ಅವ್ರು ರಿಟ್
I'm
ಪಿಟಿಷನ್
sorry.
ಹೇಳ್ತಿರೋದು ಹಂಗೆ. Full stop. The learned counsel for the petitioner submitted that the charges leveled against the petitioner was that as against a book balance of 2.014.085 metric tons on 6/8/2010, there was no ground balance and therefore the petitioner was accused of manipulation. Likewise, in respect of stack number A10-123, it was alleged that 15 empty gunnies were kept in the stack U4A10, and the shed in charge told that the gunny bags were released from the stack, which was not accepted by the squad for the reason that those gunny bags were of different stencil marks and did not pertain to Haryana region from where this stack was received. Full stop. It was also accused that the petition, it was also accused that 50 numbers of empty gunnies found hidden under polythene covers in U4/B5 block on 4/8/2010. But on inquiry, the petitioner was not able to give any convincing reply and was accounted as receipt in the gunny register in folio number 33. Full stop. The learned counsel therefore submitted that the petitioner, therefore, the learned counsel submitted that the petitioner had specifically replied to these charges and had in detail explained the manner of storage of the gunnies as well as the stock received. She contends that the respondent number 1 did not consider the explanation offered, but on its own came to the conclusion that there was no need to conduct a disciplinary inquiry and proceeded to pass an order. Full stop. She submits that the respondent number 1 was bound to at least form an opinion about why a disciplinary authority inquiry was not necessary after hearing the petitioner. She therefore submits that the impugned order passed by the disciplinary authority imposing penalty to recover a sum of rupees 1,32,407, is illegal and deserves to be interfered with. Full stop. Per contra, the learned counsel for the respondents submitted that the petitioner was the in charge of the shed where on an inspection there were certain irregularities found and that the petitioner did not satisfactorily explain the reasons for the illegalities noticed by the inspection team. He submitted that the reply of the petitioner was indeed considered and the respondent number 1 felt it inappropriate to accept the reply of the petitioner and therefore passed the impugned order directing recovery of a sum of rupees 1,32,407. He submits that the said order was thereafter modified in terms of which, the penalty was reduced to a sum of rupees 50,000 as per the order dated 2/7/2011. The learned counsel contended that under the staff regulations, a discretion is vested in the disciplinary authority to dispense the conduct of a disciplinary inquiry if the disciplinary authority is of the opinion that the reply by the charge sheeted official was baseless or frivolous. He therefore contends that the disciplinary authority in the present case found that the petitioner did not explain satisfactorily about the lapses found in the shed and therefore passed the impugned order, which is neither excessive nor irrational. He therefore contends that full stop. It is further contended that this court ought not to exercise jurisdiction in a matter relating to department inquiry when the petitioner has been given all opportunities to show cause against the intended action. Full stop. Next, staff regulations ಕೊಡಿಲ್ಲ. Next para. The articles of charge framed by the respondent number 1 against the petitioner shows the following. Shows that the petitioner was charged with the following. Copy mode. Page number. Well. Full stop. The petitioner submitted his reply to the articles of charge on 29/11/2010, setting out the following reasons. Paragraph number 13 ಅಲ್ಲಿ pencil mark 13 and 14 ಅಲ್ಲಿ. The order passed by the disciplinary authority shows that the disciplinary authority was of the opinion that page number 16, pencil mark. The disciplinary authority thus proceeded to dispense proceeded to hold the petitioner guilty of the charges and pass the impugned order of penalty, directing recovery of a sum of rupees 1,32,407 from the terminal benefits of the petitioner. This was later modified and the penalty was reduced to a sum of rupees 50,000 in terms of the order dated 2/7/2011. Full stop. A perusal of the Food Corporation of India (Staff Regulations 1971) perusal bada, the Food Corporation of India Staff Regulation 1971 at Regulation 60 contains the procedure for imposing minor penalties. Full stop. The same is extracted for immediate reference. Section 61B grants discretion to the disciplinary authority to decide whether an inquiry is necessary or not in the facts and circumstances of a given case. Full stop. In the case on hand, there is nothing to show how the disciplinary authority came to the conclusion that an inquiry was not necessary. On the contrary, the order passed with, the order imposing penalty passed by the disciplinary authority proceeds on the observation of the disciplinary authority based on certain records that were inspected. Full stop. It is now tried that the disciplinary authority has to form an opinion as to why, how and why an inquiry is not necessary in the manner provided under Regulation 58 of the Staff Regulations 1971. Full stop. In similar circumstances, the apex court in the case of Goswami judgment could
Before that minutes,
ಹೇಳಿ.
page 5 of written submissions,
Hmm.
they have called out all the procedures with regard to 60 and how this has to be done in the written submissions.
ಹೇಳಿ.
That is based on the judgment of the Prahalad.
ಕುಡಿಯೋದು Goswami judgment.
As para 8, page 5, as regards the inquiry under section, regulation 60,
Hmm.
it is a misconception that under regulation 60, disciplinary authority will either conduct a regular inquiry as per regulation 58 or does not conduct any inquiry at all. If the disciplinary authority feels that a regular inquiry as contemplated in 58 is required to be conducted, even when punishment proposed to be imposed as a minor penalty, then the authority has a discretion to do so as per regulation 61B. But if the disciplinary authority feels that regular inquiry is not necessary, then it does not mean that no inquiry will be conducted at all. In the latter case, the inquiry would be summary inquiry and not regular as contemplated in regulation 58, which is for major penalties. A bare perusal of 63, in fact, this provision has been overlooked in that judgment which the other side has said last occasion, because the entire record of the proceedings in such case.
Correct. ನೀವು ಒಪಿನಿಯನ್ ಮಾಡಿ ಬೇಡ ಅಂತ ಹೇಳೋದಿಲ್ಲ.
ಒಪಿನಿಯನ್ ಇಲ್ಲ, ಏನಿರ್ಬೇಕು ಈ ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿ ಏನ್ ಮಾಡ್ಬೇಕು? ಒಂದು ರೆಗ್ಯುಲರ್ ಎನ್ಕ್ವೈರಿ ಅಂಡರ್ 58. If it is a minor penalty, he need not do that exercise.
He need not do ಅಂತ ಇಲ್ಲ ಸರ್. ಪ್ಲೀಸ್ ಇನ್ನೊಂದ್ಸತಿ ಓದಂಗಿದ್ರೆ ಓದಿ ಸರ್. ಓದಿ ಇನ್ನೊಂದ್ಸತಿ.
ನಾನು
ಇನ್ನೊಂದ್ಸತಿ ಓದಿ.
I have read that. We will go to
Please
the
read for the benefit of the court.
ಇಷ್ಟೇ ಬೇಡ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ para 4 ಅಲ್ಲಿ just Prahaladrao judgment, sir, Prahaladrao case.
Anyway, let us read again. Subject to the provisions of subregulation 3 of section 59, no order imposing on an employee any of the penalties specified in clauses 1 to 4 of regulation 54 shall be made except after informing the employee in writing of the proposal to take action against him and of the imputations of misconduct or misbehavior on which it is proposed to be taken, and giving him an opportunity of making such a representation as he may wish to make against the proposal.
Three things are required. First, memorandum, then opinion, that is articles of charge alle ide, then representation was given by him, it was considered.
ಅಲ್ಲಿ ಬಂದಿ representation ಕೊಟ್ರು. ಕೊಟ್ರು ಅಲ್ಲಿ ತಾನೆ. Please wait, ಅಲ್ಲಿವರೆಗೂ. Then B, holding an inquiry in the manner laid down in subregulation 3 to 23 of regulation 58, in every case in which the disciplinary authority is of the opinion that such inquiry is necessary. ಅಂದ್ರೆ ನನಗೆ ಅರ್ಥ ಆಗಿದ್ದು ನಾನು ಹೇಳ್ತೀನಿ. Correct me if I am wrong. If the disciplinary authority comes to the conclusion that an inquiry is necessary, then the inquiry should be done in the manner provided under regulation 658. This is my understanding.
I am not, what I am saying, the inquiry, if the disciplinary authority wants to do the detailed inquiry in 58, then such things are required.
Detailed inquiry, the rules say that.
For
the
all
rules say that.
For all these penalties, minor or major, there is a difference between minor and major.
Yes.
Illi, this minor penalty,
ಇದೇನ್ ಹೇಳ್ತದೆ?
ಅದಕ್ಕೋಸ್ಕರ
Regulation 59. We'll go to
ಆಮೇಲೆ
regulation.
ಸಬ್ ರೆಗ್ಯುಲೇಷನ್ 3 ನೋಟ್ಸ್. sub-regulation 3, page number 9, 5 ಅಲ್ಲಿ letter sub-regulation ಬರ್ದಿದೀವಿ.
58.
What all has to be there in the record of proceedings in a minor penalty case. ಇದರಲ್ಲಿ minor penalty cases ಅಲ್ಲಿ detailed evidence ಕೊಡಬೇಕು, cross examination ಮಾಡಬೇಕು ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ. What it requires is only copy of the intimate. That 63 ತಾವು ನೋಡ್ಬಿಟ್ರೆ ಸಾಕು. 63 procedure for imposing minor penalties. What is the procedure?
Oh, this is.
The record of the proceedings in such cases shall include a copy of the intimation to the employee of the proposal to take action against him, copy of the statement of imputations of misconduct or misbehavior delivered to him, his representation if any, the evidence produced during the inquiry. Next, the finding on each imputation misconduct, the orders of the on the case together with the reasons therefore. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ ಇದು this is the required, these are the things which are required under the what is it, minor penalty procedures.
ಆಯ್ತು,
Major
ಬನ್ನಿ
penalty.
ಬನ್ನಿ ಬನ್ನಿ ಬರ್ಕೊಳ್ರಿ. ಏನಾಯ್ತು? ಅದು ಸಿಮ್ಲರ್ ಆಮೇಲೆ ಮಾಡಿದ್ರು. A perusal of Regulation 54, small Roman 1 to 4 shows that the minor penalties are: number 1, censure; number 2, withholding of his promotion; number 3, recovery from his pay of the whole or part of any pecuniary loss caused by him to the corporation by negligence or breach of orders; number 4, withholding of increments of pay. Full stop. Therefore, whenever the disciplinary authority decides to impose a penalty specified in the above clauses, then he has to inform the employee in writing of the proposal to take action against him and the imputations of misconduct or misbehavior, and also give him a reasonable opportunity of making a representation. Full stop. Thereafter, the disciplinary authority shall decide whether an inquiry is necessary. Full stop. If the disciplinary authority decides to proceed to conduct a disciplinary authority, then such inquiry shall be in the manner provided under Regulation 58 bracket subregulation, 58 subregulation 3 to 23. Full stop. In a case reported in FCI and others versus Sharat Chandra Goswami, 2014, Part 13, SEC, page 211, the apex court held, while considering the staff regulations of 1971, comma, paragraph number 9, as follows. Copy them out. Full stop. In the case on hand, comma, there is nothing on record to show as to how the disciplinary authority came to the conclusion that an inquiry was unnecessary. Full stop. There is nothing on record to show that the disciplinary authority issued any notice calling upon the petitioner, informing the petitioner the reasons on which it had felt that an inquiry was unnecessary. Full stop. Therefore, the impugned proceedings initiated by the therefore the impugned penalty imposed by the disciplinary authority has no legs and consequently deserves to be set at naught. In that view of the matter, this petition is allowed and the impugned order of penalty imposed by the respondent number 1 and upheld by the appellate authority are set aside. It is, however, having regard to the fact that there are certain financial irregularities reported during the time the petitioner was officiating as the shed in charge, it is appropriate to permit the discipline authority to conduct an inquiry. Discipline authority to first apply its mind whether inquiry is necessary the inquiry is necessary, and if it is found that an inquiry is necessary, the disciplinary authority shall proceed in accordance with law and conclude the inquiry within an outer limit of 3 months from the date of receipt of a copy of this order. ಯಾವುದು ಇಲ್ಲಮ್ಮ ತಗೊಳ್ಳಿ, ಯಾವ್ದಿದೆ ತಗೊಳ್ಳಿ. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಫೈನಲ್ ಹಿಯರಿಂಗ್ ತಗೊಳ್ಳಿ.
Submission, my lords.
Please wait, madam.
List number 2 for final hearing matter, serial number 4. Manjunath S. Joyce.
Petitioner.
Not I appear for the respondents, madam. I seek for a short passover, madam.
No passover, madam.
My lord, my senior is just in the next court, my lord. Just a
Let
short
him argue.
Please,
Let him commence.
please.
Petitioner is a retired Sirestadar.
Petitioner is retired?
Sirestadar.
Sirestadar.
He died in 2017. Come on record LR.
What is challenged?
Now it's petitioner is eligible for retrospective promotion. His triptych order has been passed by the second respondent. Annexure up.
Mic use ಮಾಡಿ.
Annexure up. Annexure up. In view of the 3 charges being proved against UK Ganapati, so and so, my lord, that punishment has been modified as a censure.
ಯಾವಾಗ?
In the year 2010, madam.
2013 ಇದಾಗಿದೆ, ಸೆನ್ಶೂರ್ 2010 ನಲ್ಲಿ ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ?
Madam, ಇಲ್ಲಿ kindly annexure C, annexure annexure B, madam.
Annexure B.
Yes, madam.
What?
High Court has ordered that order dated 22/4/2006 passed by the District and Session Judge order Medicare Disciplinary Authority D number 4 of 96 UK Ganapati SAD Court of Civil Judge and JMF CJM Medicare imposing the penalty of reversion from the grade of FDA to the grade of SDA be modified and penalty of censure be imposed on the DGO by withholding 1 increment without cumulative effect. That is that annexure C, annexure C is petitioner
Not able to understand what is your case.
That is the matter. Retrospective promotion. I am not a petitioner is not
So what is
permitted
this
to.
annexure B? What is annexure B?
Annexure A is the first matter. I come to first annexure. Annexure A is the promotion order matter.
Yes.
SDA to FDA.
Yes.
That order has been passed by the district and session judge Kodagu.
Yes.
This order has been the subject matter of departmental inquiry.
Now this sort of subject matter department ಹೆಂಗಾಗುತ್ತೆ?
Inquiry has been imposed. Inquiry ಮಾಡಿಬಿಟ್ಟು ಆಮೇಲೆ ಇವ್ರನ್ನ ರಿವರ್ಟ್ ಮಾಡ್ತಾರೆ SDA. FDA ಇಂದ SDA ಗೆ ಮಾಡ್ತಾರೆ. SDA ಗೆ ಮಾಡಿದ್ಮೇಲೆ ಅದನ್ನ ಹೈಕೋರ್ಟ್ಗೆ ಬರ್ತದೆ ಸ್ವಾಮಿ. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ that has been modified as a censure ಅಂತ ಮಾಡ್ತಾರೆ. Censure with one increment.
Yes.
Annexure B. Annexure B 1 increment ಮಾಡಿ censure ಅಂತ ಮಾಡಿ ಅದನ್ನ ಅಲ್ಲಿಗೆ ಬಿಡ್ತಾರೆ. ಆಮೇಲೆ next annexure C ನಲ್ಲಿ
censure be imposed on DGO by withholding
one annual increment
without cumulative effect.
That is annexure C permitted him to draw the all consequential benefits after completion of 1 increment.
Thereafter, my lord, the petitioner has been promoted as Shiras Tadar, Annexure D, with effect from 6/8/2010, my lord. Thereafter, applicant petitioner has clarified with Annexure F, my lord. With reference to the above, I am directed to state that under Secretary, Law, Justice and Human Rights Department, wide reference to above has clarified regarding giving promotion to the UK Ganapati Shirastadar in the cadre of Shirastadar from retrospective date. The details are furnished in the government letter to take further action.
ಯಾವ್ದು ಓದ್ತಿದ್ರಿ?
Annexure F, my lord. Annexure F.
F.
Yes, my lord. Annexure F, on page number 13. Again, with reference to
Annexure
above-
F is at page number 17.
Annexure F, Annexure F, ಇಲ್ಲ sir. Page number
Annexure
13.
F is at page number 17.
That is Annexure E, my lord. Annexure E, sorry, Annexure E. That is wrong. Annexure E. With reference to above, I am directed to state that under Secretary, Law, Justice and Human Rights Department, wide reference number 2, above has clarified regarding giving promotion to
ಅದು ಸಿಗ್ತಾ ಇಲ್ಲಪ್ಪ. Annexure E ನ F?
E, some E, Annexure E, page number 13. Page number 13.
Yes.
The order dated 7/2/2013. Yes, ma'am. With reference to above, I am directed to state that under Secretary, Law, Justice and Human Rights Department, wide reference to above has clarified regarding giving promotion to the UK Ganapati Shirastadar in the cadre of Shirastadar from retrospective date. The details are furnished in the government letter to take further action, ma'am.
Yes.
Hence, the copy of government letter along with service register UK Ganapati Shirastadar enclosed herewith. My lord. Annexure, page number 14 is the government order. Government order. Please come to page number 15, ma'am.
Yes.
Last para, last bottom, 15. ಸರ್ಕಾರಿ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ so and so 6/4/2010 ತನ್ವಯ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ವರ್ಗೀಕರಣ ನಿಯಂತ್ರಣ ಅಪೀಲು ನಿಯಮಗಳು 1957 ನಿಯಮ 8 ರನ್ವಯ ವಾಗ್ದಂಡನೆಯನ್ನು ವಿಧಿಸಿ ದಿನಾಂಕದ ನಂತರ ಸಂಬಂಧಿಸಿದ ನೌಕರರ ಪ್ರಕರಣವನ್ನು ಮುಂಬಡ್ತಿಗೆ ಪರಿಗಣಿಸಬಹುದಾಗಿದೆ ಆಗಿರುತ್ತದೆ ಎಂದು ಸ್ಪಷ್ಟೀಕರಿಸುತ್ತದೆ. ಆದರೆ ಅದರಂತೆ ದಿನಾಂಕ 6/4/2010 10ರ ಸರ್ಕಾರಿ ಸುತ್ತೋಲೆಯನ್ವಯ ವಾಗ್ದಂಡನೆಯು ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಮಂಜೂರು ಮಾಡಬೇಕಿರುವ ಹಿರಿಯ ವೇತನ ಅಡ್ಡ ಬರುವುದಿಲ್ಲ. ಆದರೆ ಇಲಾಖಾ ವಿಚಾರಣೆ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ಪ್ರಾರಂಭದ ದಿನಾಂಕದಿಂದ ವಿಚಾರಣೆ ಮುಗಿದ ದಂಡನೆಯಲ್ಲಿ ಪೂರ್ವ ಪರ್ಯಾವಸನಗೊಂಡಲ್ಲಿ ಈ ದಂಡನೆ ಜಾರಿ ಇರುವ ಅವಧಿಯವರೆಗೆ ಹಿರಿಯ ವೇತನ ಮಂಜೂರು ಮಾಡಲು ಬರುವುದಿಲ್ಲ. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ವಿಕೆ ಗಣಪತಿಯವರಿಗೆ ಪ್ರಥಮ ದರ್ಜೆ ಸಹಾಯಕ ವೃಂದದ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯಲ್ಲಿನ ಅರ್ಹತಾ ದಿನಾಂಕದಂದು 15 ವರ್ಷಗಳ ಸೇವೆಯನ್ನು ಪರಿಗಣಿಸಿ ಇಲಾಖಾ ವಿಚಾರಣಾ ಅವಧಿಯನ್ನು ಮತ್ತು ದಂಡನಾ ಅವಧಿಯನ್ನು ಮುಂದೂಡಿದ ನಂತರ ಸದರಿಯವರು 1991ರ ಕರ್ನಾಟಕ ಸಿವಿಲ್ ಸೇವಾ ಹಿರಿಯ ವೇತನ ಶ್ರೇಣಿ ಸ್ವಯಂಚಾಲಿತ ವಿಶೇಷ ಮುಂಬಡ್ತಿ ನಿಯಮಗಳಲ್ಲಿ ವಿಧಿಸಿರುವ ಇನ್ನಿತರ ಷರತ್ತುಗಳನ್ನು ಪೂರೈಸಿದ್ದಲ್ಲಿ ಹಿರಿಯ ವೇತನ ಶ್ರೇಣಿಯ ಮಂಜೂರಾತಿಯನ್ನು ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಿಯಾದ ತಾವೇ ಪರಿಶೀಲಿಸಿ ಮುಂದಿನ ಮಂಜೂರು ಮಾಡುವಂತೆ ಸೂಚಿಸಿದೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಮೀಟರ್ ಮುಂದುವರೆದು ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮ 58, 59 ಹಾಗೂ 59A ಕಡೆಗೆ ಗಮನ ಸೆಳೆಯಲಾಗಿದೆ. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಈ ನಿಯಮಗಳನುಸಾರ ಸೂಕ್ತ ನಿರ್ಧರಣೆಯನ್ನು ದಂಡನಾದೇಶವನ್ನು ಹೊರಡಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಪರಿಗಣಿಸಿಲ್ಲವಾದ್ದರಿಂದ ಪ್ರಶ್ನೆಯು ಉದ್ಭವಿಸಿರುವುದಾಗಿದೆ. ಆದ್ದರಿಂದ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮಗಳು ಉಪಬಂಧವಾನುಸಾರ ಸೂಕ್ತ ನಿರ್ಧರಣೆಯನ್ನು ಪಡೆದು ಆ ಮೇರೆಗೆ ಪ್ರಕರಣವನ್ನು ನಿಯತಗೊಳಿಸಲು ಕ್ರಮ ವಹಿಸತಕ್ಕದೆಂದು ತಿಳಿಸಲು ನಿರ್ಧರಿಸಿದೆ. ದಟ್ ಈಸ್ ದಿ
ಏನಂತ ವಾಟ್ ಯು ಮೀನ್?
ಅದೇ ಸೆನ್ಸೂರ್ ಇದ್ರೆ ಅದನ್ನ ನಾಟ್ ಎಫೆಕ್ಟ್, ಸೆನ್ಸೂರ್ ಇದ್ರೆ ನಾಟ್ ಎ ಮೇಜರ್ ಪನಿಷ್ಮೆಂಟ್.
ಬರೀ ಸೆನ್ಸೂರ್ ಅಲ್ಲ, ಇಟ್ ಇಸ್ ನಾಟ್ ಓನ್ಲಿ ಸೆನ್ಸೂರ್.
Without cumulative effect. After completion of
it is not mere censure. ಬರೀ ಸೆನ್ಸೂರ್ ಅಲ್ಲ.
ಸೆನ್ಸೂರ್ ಅಲ್ಲ, ಅದು 1 ವರ್ಷಕ್ಕೆ ಮಾತ್ರ ಇತ್ತು. 1 ವರ್ಷ ಕಂಪ್ಲೀಟ್ ಆದ್ಮೇಲೆ as it is ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. That is my case. Thereafter endorsement has been issued.
Replic endorsement, this is not speaking endorsement. ಅವರು ಇಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ದೇ ಫೈಲ್ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದರಲ್ಲೂ ಅವರು ಅದನ್ನೇ ಹೇಳ್ತಾರೆ.
Yes, sir. Yeah.
As per the Karnataka Civil Service automatic grant of special promotion to senior scale of pay, Rule 1991, my lord.
Could you believe?
Yes.
Could you? ಯಾವ್ದು rules?
Sorry, the Karnataka Civil Services automatic grant of special promotion to senior scale of pay, Rules 1991, my lord. E-book input.
Yes, I have this.
Yes, sir. My lord, if a person is stagnating in a one particular post for a 15 years, my lord, he will get a promotion to the next pay scale, my lord. The same work he will continue to do.
Stagnation.
So he will get one promotional pay scale, my lord. That is the concept, my lord. That particular Rule 3, my lord, it speaks about grant of special promotion to senior scale of pay. Then, my lord, what is the qualification has been explained in section 3, my lord. But what is applicable to this case is, my lord, subsection B, my lord. Sorry, sub-rule B, my lord. I will just read it, my lord.
D na?
B, my lord. B. He has satisfactory record of service. The satisfactory record of service being determined in the same manner as merit is determined for promotion on the basis of seniority cum merit, my lord. So his record has to be seen. And if there is any remarks in his service record, in that event, my lord, the discretion lies with the employer to whether to grant this particular one pay scale or not, my lord. That particular record has been looked into.
How have you come to the conclusion?
My lord, that particular conclusion, they have.
Annexure F, what does it make out?
Yes, sir.
Just because there is an inquiry and a censure order.
Yes, my lord.
You say that he is not entitled.
My lord,
where is the assessment?
My lord, for this particular post, my lord, for this if for any other promotion, my lord, there is a need of assessment. Whereas with respect of this particular promotion to the next pay scale, my lord, we are not required to follow the regular promotion requirement.
Say that. The rules say
no, rules does not say that, my lord. My lord, there is one particular judgment, my lord, with respect of this particular interpretation of Rule 3, my lord. Yes. There was entry in the service record, my lord, regarding he is coming to the office late, my lord. That particular aspect was taken into consideration, that promotional pay scale was not given to him, my lord. Yes, my lord. It's a short judgment, my lord, para 1 and 2, I will read it. The petitioner challenges Annexure H order dated 19/9/2006, passed by the Karnataka Administrative Tribunal in application number so and so. As per Annexure H order, the tribunal rejected the claim of the applicant for automatic grant of special promotion to senior scale of pay under Karnataka Civil Service Rules 1991. The tribunal found that even though the petitioner had completed 15 years of continuous service without any promotion in the cadre of First Division Assistant on 5/2/1993, he was not granted the benefit of automatic grant of special promotion to senior scale for the reason that there were adverse remarks in his confidential report for the previous 5 years from 1988-89 to 1992-93. The tribunal also found that the petitioner was not entitled to the benefit as he did not have satisfactory record of service. It is not disputed that for the year 1988-89, the confidential report of the petitioner contained an entry to the effect that he does not complete the work in time. For the year 1991, the confidential report contained an entry to the effect that petitioner was not using the Kannada language. For the year 1992-93, the confidential report contained an entry to the effect that he was unauthorizedly absent for a long time. The petitioner has not disputed the existence of above mentioned entries in the confidential report. In the light of such entries in the confidential report, of the petitioner, it cannot be said that he had satisfactory record of service during the relevant period of time. Under Rule 3 of the Karnataka Civil Service Rules 1991, one of the requirements for grant of the benefit is satisfactory record of service, and the satisfactory record of service should be determined in the same manner as merit is determined for the promotion on the basis of seniority cum merit. Therefore, the respondents were justified in denying the benefit to the petitioner on the ground that he did not have satisfactory record of service during the relevant period in view of the adverse entry in his confidential report. Admittedly, the petitioner was promoted to the cadre of superintendent with effect from 4/1/1996. So this is the observation.
Correct, but it's the nature of a stagnation increment.
Yes, my lord. Even
Therefore, why do you connect satisfactory, what you call, what do you do?
the
Satisfactory record of service.
my lord,
Why
if
do you consider that?
it is not automatically he will not get unless he has a satisfactory service record. If
Correct,
he
but-
does not have a satisfactory service record, my lord, then my lord, he is not entitled.
Yes,
And that is what has been found in his record, my lord.
correct. ಇದ್ರಲ್ಲಿ ಏನಿದೆ annexure F ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
Alla, there is one particular proceeding
Look at
has
this
been initiated.
judgment. No, if you look at this judgment,
Yes, my lord.
in this judgment, there was something to show that there was application of mind before coming to the conclusion that he did not have satisfactory record of service.
Yes, my lord.
What is the material now?
My
or
lord,
what is
in
the
this
finding
particular
recorded in
case,
this
my
one?
lord, in this particular case, my lord,
Hmm.
against him, charges were framed.
Yes.
Then, my lord, penalty was imposed against him. Thereafter, he preferred an appeal. And thereafter, in appeal, my lord, he was censured and one increment was withdrawn.
Yeah.
And this particular penalty which has been imposed, it has been accepted. It is not in dispute, my lord. It has attained the finality also.
Yes.
And because of that particular proceedings, which is reflected in his service record, my lord, entitled to look into it.
What is the
and
implication? What is the increment? What would be the increment?
My lord, in that particular case, my lord, the one he told one increment.
Sorry, if this stagnation increment is given,
Yes, my lord.
what will be the benefit of the petition?
He will only get a benefit of a one pay scale, my lord, not more than that.
Yes, sir.
And he has already retired, my lord.
Yes.
And one pay scale because of his stagnation in that particular post. And my lord, since that particular automatically he will not be entitled unless he has a good service record.
My lord, petitioner
But,
cannot be subjected to double punishment, my lord.
The question of double punishment will not arise, my lord. The reason is that, my lord,
Double
this particular promotion is not as a matter of right. It is a stagnation, whether to grant or not, whether to provide him or not. For that, my lord, this particular the rule B appended to rule 3, my lord, would guide to exercise the power, my lord. And
Yes.
accordingly, the decision has been taken, my lord.
When was he entitled to this stagnation increment?
My lord, according to
7, my lord.
2007.
7.
And when was the,
My lord, I will put it
2007
like this,
June.
my lord. He was appointed on 2/5/1973, my lord.
Hmm.
Then, my lord, he received one promotion on 17/10/1984, my lord.
Hmm.
Then he received another promotion on 6/8/2010, my lord.
Hmm.
Then, my lord, he was also looking for stagnation, and then he sought for his next promotion, that is the pay scale. And that is the application he submitted.
Yes.
And that particular application came to be rejected, my lord.
Yes.
Taking into account of his all other promotion he has received, my lord. Whatever the promotion he is entitled, he has received. But one pay scale has not been given to him as per the rule 3.
Yes, Mr.
So after completion of one increment punishment, a petitioner is entitled to hold.
I think, how do you get over this satisfactory record of service?
Double punishment is not.
Double punishment ಎಲ್ಲಿ ಬಂತು?
One censure on some censure and ಆಮೇಲೆ one increment.
Double punishment ಎಲ್ಲಿ ಬಂತು?
Double.
You are not entitled to ಅಂತ ಅವ್ರು ಹೇಳ್ತಿರೋದು.
Yeah.
Because you did not have satisfactory record of service, you are not entitled to the increment.
Maintained clean record of service, my lord.
Allow this petition, no satisfactory record of service. The impugned order is very,
My lord,
Cryptic.
it's a
my lord,
cryptic order.
my submission is that, my lord, the censure has been, what is the ultimately, my lord, is the record, my lord.
Yes.
And that record has to be seen. There is no need of a passing of a detail order or anything.
not
If his service record is clean, my lord, he's automatically he's entitled. If his service record is not clean, my lord, and if the service record shows that there is a certain penalty which has been imposed on him, here, my lord, in this case, my lord, a punishment as contemplated under part 4 of subrule 2 of rule 8 of the KCS rules 1957 has been imposed. And that has been taken into consideration. And that particular order has attained the finality. My lord, if that particular aspect is overlooked, everyone will claim as a automatically. That is not the object of the rule 3, my lord.
ಅಷ್ಟೇನಾ?
ಇಂಪಿಂಗ್ ಆರ್ಡರ್ ಅಂತ ಓದಿ
ಓದಿ.
ಅಷ್ಟೇ, 4 ಲೈನ್ ಬರೆದಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಹ್ಮ್.
In view of 3 charges being proved against UK Ganapati, Sirastadar, so and so, and clarified in the letter reference at 2 and 3, above request of the above said official grant of automatic promotion to senior scale pay and promotion, giving promotion in the case of Sirastadar from retrospective date is rejected. Yeah, sir.
ಅಷ್ಟೇನಾ?
It is cryptic card, madam. ಅದಕ್ಕೆ
Cryptic card ಸರಿ, but ಏನು you don't deny this the finding recorded against you. ಅದೇನು ಡಿನೈ ಮಾಡಲ್ಲ ನೀವು.
ಅದೆಲ್ಲ ಡಿನೈ ಮುಂಚೆಯಿಂದ ಡಿನೈ ಮಾಡಿದೀನಿ, ಬಟ್ ಅದೆಲ್ಲ
ಡಿನೈ ಮಾಡಿದಿರಿ, but you not challenge that order.
ಅದು ಯಾವ್ದು ರೆಕಾರ್ಡ್
Imposing a penalty of reduction of 1 increment. ಬರ್ಕೊಳ್ಳಿ.
ಒಂದು ಇನ್ಕ್ರಿಮೆಂಟ್ ಬರ್ಬೇಕು ಸರ್, 2006-7 ಇಂದ ಅಷ್ಟೇ. ನೀವು
The petitioner has challenged an order passed by the challenged the order bearing number so and so dated 27/8/2013 passed by the Principal District and Session Judge Prabhu Madikeri, by which the request of the petitioner for grant of automatic promotion to senior scale of pay and giving promotion in the court of Shirastadar from retrospective effect was rejected. Next paragraph. The petitioner was appointed as a second division assistant during the year 1996. Appointed was working as a second division assistant in the year 1996 in the court of the civil judge in JMFC Madikeri. Full stop. He was promoted to the cadre of first division assistant. Full stop. However, a departmental inquiry was initiated against the petitioner, and the disciplinary authority passed an order reverting the petitioner to the post of second division assistant. Full stop. The petitioner challenged the aforesaid order before the respondent number 1, which was allowed, and the order reverting the petitioner to the cadre of second division assistant was modified, and the petitioner and the petitioner was censured and one increment without cumulative effect was passed, and withholding 1 increment without cumulative effect was passed. Full stop. The petitioner contends that
and drawn the all benefits.
petitioner contends that he ಯಾವ ರಿಟೈರ್ ಆಗಿದ್ದು
In 2007,
petitioner contends that he attained the age of superannuation in the year 2007.
ಇಲ್ಲ ಸರ್, 2007, 2014 ಅಲ್ಲಿ. But
The petitioner contends that the petitioner contends that he was granted all his annual increments and other arrears of pay from June 2006 and was entitled for a time-bound promotion which had fallen due in the year 1999. However, the respondent number 2 rejected the request of the petitioner for time-bound promotion to the senior scale of pay in view of the order passed by the disciplinary authority. Full stop. The petitioner is therefore before this court challenging the said order. Next, the learned counsel for the petitioner contended that the impugned order does not set out any reasons as to why the petitioner was not entitled to automatic grant of promotion to the next higher scale of pay. He submits that as a result of the impugned order, the petitioner has been exposed to double punishment in as much as in the disciplinary proceedings, one increment without cumulative effect was imposed. And by virtue of the same findings, the petitioner is deprived of the grant of automatic promotion to the higher scale of pay. Full stop. He contended that the government of Karnataka has issued a clarification regarding grant of automatic increment and the government
Number 16.
specifically the government was of the clear opinion that the case of the petitioner for grant of automatic promotion to the next higher scale of pay could be considered. Full stop. He therefore submits that the respondent number 2 committed an error in not granting the benefit of the higher automatic grant of promotion to the next higher scale.
ಗೌರ್ಮೆಂಟ್ ಲೆಟರ್ ಇನ್ನೊಂದು ಸಾರಿ ಓದಿ. ಸಂಬಂಧಿಸಿದ ನೌಕರರ ಪ್ರಕರಣವನ್ನು ಮುಂಬಡ್ತಿಗೆ ಪರಿಗಣಿಸಬಹುದಾಗಿರುತ್ತದೆ.
Next for contra, the learned counsel for the respondent submit that the grant of automatic grant of special promotion to senior scale of pay is governed by the KCS automatic grant of special promotion to senior scale of pay rules 1991. He submits that rule 3B deals with grant of deals with the criteria for grant of special promotion to senior scale of pay and reads as follows. Double inverted comma, he has satisfactory record of service, semicolon, the satisfactory record of service being determined in the same manner as merit is determined for promotion on the basis of seniority cum merit. He therefore contends that the case of the petitioner was considered and he was found and considered, and his record of service was not found to be satisfactory, and therefore the petitioner was denied the grant of automatic special promotion. In support of his contention, he relied upon the judgment of a division bench of this court in ILR 2008 Karnataka 492. Full stop. Next para. I consider submissions made by the learned counsel for the petitioner and the learned counsel for the respondents. Next para. The petitioner had joined the services of the district judiciary ಯಾವಾಗ ಸೇರಿದ್ದು?
1984.
In the year 1984. Full stop. The petitioner was granted time-bound promotion.
Sorry, my lord. He was appointed on 2/5/1973, para number 3 of my SO.
2/5/1973.
Yes.
2/5/1973. Full stop. The petitioner was granted time-bound promotions. And the last being the one granted on 31/10/1999. Full stop. He was thereafter granted promotion as a Shiristidar. Full stop. However, the petitioner was denied the time-bound promotion, and the request of the petitioner was thereafter forwarded to this court. Forwarded by this court to the respondent number 2, along with a letter addressed by the state government regarding the grant of time-bound promotion to the petitioner. Full stop. A copy of the letter addressed by the state government to the respondent number 1 shows that the state government was also of the opinion that the petitioner could be granted the benefit of the special promotion as the order of censure out of the disciplinary authority censuring the petitioner and imposing a penalty of withholding one increment without cumulative effect would not come in the way of the petitioner being entitled to this special promotion. Full stop. If the petitioner has worked in the district judiciary from the year 1973 till he retired in the year
73.
till ಯಾವ retirement?
Retired.
1973 till he became entitled to the special promotion, the respondent number 2 must have considered the satisfactory record of service, not only in the light of the order of censure and withholding one increment without cumulative effect, as that was a minor penalty which did not affect the service of the petitioner in any manner whatsoever. Full stop. Therefore, the petitioner, there was no proper application of mind by the respondent number 2 to consider whether the petitioner had satisfactory record of service from the year 1973 till he became entitled for this special promotion. The judgment relied upon by the learned counsel for the respondents is not applicable to the facts of this case, as in the said judgment, the delinquent official had a dissatisfactory record of service for the previous 5 years from 1988-89 to 1992-93. Full stop. For every year commencing from 1988-89, there were adverse entries in his confidential report. However, in the present case, except for an order of censure and an order withholding one increment without cumulative effect, there was no penalty of whatsoever nature against the petitioner to hold that the record of service of the petitioner was not satisfactory. Therefore, the impugned order passed by the respondent number 2 is without proper application of mind and without setting out any reasons for denying the special promotion to the petitioner. More particularly, in the light of the recommendation by the state government that the petitioner is entitled to the special promotion. In that view of the matter, this writ petition is allowed. The impugned order passed by the respondent number 2 is set aside. The respondent number 2 is directed to grant the special promotion to the petitioner in accordance with law and release all the consequential benefits to the legal representative of the petitioner within a period of 3 months from the date of receipt of a copy of this order.
Serial number 5. Fayaz of BG.
Fayaz Saab. Fayaz Saab. Really, Raghavendra, really.
Petitioner was, my lord, applied for the post, my lord, on, furtherance of the notification dated 16/1/2005. My lord, he was appointed on 28/6/2006. But my lord, the new pension scheme came into existence on 1/4/2006 before his appointment. Therefore, he was given, my lord, NPS pension. He praised in this writ petition seeking, my lord, the old pension.
What is the new policy?
Lord, latest government order is in his favor. He has to, whether he has to make representation in furtherance of the government order on, I don't know.
Other prakara ಮಾಡಕ್ಕೆ ಹೇಳೋಣ ಅಷ್ಟೇ.
Please. ನಾ ತಗೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದೇನೆ ಅದು. ಅಲ್ಲಿ ಟೈಮ್ ಲಿಮಿಟ್ ಇದೆ, 1 month ಅಲ್ಲಿ ಮಾಡ್ಬೇಕು ಅಂತ ಇದೆ.
ಆಯ್ತು, will extend it.
Please.
The petitioner sought for the following reliefs, copy of. The facts in brief are that the petitioner joined the services of the district judiciary
As a process server.
the process server
On 28/6/2006. 28/6/2006.
28/6/2006. ಅಲ್ಲ ಇಂಟರ್ವ್ಯೂ ಲೆಟರ್ ಎಲ್ಲ 17/1 ಮಾಡ್ಬಿಟ್ಟು ಪಾಪ ಅವ್ರು ತೊಂದರೆ ಆಯ್ತಲ್ಲ.
ಹೌದು, ಇಂಟರ್ವ್ಯೂ ಮೊದ್ಲೇ ಆಗಿತ್ತು, 1 ವರ್ಷ ಡಿಲೇ ಆಗಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿತ್ತು. But government order says, my lord, whoever appointed after 1/4, my lord, they are not eligible. But now ಈಗ ಅದನ್ನ ಬೆನಿಫಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
28/6/2006. Full stop. That is much later, 28/6/2006, though the recruitment process was completed and an order of appointment was issued on 1/8/2005. Full stop. The petitioner contends that from 1/4/2006, the new pension scheme was rolled out. As a result of which, the petitioner had to make contributions to the new pension scheme. The petitioner, after completion of a declaration of her probationary period, made a request to the respondents to consider her claim for the old pension scheme as the recruitment to the post of process server was completed even before the new pension scheme came into force.
ಪ್ರೊಸೆಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿರ್ಲಿಲ್ಲ,
ಆಗಿತ್ತು ಅಂತ
ಬರೀ
ಹೇಳ್ತಾರೆ.
ಇಂಟರ್ವ್ಯೂ ಆಗಿತ್ತು ಅಷ್ಟೇ.
ಇಲ್ಲಿ ಹೇಳ್ತಾರ
ಅಲ್ಲ, ಅವ್ರು ಹೇಳ್ತಾರೆ, ಬಟ್ ಆಗಿರ್ಲಿಲ್ಲ.
ಆಗಿರ್ಲಿಲ್ವಾ?
ಆಗಿರ್ಲಿಲ್ಲ.
Full stop. Next para.
But he urges, man.
The learned counsel for the respondents, learned counsel for the petitioner, therefore prays that the petitioner be granted the benefit of the old pension scheme. Full stop. This petition is opposed by the respondent, who contends that by the time the petitioner reported to duty, the new pension scheme was already in force. And therefore, the petitioner is not entitled to the benefit. However, he contends
How?
that in view of the proceedings of the state government, the petitioner may be entitled to the benefit of the old pension scheme. In this regard, is placed on record.
ಅಲ್ಲ ನಾನ್ ಹೇಳಿದೆ ಅಂತ
ಆಯ್ತು, full stop. ಆಯ್ತು, ಏನ್ ಮಾಡ್ಬೋದು? ಏನಾಯ್ತು? ನೀವ್ ಹೇಳಿದ್ರೆ ಯಾರು ಹೇಳಿದ್ರು ಒಂದೇ ತನ ಇದ್ದಿದ್ದೆ
ಮುಂದೆ
ತಾನೆ.
ಆದ್ರೆ
Whether
ಏನಾಗುತ್ತೆ
state or
ಅಂದ್ರೆ
not, the government has issued a notification.
ನೀವ್ ಯಾಕೆ ಹೇಳಿದ್ರಿ ಅಂತ.
Huh? And therefore, the petitioner is not entitled to any reliefs. Full stop. The learned AG on the other hand submitted that the state government has now come out with a has passed a, the state
Government
government
order.
has issued a government order dated 24/1/2024, applying the old pension scheme to all those employees who were recruited before 1/4/2006.
Who applied for the post but appointed after 1/4/2006.
Who applied for the post and who were appointed after 1/4/2006. He therefore contends that since the petitioner had applied to the post prior to 1/4/2006 and was appointed later, the petitioner would be entitled to the benefit of the old pension scheme. We'll stop. Next para. In view of the submission of the learned AGA, the petitioner is entitled to succeed in this writ petition. In that way of the matter, this writ petition is allowed. The respondent number is allowed in the light of the government order dated 24/1/2024.
Respondent.
We'll stop. The writ petition is allowed. The respondents, the petitioner is directed to make appropriate representation before the respondent number 2 to consider her case for three na
Processor district judicial.
ಅಲ್ಲ ಬಟ್ ಅಲ್ಲೇ ಇರ್ತಾರ ಚೇಂಜ್ ಆಗ್ತಿರ್ತಾರ
ಈ ಪೋಸ್ಟ್ಗೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್
respondent number 3
ಇಲ್ಲಿ 2 and 3 ಅಂತ ಎರಡು ಹೇಳ್ಬಿಡಿ.
to extend the benefit of the old pension scheme in the light of the government order dated 24/1/2024. Full stop. If a request is made, the respondent number 3 shall pass appropriate orders within a period of 3 months from the date of receipt of a copy of this order.
ಮಚ್ಚ
Serial number 7.
ಇದೊಂದು ಕಾಪಿ ಇಟ್ಕೊಂಡ್ರಿ.
Serial number 7, P. Rajshekar.
ಯಾವುದು? P. Rajshekar. ಸಂತೋಷ್ ನಗರಾಳೆ.
Appearing for respondent, my lords. My lords, kindly seek short accommodation, my lords. Senior is out of station, my lords, due to personal inconvenience.
You are for Rajshekar?
No, my lords.
No, Mata?
R1 and R2, my lords. Respondent.
Learned counsel for the petition is absent. List on.
3rd August. Serial number 8, H.N. Basuraju. H.N. Basuraju.
There is no representation for the petitioner.
For the respondent, my lord, short accommodation, senior is held up.
Senior either ಮಾಡ್ತಾರೆ ಬಿಡಿ.
Senior,
Yes,
for the
sir.
respondent, my lord.
ನೀವು ರೆಡಿ ಇಲ್ವಾ? ನೀವು ಫೈಲೇ ಇಲ್ವಾ?
Kindly have it on next week, my lord, Wednesday.
ಬಂದಿದ್ದೇನೋ ಮುಗಿಸ್ಬೇಕಪ್ಪ ಅಷ್ಟೇ ಏನೋ. ಎಲ್ಲ ಹಳೆ ಕೇಸ್ಗಳಲ್ಲಿ ಇದೆ ತರ.
He was a lift operator. He is working at my lord family court. During pendency of the writ petition, my lord, he died and his LRs are brought on record. One Kumar, my lord, DG Naidu made a complaint to the registrar, my lord, saying that he has some matters at family court. While attending those matters, he contacted this AGO, that is employee.
who promised that if some money is paid, the matter could be get it disposed of earlier, and in such a way, he made a complaint and he paid 40,000 rupees. It was not repaid and matter was also not disposed of. That was the complaint made to the registrar. Based on that, primary inquiry was conducted. Thereafter, the charges are framed. Your Lordship may kindly see page 19, annexure E. That while you are working as a lift attendant at Bangalore Mediation Center, Naya Jagala had to Siddhaya Road, Bangalore, on the pretext getting his matrimonial care disposed of. Early and promising asset you have received 2,000 so and so and 38,000 so and so from the DGG Naidu, aged 54 years, etc. etc. This act of your part amounts to unbecoming of a court servant, and thereby you have committed misconduct within the meaning of Rule 22 of the High Court Act. So a charge made against him. Then he denied the charges, then inquiry was conducted. In the inquiry, the RGT Naidu was examined. His examination I have produced. Your Lordship may kindly see annexure of page 22. Then, my lord, he was subject to cross-examination. Lord, I'm not taking your Lordship's much time. But the inquiry report, my lord, is submitted after the conclusion of such inquiry. Page 42, annexure M may kindly be seen. Page 43. Point arises on consideration is whether it is proved that DCS, being a court servant, has demanded and received a sum of rupees 40,000 on so and so from the complaint to RGG Naidu on the pretext of getting his matrimonial care disposed of early and promising to have such. This is the charge, my lord, it is, and it is the point, a point for consideration. My lord, this aspect was considered, and while appreciating the evidence, my lord, the inquiry officer said, may kindly go to page 45. That is, my lord,
Yes.
just ninth line from the top, man, after word 50,000. On the same evening, DCS came to him. He has paid DCS rupees 2,000 on 29, 2010.
DCS andre?
Department, delinquent court servant. Delinquent court servant. He was paid another sum of rupees 38,000 to the DCS in the hotel situated near Regular within 11 a.m. and 10:30 a.m. When he insisted DCS to give document for having received 40,000, DCS gave him signed blank stamped promissory note. It is marked as Exhibit P1. Exhibit P1A, P1B are signature of DCS. Since there was no progress in his case, he asked DCS to repay the amount. Finally, DCS returned sum of rupees 10,000 equal to 2010. DCS did not return the balance amount. He also approved Deputy Director of Mediation Center, etc. Then ultimately, your Lordship may kindly go to page 47, paragraph 14. The complainant contends that Exhibit P1 is given by the DCS at the time when he received money from him, more particularly 38,000 on 29, 2009. The complainant said the signature found in Exhibit P1 marked Exhibit P1A, P1B or the signature of the DCS, but the DCS denied those signatures. Of course, my lord, it is very important. Of course, even on bare comparison of the signature marked in Exhibit P1A and P1B with the admitted signature of DCS, one can make out that there are no similarities between the admitted signature and the disputed signature. It itself will not exonerate the DCS if further evidence would point out sexual guilt. Then may kindly go to next page. Ninth line from the top. This part of the evidence, could you all
Yes.
Yes, this part of the evidence when viewed in the background of the complaint taken to the DCS over phone frequently suggests that there was some money transaction between the complainant and the DCS. May kindly make a note. There is evidence to show that matrimonial cases related to the complaint were pending at the relevant time in the family court. In this background, when the evidence on record is properly considered, there are reasons to believe that DCS had received some money from the complainant, assuring to have his case disposed of early. How much amount he has received is not proved by the complainant. When the complainant has obtained a promissory note, he should have insisted for filing a document to show how much money he has paid to DCS. Exhibit P1 is a blank signed promissory note. The complainant has not produced any document to show he has paid totally 40,000 rupees. Therefore, there is a materials to believe DCS has received the money from the complainant, but it is no clear evidence to show he has received 40,000. It is possible to believe that prevailing circumstances that DCS has demanded received certain sum of money from the complainant, assuring to have his matrimonial case disposed of early by misusing his position as an employee in the mediation center. Hence, I hold that charges are framed in part and he was imposed with a penalty. My submission to your lordship is charge is very accurate and clear. I received 40,000 rupees. I promised him to complete his work. But the evidence and findings recorded by the inquiry officer is otherwise. He said he received some money, but promissory note is executed, signature is not tallied. And it is further assumed that it is in respect of disposal of matrimonial case, but how much money he received is not forthcoming. My submission to your lordship is the charge is not proved because it is a penal provision, where my lord evidence is required to be strictly construed. If there is a charge that I received 40,000 for particular purpose, that evidence has to be proved. Only because I received the money, it would not attract the misconduct. It's a transaction interest between me and the other person. It would not constitute a misconduct. In that view of the matter, my lord, inquiry, the charges are not proved, but accept of the inquiry report in that way by this honorable court appears to be not correct, and I could have been exonerated. Even assuming for a moment, my lord, this is the matter, it is proved. My lord, the punishment imposed appears to be very harsh.
Who do you say it is exorbitant or harsh?
He is dismissed from the service.
Obviously, Indian Madakagathin.
My lord, indeed, of course, on reading the charge, punishment may be correct. But when that charge was not proved in such a way, because what degree how the charges have to be proved, that was not proved to that extent. In the absence of that, my lord, this punishment would have become a harsh punishment according to.
Yes. Yes.
Senior is.
Yeah, and there math helapa.
My lord, this charge is partly proved, my lord. My lord, and he is returned.
What do you mean by partly proved?
Proved, my lord. Partly proved.
Partly proved in month. Where is the order of the disciplinary authority?
Number.
In a refers to the judgment.
Page 42.
Refers to the division bench judgment.
What is
1999 5 Karnataka law.
3 and 4 para.
Para 3 and 4. There is no question of saying that the charges are partially proved. Either they may say that charges are proved or not proved. It charged in part, and these things could not be assumed because there may be a possibility is working as a lift operator in the matrimony, that is family court. There may be a possible he promised. That was not the preponderances can be drawn. In the absence of concrete evidence as against as admitted in the inquiry.
Correct. What is the evidence that you extracted from the complainant to show that this evidence cannot be believed?
My lord, that's he himself said received 40,000 by executing a promissory note. Signature on the promissory note is not proved at all.
That's ugly.
Regular-
What is the when?
regular-
When you have been telephoning, calling him regularly on his
But it's a
telephone.
person calling telephonically only this was not the charge against me.
Yes.
It was not the charge, and that is no things at all.
It may not be the
Charge
charge.
is not, it is, you know, if
No,
you
that is-
get.
See, charge ಅದು evidence ಬಂದ್ಮೇಲೆ ತಾನೇ ಗೊತ್ತಾಗೋದಲ್ಲ ಹೆಂಗೆ?
Charge ನೊಳಗೆ, this was not there.
Yes.
The charge is very accurate and concrete is, you received 40,000 rupees, you promised him to do this.
ಏನ ಇದು ರಿಟೈರ್ಮೆಂಟ್ ಏಜ್ ಆಗಿದ್ಯಾ?
Thank you, Lord.
How old is he?
ಇಲ್ಲ, he passed away.
He passed away.
He passed away, his LRs on record.
ಹಾ. ಏನ್ ಮಾಡ್ತಾರೆ ಮಕ್ಕಳು?
Entered in 1996.
What do the children do? ಮಕ್ಕಳು ಏನ್ ಮಾಡ್ತಾರೆ?
ನನಗೂ ಅವರಿಗೂ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ಮೇಲೆ ಅವ್ರು ಬೇರೆ ಬೋರ್ಡ್ಸೇ ಗೊತ್ತಿಲ್ಲ. ನೀವು ಟೈಮ್ ಕೊಡಲ್ವಲ್ಲ ಅಂತ ರೆಡಿಯಾಗಿ ಬಂದೆ ನಾನು ಇವತ್ತೆ.
ಹಾ? ನನಗೇನಿಲ್ಲ ಸರ್, ಯಾವಾಗಾದ್ರು ತಗೊಂಡೋಗಿ ಇದೆಲ್ಲ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್.
ಈ ಮ್ಯಾಟ್ರಿಗಳಲ್ಲಿ ನನಗೂ ಟೈಮ್ ಕೇಳಕ್ಕೆ ಐ ಮೇ ನಾಟ್ ಗೆಟ್ ಗುಡ್ ಸ್ಲೀಪ್ ಇನ್ ದ ನೈಟ್ ಇಫ್ ಐ ಆಸ್ಕ್ಡ್ ಫಾರ್ ಇಟ್.
No, that is not the question. I also face this kind of problems, old matters, client ಸುಳ್ಳು ಹೇಳಿ. So therefore I am trying to get these old matters listed.
ಇದರಲ್ಲಿ
Correct, but see, if we were to tell the client that there are no judges in the court, judges shortage ಇದ್ದಾರೆ, appointment ಆಗಿಲ್ಲ ಅಂದ್ರೆ, they should disbelieve us. ಏನೋ ಸುಳ್ಳು ಹೇಳ್ತಿದ್ದಾರೆ ಲಾಯರು ಅಂತ. ಎಷ್ಟು ನಾವು ಫೋನ್ಗಳು ಅವಾಯ್ಡ್ ಮಾಡಬೇಕು.
ಯಾರು ಏನಾರು ಅರ್ಜು ಮಾಡ್ಕೊಳ್ಳಿ, ಏನ್ ಹೇಳ್ತೀವಿ ನಾನು ಮೇಲೊಬ್ಬ ನೋಡ್ಕೋತಾನಲ್ಲ, ಅವ್ರಿಗೆ ಬಿಟ್ಬಿಡ್ಬೇಕಷ್ಟೇ.
So therefore
I can ascertain that information, what is their financial status, that High Court can think over to compensate.
ಆಯ್ತು, ಏನಾದ್ರು ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಏನೋ ಮಾಡಕ್ಕಾಗತ್ತ ನೋಡಿ.
Page number 49, my lord. Page number
No,
49.
please tell us what are the children doing? Let us see.
I will tell you.
ಯಾವಾಗ ಹೇಳ್ತೀರಿ? ನಾಳೆ ಹೇಳ್ತೀರಾ? ನಾಳೆ ಅಲ್ಲ, ಟ್ಯೂಸ್ಡೇ ಆಗುತ್ತಾ?
Wednesday, man. Wednesday. Kindly have it on Wednesday.
ಎವ್ರಿ ಫ್ರೈಡೇನಾ? ಫ್ರೈಡೇ.
Please.
ನೋಡ್ತೀನಿ ಇಲ್ಲೇ ಯಾರನ್ನಾರ ಅಫಿಷಿಯಲ್.
ಇದ್ರೆ ಕೇಳಿ, ಏನೋ ಇಫ್ ದೇರ್ಸ್ ಎ ವೇ ಏನೋ ಸಹಾಯ ಮಾಡಕ್ಕಾದ್ರೆ ಮಾಡೋಣ. ಎಸ್. ಹಾ?
ಯಾವ ವರ್ಕಿಂಗ್
ಹಾ, correct. ಯಾವ ಫ್ರೈಡೇ ನೋಡಿ? 16th already, 23rd. No more argument on that day.
Only High Court has to say what concession they could able to.
Yeah, but you see, if everybody starts doing this, where does the institution go?
Things have to be reviewed in that angle also.
No, that is okay. I mean, if because the man is dead, we have all sympathy for the children.
If the evidence record shows that it is concretely proved and it is completely proved, I can agree.
Sir, ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿಲ್ಲ. ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದ್ರೆ ಲಿಫ್ಟ್ ಆಪರೇಟರ್ ಏನೇನ್ ಮಾಡಬಹುದು ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಿರ್ತಿತ್ತು.
ವಾಸ್ತವ ಬಿಟ್ಬಿಡೋಣ, ರೆಕಾರ್ಡ್ ನೋಡೋಣ. ವಾಸ್ತವ ನನಗೂ ಗೊತ್ತು, ನಾನೇ ಬೇಕಾದ್ರೆ ಸರಿ ಕೊಟ್ಟು ಓಡಾಡಿದ್ದೀನಿ. ದಟ್ಸ್ ಎ ಡಿಫರೆಂಟ್. It's a matter of record and ultimately some human sense is also take a role. That's all my submission. If he is alive, I could not have been.
ಅಲ್ಲ, ಅದಕ್ಕೆ because he is dead, we have all the sympathies for his family members.
Yes.
Yes.
Very well. Next.
Number 9, MP Srikanth.
Appearing for the petitioner, my lord, kindly have seen there is some inconvenience, kindly have some short dating.
ಆಯ್ತು, ಇಲ್ಲಿ ಮಿಸ್ಟರ್ ರವಿಶಂಕರ್ ನಿಮ್ದು ಯಾವ್ದೋ ಇತ್ತಲ್ಲ, ಯಾವ್ದೊಂದು ಮೂವ್ ಮಾಡಿದ್ದೆ, ಯಾವ್ದು?
Submission. Rule matter. Number 29, by mistake, B group ala.
ಶ್ರೀಲಂಬ
29.
ಸತೀಶ್.
Last occasion.
ಸತೀಶ್.
Yes, sir. I appear for this.
ಆಯ್ತು, ಅದು 29 ನೋಡ್ರಿ, ಲಿಸ್ಟ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂತ ಹಾಕಿ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಬಿ ಗ್ರೂಪ್ ಯಾಕೆ ಹಾಕಿದ್ದಾರೆ? ಎಲ್ಲ
Issue rule ಆಗಿದೆ.
ರೂಲ್ ಇಶ್ಯೂ ಆಗಿರೋದಲ್ಲ, ಬಿ ಗ್ರೂಪ್ ಯಾಕೆ ಹಾಕಿದ್ದಾರೆ?
ಆಗ್ಬಾರ್ದು.
ವಿಲ್ ಲಿಸ್ಟ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್.
Yes, sir.
ಏನ್ ಡಿನ?
ಅಲ್ಲ, rule is question.
ಹಾ?
Rule, promotion rule.
ಅದು ನೋಡಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 29, 30 ಎಲ್ಲಾನು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಹಾಕಿ.
22nd.
We take whichever date you want.
22nd. What of it? 21 or 22nd?
ಇದೇನು ಅರ್ಜೆಂಟ್ ಆಯ್ತಲ್ಲ, ಯಾರು ಬರ್ಲಿಲ್ಲ ಅಂತ.
ಕರ್ಕೊಂಬರಕ್ ಬಂದಿದ್ರು.
Copy served.
Copy served. Yes, what is this case? ಏನ್ ಕೇಸ್ ಹೇಳಿ?
What's his petitioner is physically handicapped and is working as an assistant engineer in Whitefield O&M unit. But he was sought to be transferred on 27th May 2022. What's page number 20, or lots my kindly see notes.
Page number 20.
20.
Ah.
What's the transfer order was challenged. Not this honorable court considered the extant transfer policy considering the physically handicapped, and at page 21, Milords, the last 3 paragraphs, upon consideration of such representation being made, respondents to take appropriate decisions as regards the impugned order, reconsideration as directed to be completed within a period of 4 weeks. Such order on reconsideration to be placed before this court and could be given effect to only by the orders from this court. Not having done this, they did not take any decision. They again passed an order of transfer without concurrence of the court. Again, we had to approach this honorable court at page number 26, annexure D. Not page 27.
Yes.
Taking note of the orders passed in WP number 10581 of 22, Milords, this honorable court again granted an interim order, was continued there. Milords, there was a policy for what is called as a mutual transfer. Wherever the he is a physically handicapped, he is permitted to. Milords, this request was made at annexure F, page number 30, to be posted to Vartur, and the person who was in Vartur wanted to come to this place. This is the closest place to my residence. Now, this representation was in fact being considered, at which point of time I was kept under suspension for some incident. Not the order of suspension when it was in force. Again, somebody else came and sat in my post. Page 36 minutes is the 3rd round of litigation, in which at page number 53, suspension order was set aside. Page 53 minutes, I'm sorry. Suspension order is set aside, and I was directed to be continued in the same post. Notice, when this representation was there, at annexure J, page 55, the competent authority has passed an order that the mutual transfer representation has to be considered and they will have to be transferred to respective positions. Notwithstanding, this is an order passed on 12/6/24, which was also updated in the net, page 56 minutes. On the net also, it has been updated that this mutual transfer has been approved. Notwithstanding, on 37, Lords will kindly see me, Lords, at page number 60, on 37/2024, a transfer order is passed, but it is not communicated to me. I am posted to EPIP Ghataka, Karya Mattu Palana Ghataka, 12ನೇ Purva Upabhaga Valya. And in this order, Lords, what they do in the next order, that is on 31/7/24 at page 37, serial number 37, page 65. The person who was required to come to my place, he is actually posted to that place. The orders of the competent authority is implemented in part. So far as Somshekhar is concerned, who did for petitioner, it is denied. He is posted elsewhere.
No. Who is posted in Whitefield?
Somshekhar, who was the person with whom I had given a joint representation for mutual transfer.
No.
Who is the caveator?
Whitefield ಅಲ್ಲಿ ಯಾರು ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ?
ಅದೇ ಸೋಮಶೇಖರ್ನ. Somshekhar was the person who had joined me for requesting for a mutual transfer.
ಸೋಮಶೇಖರ್ ಎಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು ಮುಂಚೆ?
ವರ್ತೂರ್. ವರ್ತೂರ್ಗೆ ಇವಾಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ, Lords, annexure M1, page 66.
So you wanted to go to Vartur?
ವರ್ತೂರ್.
ವರ್ತೂರ್ ಮತ್ತು EPIP ಗೆ ಎಷ್ಟು ದೂರ ಇದೆ?
ಅಲ್ಲ, ವರ್ತೂರ್ ದೂರ, ಪೇಜ್ serial number 38 ಡಿಸ್ಟೆನ್ಸ್ ಇದೆ. ಪೇಜ್ 69 serial number 38.
EPIP ಬರೋದು.
ಹೌದು. ಇಲ್ಲ, ತುಂಬಾ ಅಲ್ಲಿ ಸಬ್ಸ್ಟೇಷನ್ಸ್ ಆರ್ ಅಟ್ ಡಿಸ್ಟೆನ್ಸ್.
EPIP ನೀವು ನೋಡಿದಿರಾ? EPIP
ನಾನು ನೋಡಿದೆ.
ಏನ್ ನೋಡಿದ್ರಿ?
ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಫೇಸ್, ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಟಿ ಫಸ್ಟ್ ಫೇಸ್.
ನೋ ವೈಟ್ಫೀಲ್ಡ್ ಕಡೆ ಇರೋದು ಅದು. ವೈಟ್ಫೀಲ್ಡ್ ಮತ್ತೆ ಬೆಳ್ಳಂದೂರು ಆ ಸ್ಟ್ರೆಚ್ ಬರೋದು.
ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ, ಪೇಜ್ 69 serial number 38, Naveen D, who was working there, he was trapped. It was a trap. He was kept under suspension. Thereafterwards, he is again posted to the same post. He was trapped in Vartur only.
Yes, madam.
Lords, I appear for the cavator respondent number 4. Lords, the petitioner and I, we'd made a mutual request, my lords, whereby I am, by virtue of the order at
Yeah, what about this,
this
Naveen-
fifth
Naveen?
respondent now, my lords, has come to the place where the petitioner had requested.
fifth respondent is also a physically handicapped person?
No.
No,
Uh,
the transfer policy is at page 70, my lords, regarding the
I-
physically handicapped.
My lords, previously,
Anyway, you are sailing with him.
please, my lords.
Obviously,
One
you have-
point I want to bring to your
I
lordship's
need not
notice.
hear you when I already heard him.
Because he's previously, Naveen has tried for Vartur, on which I had taken a stay, my lords.
ಯಾರು ಕೊಡ್ರಿ ಲಿಸ್ಟ್ ಕೊಡ್ರಿ. ಯಾರು ಬೆಳಿಗ್ಗೆ ಮಾಡಿದ್ದು? ರಕ್ಷಿತಾ ಮಾಡಿತ್ತಲ್ಲ? ರಕ್ಷಿತಾ ಮಾಡಿದ್ದು ಯಾರು ಮಾಡಿದ್ದು ಬೆಳಿಗ್ಗೆ? ಚೆನ್ನೇಗೌಡ. Sumana Naganand is directed to accept notice for respondents 1 to 3. Issue emergent notice to respondent number 5. In view of the earlier rounds of litigation before this court, to protect the place of posting of the petitioner, and in view of the interim orders granted therein, the impugned order of transfer of the petitioner at annexure A.
Annexure L, my lords.
Yena Ella,
L.
annexure L. He stayed in so far as the petitioner and respondent number 5 are concerned.
Respondent number 5 transfer ಇರೋದು annexure M ಅಲ್ಲಿ. Annexure M.
Annexure A, L ಮಾತ್ರ ನಿಮ್ದಲ್ವಾ?
L ಅಲ್ಲಿ ನಮ್ದು.
L and M. In so far as petitioner and respondent number 5 are concerned. M is R5 ಅಲ್ಲ?
Yes.
Sir, M1.
M1.
M and M1 ನಾ?
M1. M and M1.
ಅಲ್ಲ M1 ಎಲ್ಲಿದೆ?
M1 page 66.
ನಿಮ್ ಟ್ರಾನ್ಸ್ಫರ್ ಎಲ್ಲಿದೆ?
ನನ್ ಟ್ರಾನ್ಸ್ಫರ್ page 61. ಅದು annexure L.
Annexure L and?
L and M.
M.
M so far as Somshekar is concerned.
M ಯಾಕೆ ಮಾಡಿಸ್ತೀರಾ?
ಅಲ್ಲ ಈಗ ಏನಾಗತ್ತೆ ಅಂದ್ರೆ ಈಗ
M ಯಾಕೆ ಮಾಡಿಸ್ತೀರಾ?
M1 ಅವ್ರದ್ದು ಸ್ಟೇ ಆಗ್ಬೇಕು ಇಲ್ಲಾಂದ್ರೆ
M1.
M1.
L and M1.
M1 so far as petition and fifth respondent are concerned.
Yes.
Great.
31 not let.
Huh?
Number 31.
ತಗೊಳ್ಳಿ ಯಾವತ್ತು ಬೇಕೋ ತಗೊಳ್ಳಿ, whichever date you want.
Serial number 36, may I make a mention, my lords? There was an interim order passed.
Interim
by
order
the
will be extended.
My concern is that there was an interim order already passed on 16/7, reinstating our services as temporary assistant professors. We've been issued the order yesterday, my lords. We've reported for duty this morning. However, the order says guest faculty. That is like a demotion in our.
File an application if you want a correction.
Sir, could have, sir, 39.
Number 39.
31 13.
Sir, serial number 39, 13ಕ್ಕೆ.
Monday.
Court officer, serial number.
Serial number
10.
39.
Serial number 31, sir.
39.
13
ಬೇಡ 14 ಎರಡು full ಇದೆ. 20 20. 31 28.
Yeah.
Serial number 39.
33. 33, sir.
What's the next Friday? Oh, next Monday, Tuesday.
34. 33 27 ಎಂಟು ಹಾಕಿ sir. 34 ಸಾಗರ್ ಬಿಬಿ. ಅರಿವಾ. 28 ಹಾಕಿ.
Sir, 35 not petitioner. 35. 19th ಅಥವಾ 20th. I am the petitioner.
23 ಮ್ಯಾಟರ್ ಅಲ್ವಾ?
2023 madam. ಇದೆಲ್ಲ ಗ್ರಾಟಿಟ್ಯೂಡ್ ಎಲ್ಲ withheld ಆಗಿದೆ ಸರ್.
29th or 29th,
28 ಕೊಡಿ ಸರ್ 28.
28 madam, 28 madam. 36, 36, 36, 27, 38, 38, 38, 3rd September account. 39,
13 ಗೆ ಸರ್. 13 ಗೆ
13 14 ಹಾಕೊಳ್ಳಿ ಸರ್
13 ಹಾಕಿ ಸರ್.
ಸರ್ ಇಲ್ಲ ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇದೆ
13 ಸರ್.
14
ಸರ್ ನಾನು ಪಿಟಿಷನ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ 13 ಬರ್ತಾರೆ ಸರ್. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ 13 39.
ಅವ್ರು ಹೇಳ್ತಾರೆ
ಅಲ್ಲ ನಾನು
13 ಅದು ಓದ್ತೆ ಕೊಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ
ನಾನು
ಕೊಡಿ
petition
ತೊಂದ್ರೆ ಇಲ್ಲ ಕೊಡಿ 13 ಗೆ ಕೊಡಿ
13 ಕೊಡಿ
13 ಗೆ
ಇಲ್ಲ ಫುಲ್ ಇದೆ ಸರ್.
ಅಲ್ಲ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅವತ್ತು ಬರ್ತಾರೆ ಸರ್.
14 ಹೇಳ್ತಾರೆ.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅವತ್ತು ಬರ್ತಾರೆ.
ಫುಲ್ ಇದೆ.
ಇಲ್ಲ ಹೋದ ಸರಿ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್
ಇಲ್ಲಿ take chance ಕೊಡಿ ಸರ್.
ಆಗುತ್ತೆ ಅದು ಆಗಲ್ಲ.
ವಿಲ್ ಟೇಕ್ ಚಾನ್ಸ್
ಚಾನ್ಸ್ ತಗತಿ ಸರ್ ಪರವಾಗಿಲ್ಲ 13 ಆಗಿ
13 ಹಾಕಿ ಸರ್ ತೊಂದ್ರೆ ಇಲ್ಲ
13
ನಮ್ದೇ ನೋ ಅಬ್ಜೆಕ್ಷನ್ 13 ಹಾಕೊಳ್ಳಿ.
ಕೈಂಡ್ ಇನ್ಫಾರ್ಮೇಶನ್ 12ನೇ ತಾರೀಕು ಸಾಹೇಬ್ ರಜಾ
ಹಾ
ಎಲ್ಲ 13 ಬರ್ತಾ ಇದೆ. ಬಂದ್ರೆ ನಿಮ್ಗೆ ರೀಚ್ ಆಗಲ್ಲ ಅಷ್ಟೇನು.
14
13, 14 ಎರಡೇ ದಿನ ಇರೋದ ವಾರದಲ್ಲಿ ವರ್ಕಿಂಗ್.
ಪರವಾಗಿಲ್ಲ 13 14
ರಜಾ 16 ರಜಾ 17 ರಜಾ.
ಹೋಗಿ ಅರ್ಜೆಂಟ್ ಕೊಡಿ ಸರ್ ನನ್ನ ಉದ್ದೇಶ ಇಲ್ಲ 14 ಕೊಡಿ ಸರ್.
19ನೇ ತಾರೀಕು ಅಲ್ಲಿಗೆ ಹಾಕ್ಸಿ.
ಸರ್ 13
ಇಲ್ಲ ರಜಾ ಬರೀ ಸಿಟ್ಟಿಂಗ್ ಅಂತ ಓದಿಲ್ಲ ಅವರು ರಜಾ
ರೀಚ್ ಆಗಿಲ್ಲ ಬಂದ್ರೆ ಹಿಂಗೆ ಆಗುತ್ತೆ ಸರ್. ಹೇಳ್ಕೊಳ್ಳಿ ಗೊತ್ತಿದೆ ಬೋರ್ಡು.
19
37 ವಿಡ್ರಾ ಆಯ್ತು ಸರ್. ವಿಡ್ರಾ 32 ಫಾರ್ ವಿಡ್ರಾಲ್ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಮಧ್ಯಾಹ್ನ 2:30 ಸಾಹೇಬ್ರು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು. ಬೆಳಿಗ್ಗೆನೆ ಬಂದಿತ್ತು ಬಟ್ 2:30 ಸಾಹೇಬ್ರು
I didn't prepare. Yeah, I fixed it.